Hi, y'all, and welcome to today's middle of the day live trial stream. We have never done this before on the channel. I am extremely nervous, but also really excited. We are going to be live streaming the Donna Adelson trial. We've covered this on the channel for years now. It started, our coverage did, first trial we covered was Charlie Adelson, Donna Adelson's son. Now, Donna Adelson herself is going on trial for the murder, conspiracy to murder, and solicitation to murder Dan Markel. He was a FSU law professor, married to Donna's daughter, Wendi. They had been actually divorced. They had 2 kids together. And the prosecution theory is that Donna Adelson wanted Dan Markel dead because he was standing in the way of her spending time with her grandkids, that she wanted them with her more. She wanted them to move down to Miami with her. And she also specifically wanted them to be with her unsupervised. And Dan Markel had just filed a motion to keep her from unsupervised visitation. According to the prosecution, all of that added up to motive for Donna Adelson to murder. And she got her son, Charlie, now already spending life in prison. He was convicted, to hire his girlfriend, Katie Medbanowa, spending life in prison plus 30 years, for her to hire her ex-boyfriend, Sigfredo Garcia, as well as his friend, Luis Rivera, to kill Dan Markel in his own driveway, in his own car, sitting in Tallahassee, Florida. As far as the murder was concerned, the prosecution says Donna was behind it all. She was the motivating force. Now, they also have talked about Wendi being involved, but she has not been charged. Wendi had been married to Dan Markel, but that was it. She has never been charged, even though she may have been the closest in terms of what it would have done for her, how it would have benefited her. We are in the middle of jury selection. I had said I would not go live until we got to opening statements, but 2 things happened. Number one was I was really concerned that if what we did was wait until right before opening statements, maybe we would miss it. Maybe we wouldn't be able to hit that. And I did not want to do that for anything. Plus, it turned out, not just turned out, it always is, but they were showing a fair amount of it, and it's pretty interesting and important. I think you'll really like it. And the third thing was that I was so nervous I could not stand and wait another minute. So here we are live. Would you please hit the like button? That will help it get out to more people, help people know, hey, we're here, we're live, we're ready to go on the Donna Adelson trial. I would appreciate it if you would hit that live button. And also, we will be, and be sure to turn your notifications on so you'll know every time we go live. Subscribe too, if I haven't mentioned that. So here we are. This is the final throes of jury selection. The order in which they've done things is the judge gave them just a very brief overview with some questions, just very brief. And then they went into individual jury selection, where they were asked questions about their knowledge of this case in particular. And now they're in open court, and they are doing a live discussion about what exactly it's called voir dire. It's where they ask the jury questions, and some people call it voir dire. You can call it different things depending on your state and your law school and where you got your training. But the idea behind it is, let's find out about the jurors, and each side will be given a very precious 10 strikes. They will be allowed to strike people for no reason, as long as it's not an impermissible reason. There are some of those. But as long as they do that, they're allowed to just strike people they don't want. No explanation. They don't have to explain it. They just, I don't like that person. It's not going to work. So, all right. Let's add to the screen the live that is going on now, and I'll have to move it forward and get it started.
There, number 6.
If I remember correctly, I remember hearing coming from Miami to Tallahassee, so like gas station receipt.
Okay, some evidence of that travel. Okay, what else? It's so fun when y'all help me. Better. Okay. So you know it's a murder for hire. You know there's more than one person involved. You, though, as jurors in this case, will only be asked to decide the involvement and guilt or not guilt of one criminal defendant. Are you able to set aside your thoughts and feelings about the other people that may be involved in the case and focus your verdict? How does the evidence relate to this defendant? Everybody feel like they can do that? Okay. If the evidence shows.
Kind of slow, so I'll stop for a minute. Yes, Donna is in more pastels. I am positive that she was listening to our broadcast last night where I recommended that they soften her up. So I'm absolutely sure that they were broadcasting that in the Leon County Jail, and that's where she was able to see that. Just no question about it.
That the defendant is not the one that pulled the trigger. Does that make a difference? What do you say? Why are you shaking your head no, number 15? Why does that make a difference? Okay, so even if you don't pull the trigger, you can be charged with murder? But what?
Please speak out, number 15.
Okay, you could be charged with accessory, but you don't think murder. Who else, by a show of hands, thinks if you don't pull the trigger, you cannot be charged with murder? Nobody? Why not? Number 2.
We're watching it on 1 1/4, so I'll go ahead and stop. I see some questions about, okay, who are the people that we're seeing here? So let's back it up just a little bit. The person standing nearest us, the woman in the blue suit, that's Georgia Kappelman. She's the prosecutor. Behind her, you can see the defense team. There's Josh Zellman. He's the man sitting on the end there. There's Jackie Fulford. She is another attorney representing Donna. And then, of course, you see Donna Adelson. They introduced themselves earlier this morning, and there were not just those people. There was also a paralegal sitting at the table and a jury consultant. We had some questions about whether or not a jury consultant would be used. And the answer is clearly yes. It's been used differently from how it was in Charlie's trial. So we'll get to that.
Are you able to set aside your thoughts and feelings about the other people that may be involved in the case and focus your verdict? How does the evidence relate to this defendant? Everybody feel like they can do that? Okay. If the evidence shows that the defendant is not the one that pulled the trigger, does that make a difference? What do you say? Why are you shaking your head no, number 15? Why does that make a difference? Okay, so even if you don't pull the trigger, you can be charged with murder? But what?
Please speak out, number 15.
Okay, you could be charged with accessory, but you don't think murder. Who else, by a show of hands, thinks if you don't pull the trigger, you cannot be charged with murder? Nobody? Why not? Number 2.
If you're that you hire someone or something like that, definitely you're not committing the crime personally, but if you're telling someone else to do it and they do it, that makes something pretty close to it. Yeah. Maybe
Okay.
not murder itself. But it might be something like that.
Maybe not murder itself, but it might be something close. What do you think? Number 20.
It's just the way the law is written.
Mhm.
You don't have to pull the trigger, but you can still be charged with murder. The law allows that you can still be charged with murder.
Okay. According to the law of our state, and the judge will give you the law. You do not need to know the law. I tricked you, and I'm sorry. But you can be charged just the same as if you pulled the trigger. If you also did some act or said some word to cause that murder to be done, some affirmative act to cause that murder to be done, and you intended it be done. Okay? It's called a principle. So, court reporter and I are going to do a bank heist, and we know when we go in there, the first thing we're going to do is kill the security guard. Okay? That's our plan. We both understand that that's what we're going to do. But I'm the shooter. She's the bag lady. She's going to get the money. We go in there, we do it, we're successful until we get caught. We can both be charged with first-degree murder of that security guard, the same as if she had pulled the trigger. Is that fair? How is it fair? 23.
Y'all planned it together.
But I pulled,
Y'all planned it together.
but I'm the one that pulled the trigger. Shouldn't I be worse off than her?
She knew what was going to happen.
She did. That's been proven beyond a reasonable doubt. So you agree with that law? Anybody disagree with that law? I do not think it's fair. It should be, as juror number 2 thought walking in here, something close to it, but not exactly the same.
Juror technique by in voir dire is you get one juror to begin to persuade other jurors. So remember, she got the first juror to explain his position, why he thought you could still be liable for murder. You could still be charged with murder, even though you didn't pull the trigger. Then she says, okay, who doesn't agree with that? And now they've already heard the argument on the other side. Well done.
Okay. Now that I gave you the spoiler, you won't admit it. All right, so number 2, knowing that now, would you be able to follow that law? What do you think, number 15? If we are, the law says we can both be convicted of first-degree murder, and it's proven, would you be able to convict her of first-degree murder even though she didn't pull the trigger? You would be able to follow that law.
Number 15, please speak up as much as you can.
You would. If there was a law that the judge read you in this case that you did not agree with, would you be able to follow it anyway, or do you think it would be incumbent upon you to do what your gut is telling you? What do you think? Number 16?
Since we're here to decide if something followed or broke the law, we go with the law.
Go with the law. Number 8?
Yeah, definitely.
Follow the law no matter what, even if you don't like it?
Yeah, it's not me to decide the law. It's just for us to stick to it.
Okay. It's the legislature's job. We're going to leave that to them. Okay. What is a conspiracy? Volunteers for that one? How about you, number 14? What's a conspiracy?
I'm not sure.
You don't need to know the legal stuff. Just what's your idea of it? Come and speak.
A group of people get together, saying anything that they're
Please speak up, number 14.
a group of people try to say that this was not using the word conspire.
Yeah.
To prevent what things sound like to do.
Getting together to do something?
To make something happen with
Okay.
other reasoning behind it.
Okay.
I'd like to say that it doesn't even have to be a group. You can conspire to do something alone.
Number 8. Okay. You could, are you, is that what you're doing right now? You want to tell us something? Okay. Do you all agree that a conspiracy can be evidence circumstantially? And what I mean by that is, and this is hard because we can't talk about what the evidence is. I'm asking you to imagine that it could be proven to you that people conspired to do something without an express, we're going to, go in and kill the security guard without that being expressly stated. Can you imagine other evidence, circumstantial evidence? For example, we walk in and I walk directly over to the security guard and blow him away right to the head, right? Immediately. And she says in front of everybody, yeah, just like we planned. Okay? That would never happen. But, okay, it's not in the plan. The conspirators generally don't write out a manifesto where they say, this is going to be my role, and this is going to be your role, and this is what we're all going to do. But you can infer it from the circumstances, the way the crime was done, the other communications in the case, the other evidence in the case. Can you be open to that? Nodding of heads. Very good. Thank you.
See how she's trying to interact with
Does it
them.
matter how long it takes to make an arrest in a criminal case? You guys all read the statement of the case. This crime occurred in 2014. Number 6, how old were you in 2014? 9. Can you even care about something that happened when you were 9? Can you, sir? Does it matter how long it's been?
As long as the crime that you're being charged for is within statute of limitations, it's fair to the arrest for it.
This is a young juror.
Years ago, happens, things like that.
You gotta feel like it's too long. I just can't consider evidence for 2014. I was 9. Everybody else, can you keep an open mind to evidence and a long investigation? $14? $13, why does a cooperating co-defendant come forward?
Maybe cover their own tracks.
Could be what?
Cover their own tracks.
To cover their own tracks. Yeah, put it off on somebody else. Okay, good. What else? What else could motivate a cooperating co-defendant? 19? You're on ice, 19. I actually have a volunteer, number 6. They have a deal.
Please speak up.
They got a deal.
Yeah, they might be
Two
trying to get something
cooperating
to help themselves.
defendants,
Does that mean they're lying?
at least.
No, it could mean that. But it could mean they're telling the truth to get something. Is that right? Do you agree with that, 19? Okay, can you keep an open mind to that type of testimony and weigh it with all the other evidence in the case? You're going to observe the witness. You're going to hear what they say. You're going to see if it fits with everything else. And you're going to make a decision about their credibility based on all that, including the fact that they have this motive or whatever. Can you do that? Everybody feel like they can do that? Okay. Unsavory witnesses. That's a very nice way of putting this topic. So there could be witnesses in the case that you all do not want to have a beer with or a cup of tea with. Okay? Can you keep an open mind to the testimony of someone who is different from you and lives your life differently from the way you live your life? Number one, can you do that? 2, can you do that? Everybody? If you don't hear a particular type of evidence that you're expecting, can you keep an open mind to the type of whatever evidence that there is and render a verdict based on that? I just don't want you guys to walk in thinking, oh, there's no gun. Can't convict of a murder without a gun. You know, is there anybody that's like that? There's a particular thing that you require. Inconsistencies. Would you all expect the testimony to be completely consistent or there to be some inconsistencies? Let's say we're going to have a 2-week trial. You're going to hear from witnesses every day, all day for the period of 2 weeks. Are we going to have any inconsistencies? 17.
Many.
Purely a guess, but based on the duration, probably something.
Okay. Every single one of you went back in the room back there and answered the questions in private. And I was sitting back there, Ms. Dugan was sitting back there, and we were wearing the same outfits all day. If we isolated each one of you and asked you, what can you tell me about what Ms. Dugan was wearing yesterday or the day that you were back there? Let's say it was all the same day. Do you think we'd get some inconsistencies? Might get some blue, some black, dark pants. I think it was, we might get a lot of different answers, right? Does that mean that anyone's lying? Okay. Now, you all will have to weigh inconsistencies, which are going to occur naturally in a case like this. And you will decide, is this a point on which...
Stopping with that. That is a really dangerous thing to say right there, because she is going to argue that many witnesses are lying because they have inconsistent statements. And so what she's trying to do is draw a distinction between inconsistent statements among witnesses and from a single witness. But frankly, there's a lot of overlap in that.
This inconsistency is important and equals a reasonable doubt versus this doesn't matter at all, right? Can you do that? All right, so all crimes have elements. The judge will give you the elements of the crimes, and I will be responsible, with Ms. Dugan's help, of proving each of the crimes were committed. And that means proving each of those elements beyond a reasonable doubt. Number 7, what does a killer look like? Yeah.
Please speak up, number 7.
A louder.
Oh, whoa, she turned around and stared at
No default. Really? They can look like anything?
Yes.
Who disagrees with that? Can a killer look like anything? Number 1?
Anybody?
Anybody. Can it look like your grandmother? My young people? Number 5? Can a killer look like a granny?
I mean, it's all you in picture, but like anyone who's capable of has a personality.
You could keep an open mind to the possibility that a grandmother could be a killer. That's kind of a tough one. Can everyone keep an open mind to that possibility?
Yes.
For my folks that have been divorced, any custody battles? Raise your paddle if you've been involved in a custody battle.
Ooh, this is an important
Okay,
one.
so just divorces. Anybody in a particularly messy divorce? Ugly divorce?
Real important.
Highly litigious divorce? Anybody go to court for their divorce? Did go to court, okay, but it was not particularly nasty.
Never showed up.
Oh.
It was very,
You won.
yeah.
Okay. Okay, so you guys haven't personally experienced this, but does everyone agree that those types of issues, domestic issues, divorces, custody battles, those are things that are highly emotionally charged? Yes. May I have a moment to confer, Your Honor?
Go ahead.
So a lot of people talking about Donna's earphones where she is listening to court proceedings. This looks like a pretty smallish courtroom with pretty good acoustics, so she may not need them. A lot of people are saying, well, maybe she's doing that just for looks.
For my folks that have been on a jury before,
It can be
what is a hung jury?
Courtroom. I don't blame her.
Number 22?
Speaking from personal experience.
Because a jury has to be what? Unanimous, and that means it has to be the verdict of each juror as well as the jury as a whole. So, my shy guys, can you speak up and make sure this is your verdict? Not sure I've identified exactly who you are. I think number 6 is a little bit of a shy guy, and you already told me you could do it. Who else considers himself a little shy? Nobody.
At first I am, but once you get to know me.
Okay. Are you going to return a verdict that's your verdict?
Yeah.
What if you get back there and everybody's against you?
This is someone's life, so I don't care about it.
Okay. I would encourage you to listen to your fellow jurors, and if you
Sure.
change your mind, great, because your mind's changed, and it's then your verdict. But I just want to make sure I've got folks that aren't going to be like, it's Friday night or whatever, you know. Everybody promise to do that? All right. Anybody have something you feel like you need to tell me? I didn't ask the right question. I didn't call on you. Something you think I should know about you that's related to the topics we've touched on?
This could be an important question.
Thank you very much.
Okay, well, that was pretty short, really. Overall, we didn't listen to the whole thing.
10 minutes. You'll have an opportunity to stretch your legs, use the restroom, or look at your phones or devices if you need to. This break will be for everyone, but that is both in the box and also in the gallery. While you're on your break, you're not to speak to each other concerning this case or at all. Do not speak to anyone else concerning this case as well. We will resume with the jury selection at 1:30. You may use the restrooms and leave the courtroom at this time.
Okay, we will we'll leave that up so we'll know right when it goes back. But I do want to talk a little bit about, we were in the middle of talking about a question here we got from Pascaline asking about Donna wearing those hearing devices. I do think it can be really hard to hear in a courtroom. I say that it was super hard to hear in the Delphi trial when I went there. And excuse me, when I went to the Brooks Hout trial, I asked for the headphones that were connected to the court sound system so I could hear better. It just made it a lot easier. I could hear absolutely everything. I had no issues as long as I had that. You could hear mostly in the Brooks Hout, but boy, Delphi was another matter. Huge courtroom with 20-foot ceilings, very large. And so this courtroom looks a lot friendlier. It looks like they've kind of set it up for hearing. I don't think it would normally be bad. I have no idea what Donna's hearing is. A lot of people are thinking, well, is this part of the look, part of the granny look? You heard Georgia Kappelman ask that question. What does a killer look like? Does a killer granny? Is that what we were expecting? And the answer obviously is no. Most people don't expect a grandmother to be a murderer. That's just not your image that you have in mind, which is exactly why the defense is dressing Donna and pitching Donna as a grandmother, as someone older, not the kind of person who would commit a murder. And she looks the part with her cardigan. I think it looks better with the softer pastel colors, but she's looking very much the older grandmother, not the kind of person who would commit a murder. She looks really different from when the jury will see her in video during the bump. And they'll see a very slim Donna, who she says she's gained a third of her body weight in prison or in jail. And so they'll see somebody who looks really different, looks like somebody who is not going to be, who looks more like a young person who might be involved in something. Now she really doesn't. And the defense team is playing that up. She's got gray hair. It's grown out. It was colored before she went into prison, but she can't really do that all that well in prison, and she's not. So she's got gray hair, and it's a different look. So certainly the hearing device could be part of that, or then again, maybe she has real trouble. I don't know the answer to that. So Carmina, I did turn that on. Now, typically when we catch up, which we should be caught up now. In fact, I'll make sure we're all the way at the end. Yep, we're all the way at the end. Okay, so it takes them a little while to do that, so we may not be able to keep that up, but I like it too, so we'll add that. Thank you. Mindy is a new member. Welcome. We are glad to have you. And Sandra is watching from Singapore. Wow, that's so cool. Well, we're really glad to have you, Sandra. Thank you for watching. Oh, we've also got Neil from Scotland. Gosh, that's cool. That is really cool. Really glad to have y'all from all over. We are very much an international community. I think almost 25% of our subscribers are from countries outside the United States. So that's really awesome. Really glad to have you and your interest in the court system and in justice. Thank you for being here. And look, Matilda is from the Netherlands. So is one of our mods, Marlon, who is parent of the most famous dog in the Netherlands, Jerry. And our other mod is Mama Pinks. And but Matilda, Marlon, like you, is from the Netherlands. And Loretta, great. Thank you. I appreciate it. I've been very nervous. I'm not exactly sure why this was so nerve-wracking. Don't I go live all the time? But I don't know. Somehow it seemed entirely different. I think because I couldn't prepare. Normally I have a script. I'm really structured. I have it really prepared. And so I normally have it all set up and I know what I'm going to say and I have stuff to do. But now when there's a long court break, like, oh no, what will we talk about? I actually have a few things queued up in case of emergency. Oh my goodness, look where everybody is from. Y'all are putting this in. We've got, gosh, from all over. I don't know if I can go far enough back, but look at that. We've got New York, Australia, Ohio, England, another Netherlands. That was Marlon, Tennessee. Let's see, where else? Ireland, Germany, New York and Aussie again, another one, and England, Manhattan, Canada, Berlin, Tbilisi, Georgia, Cape Town, South Africa, Texas, Italy, Virginia, Kansas City. Wow, y'all are from all over. That is really exciting. Really cool that you are. Finland, I can't even go through fast enough. I want to say a couple of points about some other things. There's a difference in the way a jury consultant is being used here. In Charlie's trial, the jury, there's some hubbub going on out there. In Charlie's trial, the jury consultant was actually the one who did the questioning. So you saw how Georgia Kappelman was interviewing the people on the jury, doing the questioning for the voir dire. She was connecting with them, getting a connection to them. And that is really important because that is your entree into knowing the jury and to building trust and connection with them as you present the case. So when she's doing that, it's a really important part of the case. Instead of the lawyer doing it, Daniel Rashbaum at the last trial, the jury consultant did that. But that is obviously very dangerous. Because although this person was an expert in selecting a jury, this person also did not have the kind of connection that was needed. Or if they made that connection, then they weren't actually handling the trial. And so that is exactly a difficult point for them. And so I do think it's wise that, as I understand it, the lawyers for Donna Adelson will be doing the questioning, the voir dire of the jury. I think that's really important. I think that connection is too big a deal to just ignore it. And I think that was a smart move. So the jury was also asked about whether you want to follow the law or do you think you could just decide the law on your own? That is a big distinguishing point in criminal cases between the prosecution and the defense. There is something, jury nullification, where the jury makes its own decision based on what it believes to be right, even if the law doesn't agree with what they have said. That's obviously controversial with prosecutors. It is not illegal, but what the prosecutor is doing is trying to head that off. Let's talk about why that might not be a good idea. And that's what she's doing there. All right, we will. Donna, I don't know if Donna is wearing the same blouse or not, but she's definitely wearing a different cardigan. I think it's a different blouse, but it might be the same one for Monday. It seems like it's pink instead of purple, which I think on Monday, I think she had that. So maybe it's that same one. Wow, look at all the places y'all are from. It's crazy. It's so cool. I don't sound nervous. Thank you, sis. Thank you. Colorado, Estonia, Tallahassee, Illinois, probably a bunch from Tallahassee, Colorado, South Carolina, South Jersey, coastal North Carolina, Sweden, London. Wow. Denmark. Well, thank you. Y'all are being very kind. We have such a nice group here. If I were to do this anywhere, I would want to do it with you in this group because y'all are much kinder than I think the average. All right. I'm going to skip down here. And I'm going to look for a couple of questions and see where y'all are. And then I'm going to put the court break screen up for just a minute and try to figure out about the hubbub and see if people out there calm down. All right. So Angie was asking me a question. Is a juror dismissed for alcohol consumption? Well, not if the jury, I mean, it depends, I guess, Angie. You say not obviously impaired. if a juror actually drank alcohol while on the premises of the courthouse and that was visible and known to other people, like if they out about it, I think that would be a serious problem because that could impair their ability to understand, take in, and make decisions, take in information and make decisions. So I think that would be a huge problem. But the fact that they in general drink alcohol, I don't think would be relevant or that anyone would ask about it. There might be cases where that would be relevant, maybe a DUI case, but this not being one of those cases, I don't think that will even be asked. But if they were actually consuming alcohol, yeah, that would probably be an issue. All right, let's see. Looking for question marks at the beginning. That'll give me a heads up that that's what you're. Why aren't they allowed to give hypotheticals during jury selection? Well, I mean, you kind of heard Georgia Kappelman giving hypotheticals, talking about, well, okay, the court reporter and I are about to go into, we are about to commit a murder and blah, blah, blah. She talked about what the law would mean. And so, I mean, to some extent, I mean, she hasn't committed a murder, but if what you mean is a hypothetical, let's say that Donna Adelson is guilty, and let's say that might be taking it too far into what exactly the jury is going to need to decide. This is not time to present the facts of the case. The bare basic facts have been presented. This is the time to find out whether or not the jurors are appropriate to address the case. All right, let's see. So I think Donna is wearing the hearing device probably just to be able to hear a little more, to be able to hear a little better. It can be really hard in a courtroom. I mean, just factually it can be, but it's not just that, because it's also the case that she is presenting an image. So it's possible that they are just using that, but I would say it's probably not just using that. I would say it probably is something a little more specific than that. All right. Well, let me put this screen up for just a minute and I will be right back. The court is on break. I will be back in about 1 minute. Hopefully I can figure out how to do this. Okay, I am back. All right, so let's make sure to add this back to the stage. And we will do it in that format. Okay, so let's keep talking questions and what people are interested in and talking about and wondering about the case as we head into it. And I also wanted to point out to you a few things that she asked right before we started. And I guess it would be good to get are they still planning to do opening statements today? I think so. That's all I can say. And I especially think so because that was so short, the questioning by the prosecutor. So if you take that and maybe say it's roughly going to be the same for the defense, then there's plenty of time for whatever initial instructions the judge wants to make, and then for them to go straight into questioning. I think there's plenty of time for that. So yes, I think it's very likely. And that's what everybody's been talking about and looking toward. That's what the judge is thinking anyway. So if not, we can just take a look at who they're getting in the jurors. And I did want to talk a little bit about what happened before we got on and what kinds of questions we heard the judge asking. So let me flip over to that. There we go. No, that's not it. So they talked about, for each juror, the judge asked about their criminal record, asked about, let's start with asked about other cases they had served on. Had you ever been on a jury? Was it criminal or civil? Were you the foreperson? Were you the person that everybody else voted as the leader? And you may be wondering, why is that so important? It's because everybody is looking to figure out which juror or jurors are likely to be leaders. Those are very dangerous and important people as you're doing jury selections. If you have somebody who's a leader, who's very strong, other people are likely to follow them, then their view coming into it is more important than the view of people who are not leaders, who maybe they've heard about the case or have a little bit, but they're not likely to speak up. They're less likely to be someone who would be a person everyone else would follow. You've got to watch those people very carefully because you're deciding, is that person, in my view, going to be fair to my client? Is it gonna work with that client? So, excuse me. And so they asked not only what type of case it was, but were you elected as a foreperson and what was the verdict? And several people have been on trials. I only heard people mention criminal trials, which was kind of odd. You would think it would be even more civil than criminal, but I didn't hear anyone say that. There was they asked about who are the witnesses that the state is going to call, and do you know any of these people? I will never forget in the Brooks Hout trial that we covered recently when I was up in Kentucky, the prosecutor got up there and said, here's a list of the witnesses. I think it was prosecutor, could have been the judge, but I think it was prosecutor, and started reading so fast. There was no possible way that anyone could have possibly have understood that. Because for me anyway, I would be like, oh, John Smith. Is that the John Smith that I went to high school with? By that time, he had already named 5 more people. I'd be like, oh, well, probably not. Okay, who are those 5? Wait, I missed them. Let me catch up. It was like no possibility that the people had any idea who was on the list, which is actually risky because you don't want to find out later and have a juror come up and say, oh, had no idea Jane would be testifying. Why? She lives next door to me. We've been close friends for 20 years. So you don't want that. But in this case, they read through them slowly and nobody mentioned any particular knowledge. I mean, there were a couple of people. One said, one is a substitute teacher with me. One answer. Another said, I knew this person growing up. And then, but that does not disqualify a juror because the next question is, would your acquaintance with this witness prevent you from considering his testimony with impartiality? And there was this really long pause afterwards. I'm not sure whether that was positive for the witness or negative for the witness, but witness said, no.
Everyone here agree that 12 heads are better than 1. Shake your head.
Yes.
Yes, okay. Now it's important right now for you to understand that. We're not trying to trick you. There are no right or wrong answers. We want to know what you believe. Now, during this process, would it be wrong of me if I were to ask you for your each individual own worldview? You know, we all have our own biases, resentments, beliefs. And I need to know, and I'm going to ask you to share with me, whether or not you're going to carry that with you into the jury box. Now, there's a concept that has gained momentum recently, and that is the concept of implicit bias. Does anyone here know what that is? No? Okay, well, I'm gonna try to explain it briefly. Now, we all want to see ourselves as fair. Can we agree to that? Yes? Okay. We all want to believe that we're rational. Can we agree to that? Now, unfortunately, studies have shown that despite our best intentions, none of us are free from these biases. Implicit bias refers to unconsciously held beliefs that don't necessarily reflect our conscious belief. So, for example, you walked into the courtroom either Tuesday or Wednesday, and you saw a gentleman in a black robe. When we see someone like that, we can assume that they're a judge. And you made that decision pretty quickly. Is that correct? Okay. So what if you were to walk into a supermarket and there's a big burly guy with a long beard, clad in leather, and he's walking to a motorcycle? Let's see. Number 5, when you see that, do you see someone who's adventurous?
Yeah, I mean, that's the riding motorcycle.
How about dangerous?
Not necessarily.
Okay. Now, you're making a quick judgment when you see someone like that, right?
Listen, bias, right? Right.
I'm sorry?
That's kind of almost neutral bias, right?
Yes, yes. Now, in that same token, you all walked in, whether it was yesterday, Tuesday, or today, and you look over at the defense table and you see my client, Mrs. Adelson, do you wonder to yourself, I wonder what she did? Number 2, you think to yourself, I wonder what she did, or I wonder what she is accused of doing?
Go ahead and put in the chat if that's what you would think.
I mean, I don't know her from the next person. So
Okay. What about number 9?
No, sir, I didn't have that question.
Well, which one did you ask yourself? I wonder what she did, or I wonder what she's accused of doing?
Neither.
Did anyone ask that question of themselves or say that to themselves? Number 23.
Yeah, I was wondering, what
I would.
what she is accused of.
Okay. I saw a paddle over here. Number 25. What did you think?
Yeah, I did. We have discrimination theories. I wonder what this person was.
Now, do any of you have anxiety or are claustrophobic that if you're in lengthy deliberations that you might want to just leave the jury room?
They're trying to get somebody
Anyone at all?
specific off with that question. I bet you.
Now, going back to implicit bias briefly, does everyone here agree, let's start on the first row, that you will make an effort to be conscious of implicit bias when you're considering the evidence in this case? Second row. Third row. Thank you. Now, when we were back in the jury room the last couple of days, some of you answered some of the questions. I think I might be able to, or I believe so. And you recall that we asked you to clarify that. First row? Okay. Why do you think we asked you that? Anyone?
Because sometimes, I'd say just about every day in our lives, we face bias because we have a perspective of what the world should be, and we can only deal with bias if we consciously are aware of how we feel and what's going on around us.
Thank you. Does everyone agree with that response? I need verbal.
Yes.
Thank you. So if a witness were to say, I think I saw this, is that the same as them saying, I saw this? Another important point, and I want to go to number 6. If you are selected as a juror and you hear the evidence and testimony, you go back into the jury room, are you able to say to another juror, well, that witness didn't say that they saw it. They said that they thought that they saw it. Or they didn't tell you what somebody said, but what they think they overheard. You can point that out. Number 12. Could you do that as well?
That's my duty. That's why I'm here.
I'm sorry?
That's my duty. That's why I'm here.
We're trying to prompt people to do
Number
that
11.
when they get back in the jury room. Notice when someone just says
Number
okay,
16.
and be sure to persuade your other jurors by mentioning
Yes?
it.
Yes.
Number 17.
Yes.
Maybe asking specific people he's worried about. Not all of them, probably some he wasn't, but also included some he was, just to see if they would agree with it.
Ms. Kappelman covered the leader, so some of what I was going to cover has already been addressed, so I'm not going to repeat it, and certainly not here to waste your time. Number 23, would you say that you're naturally skeptical? Okay, when I ask that, what do you think that I mean?
Like, today's going to be a great day. And sometimes you're like, yeah, there's something can go wrong. You better not, put all your eggs in one basket, so to say, and think everything's going to be great. You have to be open and know things can go wrong.
Do you question when somebody says something to you? Would you question whether or not they're being honest?
Yes.
How do you determine whether or not they're being honest with you?
The normal things, look a person in the eye, if they're fidgeting in their seat or, not able to stay still or, they have conflicting statements or whatever.
Let's see. Number 19. Do you agree with that? Are you skeptical? Are you naturally skeptical?
Depends on the situation.
Give us an example.
Oh, well, like he said, it's going to be a great day. I have to keep an open mind because I have no idea if it's going to be a great day or not.
You trailed off at the end.
I have no idea if it's going to be a great day or not.
Are you hopeful?
Not really.
Today might be a bad example. Now, you previously served on a jury. You said it was in California?
Correct.
Things are a little bit different out there?
A little bit, yeah.
In trials, I mean.
Well, what you guys did this time is different. I'm assuming it's because it's sensitive information. So.
You said that you didn't want to have to do it again. Is that accurate?
Yeah.
But it wasn't a bad experience?
No, I was not. I don't know. It was different than I was thinking, but it wasn't like horrible.
So, and I'm going to interrupt it for just to say, really notice his style. I'm so glad that her attorney is doing this instead of a jury consultant. I think it is a much better method to do it because I think that connection is important. He has a very different style from Georgia Kappelman. She's a lot friendlier, a lot more kind of folksy, more talkative, but he nonetheless is connecting with the jury. So kind of notice what his method is, how he's different, but accomplishing similar points.
Let's see. Number 13. How do you avoid misunderstandings with people?
Through conversation.
Can you give us some techniques?
Primarily through asking questions to not only hear what they're saying, but then to get at what they're intending as well, both verbally and then non-verbally.
So it's important to listen. Number 14. Do you agree? Any other examples of how to avoid misunderstandings? Anyone at all? I'm going to call it yes, number 16.
Being aware of what you've actually been told versus what assumptions you're making.
Couldn't hear you.
Being
Sorry.
aware of what information you've actually received versus what assumptions you've made.
Okay, so avoiding assumptions. Okay. Number 12, I saw your.
Oh, I was just gonna say that it's good to confirm your understanding of what someone has said, if that's possible.
So in other words, repeating back what somebody has said to you to confirm that you understood it the way they intended.
Exactly.
Number 23. I'm sorry, number 11. When you were falsely arrested, how did you feel about the criminal justice system?
I was a bit irritated with it at the time.
Okay. How long did it take to correct?
About 3 weeks in total. I was bailed out immediately, so I only spent about 8 hours in a holding cell, but about 3 weeks of back and forth before I was fully cleared.
It's actually pretty quickly.
I thought so, but I was rather persistent.
Number 23, you agreed that that was a pretty quick turnaround?
Oh, yes, yes.
By a show of hands, does anyone think that the state could make a mistake? Yes? What about law enforcement? What about the state's theory of a case? Does anyone think that the state could be wrong in their theory of what happened?
Yes.
Did anyone not raise their hand? 23?
Oh, no.
Oh, okay.
My hand.
Just making sure. Now, does anyone know people who keep large amounts of cash on hand?
Interesting question. This is about Charlie, right?
Number 26. Do they have a distrust of the banking system?
Yes.
Oh, wow. We heard nothing
Now,
about that.
I know.
I don't
At
remember.
least my generation, my grandparents and my great-grandparents certainly had a distrust of the banking system. Great Depression. People lost everything, right?
Okay, interesting, because I don't know that there will be evidence presented that anybody in here, and specifically Charlie, has a problem with the banking system. I don't remember that in the last trial. Maybe it was there. He definitely kept money in a safe at home, and maybe he said it was because of the banking system. But here, the attorney is conditioning the jury around that to be prepared to accept the fact that Charlie had a bunch of cash in his house. He says he just had it. He bundled it up, stapled it. This had been going on since his childhood. It had nothing to do with him wanting to pay a hitman. So we will definitely be hearing more about that.
I think we're starting to get into a point where I might not be able to relate with some people. Number 6.
I don't know if he said it that way.
Do you think that it would be inappropriate or illegal for someone to keep large amounts of cash? Let's see. Number 24. Have you ever made or received a personal call while you were around other people? What did you do so that those individuals didn't hear your conversation?
Usually asked to be excused.
You walk away?
Mm-hmm.
That's a yes?
Yes.
What if you couldn't walk away? How do you convey what you're trying to convey?
Then I usually ask if I can call back to the person.
So you would either try to walk away or you would continue the conversation another time.
Right.
What if neither one of those were options? Would you
well,
be vague?
Yeah, because if I'm trying to get, especially if I'm working, a lot of times I couldn't take a phone call, so I wouldn't answer.
I think Charlie.
What if the person that you're with is the one who gets the call or makes the call? How do you know what's discussed?
You can, a lot of times hear what they're talking about.
But what if you can't hear? They walk out and you can't hear. Do you know what's discussed?
No.
Oh, that's about fun.
Now, if the person comes back and tells you what was discussed, do you know whether or not that was true?
No.
By a show of hands, has anyone ever said something that they regretted? Thank you.
That would be a universal, right?
I know that nobody, and correct me if I'm wrong, but nobody here has ever worked in law enforcement, correct? Okay. Has anyone received any courses or done any type of law enforcement training, even those that were in the military? Number 13.
Yes, someone.
Can you tell us?
Side, it would have to be a sidebar.
Okay,
Due to the nature.
understood. Anyone else? What about private security, private investigation? Anyone? Does anyone here like to travel? Got a few that don't. You don't like to travel?
There's the Vietnam question.
Number 9?
No, sir.
Okay. For those of us who like to travel, let me pick on somebody. Who raised their
Ever buy one-way
Number
ticket?
25. Is it generally less expensive to stay in an Airbnb or a hotel for a lengthy trip?
I guess it depends on the area, but I guess recently Airbnbs kind of seem to be cheaper.
Now, there were a few people, and I didn't see the hands that have been involved in a divorce. Actually, number 11, you've been divorced?
Divorced?
Yes.
Yes, sir.
Okay. Did you have young children at the time?
I did.
But was it amicable?
It was.
Anyone not have an amicable divorce who's been divorced? Okay. Did you say things about your ex or soon to be ex that you didn't really believe?
No.
I'm sorry?
No, it was pretty cordial.
Oh, it's pretty cordial. Okay.
For me on my side.
Oh, on your side.
I was pretty nice.
What about the other side?
Yeah,
Not quite as much?
I wouldn't know.
Do you know how she spoke about you during the divorce?
Yeah.
Was it nice?
No.
And that same note, by a show of hands, has anyone ever spoken poorly or said mean things about somebody else? Pretty much everyone. Does that mean that you hated the person? Anyone? The fact that there are no paddles up tells me that doesn't mean they hated them.
So all of this is designed to address the question of whether or not Wendi and Dan's very acrimonious divorce, very bitter battle about who would get custody of the children, is that motive for the murder, or were they all about to get over it as they were moving through it? Because that's what Donna's going to say. Remember the banana bread? She cooked banana bread, baked banana bread for Dan. He let her babysit. So this motion where he said, don't want her to be allowed unsupervised visitation with my kids, he didn't really mean it, because really we were getting along. He was just in the throes of divorce. That's the reason he's asking.
I think it means we're just mad at time.
Thank you. By a show of hands or paddles, has anyone jumped to a conclusion before? You hesitated.
Well, I don't like to admit, but I suppose I have.
We're human. We tend to do that. It's not just analytics. We also have emotions that come into play. And that's how we interpret things, right? Now, for all of us who have jumped to conclusions, was our initial conclusion always correct? No. By a show of hands, has anyone had a knee-jerk reaction? Said something in that moment? Pretty much everybody? Okay. Number 7, did you later realize that you misinterpreted what was said? You're human. By a show of hands, has anyone ever planned a party?
Oh, this is about Harvey's 70th birthday. I wondered why the sound went out. I was like, why is the sound suddenly out? So there was an objection to, I guess, ever planned a party. That seems a pretty innocuous question, but I don't know exactly, where they're headed on this, but they're going to have a sidebar about it and talk a little bit about it. So let's talk about a few things we've just heard. The whole area of, Can the state and law enforcement make a mistake? That is one of the things that they are going to argue. That also ties in with the have you ever jumped to a conclusion question that you just heard. What they're talking about is, and I'll go ahead and make this like that, or even seem like I, oh, there we go. Okay. So all of that is sort of aimed at if law enforcement just from the get-go, as soon as this happened, they fixated on the Adelsons. They became convinced it was Wendi. They could not see past that, or at least it was on behalf of Wendi. It was Charlie, it was Donna, and they couldn't move past that. It was a mistake. It was, they looked too hard at that, and that's why, Jerry, you'll need to ignore that.
So I wanted to list out some things that I wanted to talk to you about. So we're going to start with some definitions and concepts that I want to see how you interpret it. We're going to talk about the presumption of innocence, the burden of proof, jailhouse snitches.
Interesting.
And we're also going to talk about some of the legal concepts that you're going to be asked to determine. Now, I think we've made it pretty clear. The law is going to be coming from the bench. I want to make sure that you can follow the law and that you understand what you're supposed to be doing. So I'm going to call on somebody new. Number 18. Can you tell us what a presumption is?
When you are making an assumption.
Is it an assumption?
Oh, come on.
Now,
That means juror.
just like the presumption of proof of innocence, you're not making an assumption there, are you? It's something that you believe up until a point, right?
You're not trying to get a juror caught. No.
Does everyone agree with that? So, for example, you're supposed to presume that Mrs. Adelson is innocent up to the point if the state can prove their case beyond the exclusion of a reasonable doubt. What does that mean? What is beyond a reasonable doubt? We're going to get to that.
Remember last night we talked to the presumption of innocence, although we may think it is not actually in the Constitution. It's pulled out of the Fifth Amendment, the Sixth Amendment, and the 14th Amendment. Due process, equal protection, and some of the protections we have, like the right to a fair and impartial jury. So, but it is a bedrock, important foundation for our justice system.
Now, Ms. Kappelman already talked a little bit about what direct evidence is and what circumstantial evidence is, right? Does anyone feel like we need to go over that again? Number 17?
No.
Okay. Now, something else that came up. The state indicated a moment ago that evidence comes from the state, indicated of their table. Evidence actually comes from the witness stand and in the form of exhibits, things that are presented to you. It's important for you to understand what I say, what Ms. Fulford says, what either the prosecutors say isn't evidence. It's argument. Number 20. You understand that?
Yes.
Number 14? Or, yes. You understand that? So if you interpret evidence different than we argue, what are you supposed to do?
Discuss it.
I'm sorry?
Discuss it.
And you're going to discuss it back in the jury room. Good. Does everyone agree with him?
Yes.
I have one confused look. Number 19. So if you interpret something different than what the state or defense argue it to be, what are you supposed to do?
Discuss it, like I said.
How do you determine whether or not the state's right or the defense is right?
I don't know.
You don't know?
No.
Can anyone offer any suggestions? Yes.
Ask to review the testimony.
What else?
Reviewing it.
I'm sorry.
Evidence.
Okay, so look at the evidence again.
that point also, the court will give you specific instructions on how to weigh the evidence when we reach that point. You may continue.
Thank you. Now, presumption of innocence, we touched on it briefly.
I see some questions about kind of where we are in the scheme of things. So let me go ahead and address that for just a minute. We are in the middle of voir dire, and the way it has worked so far, it's been more than one day already. This is the third day, and they started with a few overview questions from the judge. They went into individual voir dire, just individual questions that we were not allowed to see. They were done in a private conference room, and we didn't see or hear what was going on back there. They've come out, they are now doing all the people who passed through that, and some were removed from that at that point, but all the people who passed through that are now sitting here, and they are being asked questions individually. It started out with the judge asking everybody as a group, and I'm saying individually, that's not really the right description, but the judge started asking questions as a group. Some people answered. Then the prosecution got up and she asked questions, and she asked of the group, but individuals in the group will answer. And now it's the defense turn, and the defense is asking questions as well. When we finish this stage, they will decide, they will confer, the judge will give them a little bit of time to talk about which jurors they think they need to strike. They each have 10 strikes, both sides have 10, and they are going to need to decide how to spend those strikes. And then when they move from striking individual jurors, they will have a jury once they reach the correct number, 12 jurors plus 3 alternates. When they hit that point, that's a point at which the court will be ready to move to opening statements. That we've heard that there's going to be a break in between, but that it'll be pretty quickly thereafter. So that's what we're expecting. Prosecution has already finished its questioning of the group. Now this is the defense questioning the group. As soon as this finishes, there may be a few more questions from the court, but there will also be arguments from both sides about jurors they think, based on the answers they've just heard, should be stricken for cause by the judge. Meaning the judge will say, yeah, I'm not going to make you use one of your 10 strikes. I myself believe that this person is not an appropriate fit for our trial, and I'm going to strike them. For cause, there's a reason why they can't serve. So that will be happening next. All right, let's get back in.
It's important. You must presume or believe the defendant is innocent. As we sit here today, you've heard no evidence. Mrs. Adelson is innocent. The presumption stays with her as to each material allegation in the indictment, unless it's overcome by evidence. So by things that you're going to get up there, beyond the exclusion of every reasonable doubt. Does everyone agree with that legal concept? Shaking the heads. Yes, thank you.
Every time he shows that, I try to make myself smaller, and then he stops showing that.
It's the state's burden to prove that. So a few moments ago, I asked if anyone could define reasonable doubt. There's a definition. The judge is going to give it to you. We'll probably go over it throughout different points in the trial. But I find it easier to use some examples, because presuming someone is innocent is not how our mind usually works. So let's see. Number 5. Let's say this morning on your way in, you pull into the parking garage and you see a motorcycle cop pulling somebody over. What do you think? What do you think happened?
Presume they broke some type of traffic law or something.
You don't think to yourself, I wonder why that cop pulled that innocent person over, do you? Did anyone think that? Thank you. You probably thought, glad it wasn't me. That guy was speeding. That's the way our minds normally work. You see someone get pulled over, you're like, oh, they ran a red light, they were speeding. And as I said earlier, you may have done that when you walked into the courtroom this morning. Now, just because you think that way doesn't mean you're not qualified to serve on the jury. But it does mean that we can't have that kind of thinking interfere with part of your deliberative process. Does anyone here think that because law enforcement arrested Mrs. Adelson and the state has decided to charge her, and that we got all the way here to trial, does that make you think that she is guilty in any way? And I'm going to start with number 22.
I don't think it's an accident for people he asked.
Does that make you think that she's guilty in any way? In a way?
resources, time, and money to convict someone
Absolutely right.
that might not be guilty.
Does anyone agree with number 22?
I think that's a very natural assumption that most jurors make. There is a lot of time and trouble that went into bringing this person to sit here. All of these people, the prosecutor, the witnesses, law enforcement, they've all lined up to say it. They aren't doing this just for fun. At least they believe it. It's really hard to shake that. I think that's one of the reasons it's so important that we have the presumption of innocence and that the jury be reminded of that in advance, that although that might be your presumption, what really should be your presumption is that the person is innocent. And it has to be something they're reminded of because it is hard. That's a hard thing to remember.
Anyone else?
To an extent.
I'm sorry?
To an extent.
To an extent? What do you mean?
It wouldn't, in my mind, make sense for the state to spend, I'm assuming at this point, maybe 10, 11 years going after a person that they didn't believe was guilty, or that they had no reason to go after a person for that long.
Thank you for your honesty. Does anyone else agree with that perspective?
I don't think that it necessarily makes her guilty verdict, but I do think that to make it to trial at this point, there has to, at some point in our legal system, been enough substantial evidence or witness testimony or things that they found for it to be got to this point and not run out along the way. It's like, hey, there's not enough here, so there's something, but the burden of that is on the jury to figure that out.
So with that in mind, is that belief that you have, is that something that you're going to carry into the jury room?
I think it's a belief that I carry into the jury room that we have to listen to that evidence and decide if it's credible or not. That's why you have a jury.
But I guess it was a poorly worded question. The fact that you believe that it's gotten this far, does that gives you some idea that Mrs. Adelson is guilty?
Not that necessarily, like I said, not that she's guilty verdict, but that there's credibility to some evidence that potentially may point that way, which is why we're sitting here today. I wouldn't just assume that it's just all farce.
Would you say that you're pro law enforcement? So law enforcement conducts an investigation. They believe that they have probable cause. They make an arrest. You give that some weight. You also said earlier that they could be wrong. How do we determine if they're wrong?
By what we're doing right now.
And just to be clear, the defense doesn't have to prove anything to you.
Okay, so when we get to the end, I'm going to do a poll and by the end, I mean when they take a break. I'm going to ask you about your opinion about his demeanor versus George's. I'm going to ask you about that. So everybody be thinking about that.
Does anyone think that it's not fair that the state has the burden to prove beyond a reasonable doubt with evidence and testimony that the defense doesn't have to do anything? So let's go continue with the discussion.
Hold on one moment. Juror 26, Heather Pella.
I was just gonna say that, you know, somebody accused me of something, I want to speak up and say whether I did it or not, because I want to defend myself. And I want that opportunity.
Very important.
And that's fair. Now, concept in our legal system is a defendant has the absolute right to remain silent. The judge is going to instruct you that if my client chooses not to testify, you can't hold that against her. Can you follow that instruction?
No, it's, oh, yes, definitely, yeah. It's personally, I think that, there should be some kind of responsibility. You're obviously responsible for this.
Certainly. And I think that's human nature. That if someone says, well, you did this, we want to speak up and defend ourselves. But in a courtroom in this country, the defendant doesn't have to do that.
I think there's a time and place to speak up about things.
I don't disagree. Are you going to hold it against Mrs. Adelson if she doesn't testify?
Absolutely.
Would anyone here hold it against Mrs. Adelson if she chooses not to testify?
Okay. Why was what you just heard right there really loaded? It was really loaded because Donna Adelson refused to talk to the police. They had set up a conference and were trying to set up a conference with Donna and Harvey as they were up in Tallahassee for Dan Markel's funeral. And they left without ever getting hold of law enforcement. and from that point on have not spoken to or given interviews with law enforcement. So this witness volunteered in response to this that she would want to speak up and say, hey, I'm innocent. That is not what Donna Adelson did. And so he says, well, in a courtroom, you don't have to. And would you be okay with that? The juror says, well, yeah, in a courtroom, but that isn't where it was. So, and then the witness even struggles with him over this. Like, well, there's a time and a place to say it. Well, the problem is this juror may well believe that the time and the place was at right after Dan Markel's funeral when law enforcement wanted to talk to Donna Adelson and she wouldn't talk to them. So I think this is a juror they're going to have to strike. I think that's going to be an important strike for them.
So let's go back to what beyond a reasonable doubt means. I want to give you another example. We've been in here for a while. There are no windows to the outside. So we walk outside when we're done, and the sidewalk and the road is wet. Is it reasonable to think that a fire truck drove down the road and sprayed everything to get it wet? Anyone thinks that's reasonable? No, that's not reasonable. In that context, can somebody volunteer what would be reasonable?
It rained.
Wait, we're in Florida. Does that happen?
Every day.
So we're defining what is reasonable. Does reasonable mean likely to happen? Is that what the judge is going to instruct you? Number 2. So would you disagree with the statement that proof beyond a reasonable doubt means most likely to happen?
No, that's not most likely to happen. Very rarely like the case where it has every single aspect of evidence to it. To hold it to
You know, I've been using these examples for a long time, and I think this is the first time that I haven't had to come back and say no, because most people would agree with likely. Standard is not most likely. It's not probably. It's not most convincing. So there are different levels of proof. I think that you heard either the judge or Ms. Kappelman at some point talk about this. So at the bottom of the scale is reasonable suspicion. That's what's typically enough for an arrest. Or, I'm sorry, enough for an officer to stop someone, pat them down. Probable cause, what's necessary to get a warrant. Okay, so now, where on that scale we are, who knows? But that's enough to get a warrant, enough to arrest somebody. You got preponderance of the evidence, which is a civil standard. It's more likely than not. And you have clear and convincing evidence. That is what's required for the state to take your children from you. At the top of that scale, beyond the exclusion of every reasonable doubt, that's the standard. So when you think about the state's burden of proof, how do you think about that from an operational standpoint? What is the state required to do? So let's go back to the chart. What did I not call that? Number 8. Is the standard that you're going to be carrying forward into that jury room the side which convinces me the most?
No, your side doesn't have to convince me of anything. It's only the state that needs to provide evidence.
So he's got
Can both the
jury
state and the defense
explain that.
make arguments
Juror
that you
to
disagree
the
with?
Oh, sure.
That
Everyone makes
you
arguments.
believe that evidence does not support?
They could, yeah.
What are you going to do at that point?
Reconsider the evidence, deliberate with my peers.
If the state has only proved something probable or possible, what are you going to do?
Well, it really needs to, I gotta get the abiding conviction of guilt. So I really need to feel that conviction that your client will be guilty after seeing all the evidence.
Thomas checking out.
But that's exactly my point. If the state doesn't do that, you stop. It's not guilty. You understand that?
Yeah, that's what it said.
So in the definition, one of the words that you're going to see in there is exclusion. The state has to exclude every reasonable doubt. They have to eliminate it. Does anyone here at all, start on the first row, believe that they're going to have a hard time holding the state to their burden? They have to exclude every reasonable doubt. Anyone on the first row? Second row.
So when you say that, you mean that the state has to discount every other possible, like exclude to the exclusion of a reasonable doubt? Like, prove to me that it's
Oh, the judge is going to
not
step in
possible.
here. Yeah.
Don't use the word possible.
Okay.
So if in argument, the defense were to say, give alternatives or a different explanation, and you believe that to be a reasonable doubt. If the state doesn't exclude that, then what is your response going to be?
Okay, it's being.
Does that make sense? Does everyone understand that? I can make it really. No, I can go past it. Yeah.
I think she's asking him to keep something off screen. One of the statements he had up there, which is interesting because one of Charlie's huge arguments or concerns about.
Okay, so
I'll go ahead and stop this.
one of the things
I thought, but one of Charlie's very strong objections to Georgia's closing in his case was that she left the autopsy photos up, and he felt like that was unfair and prejudiced the jury. So they're setting a precedent early on that they're not going to let things stay up on the screen, which overall is exactly what should be happening.
the court's going to instruct you is that a reasonable doubt arises from the evidence, a conflict in the evidence, or a lack of evidence. So this is another place where I like to use a hypothetical. And for this one, we're going to adopt the bank robbery hypothetical that Ms. Kappelman was talking about earlier. So the hypothetical is someone goes in and robs a bank. Witnesses identify the defendant. There's obviously surveillance video showing somebody that is consistent with the defendant's features. So I'm click.
Please approach.
She does not want her analogy messed up. She does not want anybody jumping in on that and messing up. Consistent with defendant's appearance. So I don't know, although truthfully, I mean, it's not like there's a question of Donna's appearance somewhere, like she was actually heavily involved. So I think that's a little bit different. As you can see, they are battling hard over which jurors he is moving, meaning Josh Zellman, Donna's attorney, is moving very hard into the question of presumption of innocence and the burden of proof of the state. That's very appropriate. That's what a defense attorney should be doing at exactly this stage, because ultimately he's going to be asking the jury to conclude that what the state is offering as proof is not going to be enough.
I mean, prospective jurors, we're just going to take a brief break for the moment, give you an opportunity to stand up and stretch your legs if you need to. And recognize that we are going through this process and it has been lengthy. If you need to stretch or take a moment to do so, you have the opportunity right now.
Okay.
5 minutes. Be quick.
5 minutes. All right, 5 minute break. All right, so I'll get us into that format so we can talk a little bit better. All right, so we have seen the defense clearly showing its preoccupation, and I don't mean that in a negative way. I mean it in a very positive way. Their preoccupation with the burden of proof, the presumption of innocence, and so much so that they're breaking it out from the beginning, from the time that they begin to question the jurors. They've got the standard up there, they've got it written out, and they're going through that. They have several topics that they want to discuss with the jurors, and this is kind of bled over into burden of proof, but jailhouse snitching and where the evidence came from are still left in his list of things he wanted to talk about with the jury. So those are still to come. We are in the middle of voir dire, meaning the jurors, potential jurors, are being asked questions by the lawyers. And now when they finish this process, the lawyers will be given a last chance to make arguments to the judge that particular jurors should not be allowed to sit on the jury. There's cause to strike them. If they can't get the judge to strike them, then they have one last fallback, 10 strikes that they get to use themselves as they wish. Once they finish that, we're supposed to move into the opening statement. So this is all moving extremely quickly today. We have a bunch of things to talk about from that. I saw somebody mentioning, let's see, seems like Molly talking about she was brought in for a jury and they didn't pick her. She went through the long list of questions and then she wasn't ultimately picked. And while it could be that one or the other struck an individual juror. It also could just be that they reached the number they needed before they got to you. So it doesn't necessarily mean anything. You might not have been in the group they had to choose from first. As soon as they hit 10 strikes each side, 12 jurors plus 5 more, as soon as they hit that number, and before that, they'll pull out any removed for cause, then they stop striking. So when you are at juror 42, they've already reached the number they need. So you will never be actually considered for the jury. All right. So let's see. I see a question from Crazy Mom RN. Is there a fine line between good questions and alienating potential jurors? There sure is. There sure is. It is a dance, and it is something that is a skill that has to be learned. It's not something that some people are ever good at or that some people want to do. That's why I imagine they used the jury consultant to do it last time. There's an art to it, and it's not easy. So a good question ideally will get jurors talking. Why do you want jurors to talk? Because then you have grounds to move to strike them, right? You have grounds to remove them for cause. If a juror says absolutely nothing, that is the most dangerous possible juror. You have no idea where they stand. When you get to that person, you don't know whether to strike that person or not. So you are dependent on people honestly opening up and answering the questions. When they do that, then you can make your choice, and also the court is given the opportunity to strike the jurors for cause if that's important or appropriate. All right, so let's go through a little bit more about what we have heard, and we'll also, if we have time, I don't know, we may not have enough time, do a little questioning. I saw somebody talking about the stapling of money. That was something Charlie did. He testified he stapled his money into stacks. But that is as nothing compared to the laundering money by Donna Adelson. We will be getting into that in the trial by laundering money. Most of you are probably thinking taking money that was received illegally and passing it through so that it looks legal. But that is not what Donna Adelson meant, apparently. Katie Medbanaway testified that she believes that Donna Adelson actually literally washed her cash in the washing machine. So we will get into that. The comments about sometimes being cryptic on the phone and someone leaving and saying that something was discussed outside of that person's presence, and here's what was said. I'm really curious. I'm not sure exactly what they're referring to. If you know that, stick that in the chat. I'm curious what that means. So as far as the Airbnb versus hotel, I think that's a pretty weak attempt to explain away the Vietnam issue. Remember that Donna was captured as she was about to board a plane to Vietnam. It is true that she was renting a place to stay, an Airbnb, I guess, versus a hotel. But that's really not the issue that jurors will be thinking about. The issues that they will be thinking about is that she had a one-way plane ticket with no plan or no ticket to get back to the United States. And she had specifically done computer searches for non-extradition countries. So she selected Vietnam because it did not have a treaty with the US that would allow them to send her back. That's pretty different from just, hey, she picked Airbnb over hotel. I think that was not enough. There were a lot of questions about jumping to a conclusion. Oh, by the way, remember that one where he asked about, have you ever planned a party? And there was an objection to that. And that was the end of that questioning. He never got back to that. So whatever the objection was must have been granted by the court, would be my conclusion. Tons of questions around the presumption of innocence, which is entirely legitimate, is going to be one of the most important issues for Donna Adelson. They have carefully tried to exclude jurors who know a lot about the case, jurors who have an unshakable opinion about the case. And so the people left need to believe in the presumption of innocence, at least in order for her to have a chance. That's what her lawyers are going for. And that was why he was guiding them. Okay, well, if someone was trying to, would you speak up? Would you say that if you thought that? Would you do that? He wants to make sure they will actually make those efforts. And he went into detail about the beyond a reasonable doubt, about the standard that the state is going to be held to in its proof against Donna Adelson. It's not enough to say, well, it most likely had to be Donna, or it probably was Donna, or the most common belief among us was that it was Donna. That none of those are going to be enough. What they're going to have to show is that it was, and he went through the evidence, civil case, more likely than not, of more than 50%. That's the civil case standard. Clear and convincing, that's used in certain areas, for example, agency law. And then beyond a reasonable doubt, that's the criminal, and it's the highest we have within our system. So he's trying to remind them about that. He's all, what exactly the argument was over his wanting to amend the rob the bank that Georgia Kappelman, the prosecutor, asked. It would be interesting to know. All right, let's see if we have any questions over here. Let's see, not a question, but thank you very much. I appreciate so much all of the super chats I've been putting up on the screen. Thank you all very much. All right, so put your question marks at the beginning and let's do a little talk about what you were thinking so far. One thing I want to know is what you think about the styles of the attorneys. If you were here when we played Georgia Kappelman doing her version of voir dire, sort of friendly, folksy, a lot of smiling, versus Josh Selman, his style, what are you seeing as the differences? Go ahead and put that in the chat and I'll take a look at some of those and see what you were thinking about that. And then also be sure to put question marks at the beginning if you have a question, and that'll give us what we want to talk about next. I can talk about your question if you do that. Okay. So I am looking for question marks in the beginning. No one has any questions. Well, that's kind of good. And also, wait, I need you to have questions. You have to have questions here. It's your job. Oh, by the way, would you hit the like button? That waits YouTube says, yes, hello, we're here. They send out the word. So please do appreciate it. If you're not subscribed, we're going to be going live every day during the trial. So please subscribe. We would love to have you watch the trial with us. It's a super nice chat group, much friendlier, I think. They're just really nice people in general in our chat, and I really appreciate them so much. And we would like to have you be a part of our group. So please hit the subscribe button, notifications on, and come back to join us every day during the trial. All right, I got behind, and now everybody's questions are down at the bottom. Okay, Carmina, aren't they looking for 6 jurors plus alternates? I thought I heard them say 12, Carmina. I may have gotten that wrong, but I thought I heard them say 12 and then 3 for alternates. So we'll find out real soon. That's what I thought I heard them say. Do we know what Donna's defense is going to be? Asked Megan Kane. We don't yet. And I am just so curious. I cannot wait until the opening statement. We got a huge surprise in Charlie's case about his opening statement, and the questions that were asked in voir dire kind of led up to that. We learned a little bit about that. So far, I'm not really catching anything different from Charlie's. I'm not sensing that they're headed in a different direction, but we won't know until they actually make their opening statement. And then we'll have an idea about where they're headed and what their plan is. But I don't know. Will it be identical to Charlie's, or is Donna going to do her own variation on that? I think it's pretty likely she'll go with a virtually similar defense as the one that Charlie used. I don't really know what else she could think of. But then I was surprised by Charlie. So I can't say I necessarily have read their minds. So we will find out really soon, and I can't wait for that. Heather asking about how many strikes each side gets, and the answer is 10. And oh, those will be closely guarded and very, very precious. Opening statements, the trial is still in. You can see it in the center there. It's paused right now. They are taking a brief break in the court. And so we're just talking while they're on break, and it will start back up as soon as it starts back up. I never can remember which one is start and which one is go. Anyway, I think that's correct. Anyway, there's nothing happening in the court right now. So there's our bottom line. All right, we don't know what time opening statements are. It's going to depend. I don't think they're very long from now, but they are expecting it sometime this afternoon. Will they get to openings today? We hear yes. So they aren't planning on super long openings. I think I heard Georgia Kappelman talk about maybe 45 minutes for her side. So you figure an hour and a half. So as long as they can get jury selection done in the next, I don't know, hour to hour and a half, they should be able to get those in today pretty easily. How many potential jurors are in there? Not exactly sure. I think they were going with 110 for the pool that they were going to do the final selection from, but I don't know if anybody was a no-show today or if they had anybody who maybe had a hardship or got removed, but that was the group they were aiming for initially. Okay, and thank you, Rue. I appreciate that. Super sticker very much. Also wanted to say hi to Lana from earlier. All right, let's see. Mildred, it's pause, hit the play button. I never can tell. How is that obvious to everyone? Oh, what?
This is reality.
Okay, we'll back up. Sorry, my bad. Let's go right there. Okay, and I'll speed it up so we'll be quickly caught up. We'll just put it at 1.25. That'll be fine.
So I'm going to start that hypo over.
Okay, so it was
reasonable
allowed.
Doubt can arise from the evidence, conflict in the evidence, or lack of evidence. And so a hypothetical, the bank robbery. Someone goes in, witnesses identify the defendant from the stand, video evidence shows the defendant on the surveillance. Closing argument, the defense attorney gets up and argues that the state didn't put on any evidence to show that it wasn't the defendant's twin brother. How do you know it wasn't his twin? What kind of doubt would that be? Let's go to number 20. What kind of doubt would that be?
It's like a law school question. This poor guy.
Does anyone agree with her? Number 23, you grimaced. Oh, I'm sorry. Keep confusing these two. The chart's different. Number 11.
Yeah, that's a tough one.
That's speculative. There's been no evidence the defendant has a twin. Now, the defendant took the stand in that case, testified that he has an identical twin brother who is a bank robber, and oh, by the way, I have an alibi. Now it's evidence. You understand the difference? Yes? Okay. That is a doubt which attaches to the evidence from the witness stand that was admitted during the trial. Reasonable doubt. Now, what would the state have to do about that reasonable doubt in order to convict that defendant? They'd have to exclude that doubt which attaches to the evidence.
His fingerprints versus his brother's?
We're going to get there. Thank you. So let's go back to that hypothetical. In the surveillance video, and the witnesses testify that the robber's wearing a mask, so no one can identify him. Whose fault is that? Is that the state's fault? Number 8, is that the state's fault?
Yeah, he's wearing a mask.
Yeah. They can't prove who it is. Whose fault is it?
The burden would be on the state.
So there's no identification.
Fault is the right word.
So the lack of identification is what? Reasonable doubt.
Yeah.
Let's go back to that same hypothetical. You got a mask. Robber's not wearing gloves, and he touches the table. He touches the glass door. You can see all that in the surveillance video. It goes to your fingerprint question. But reasonable doubt can arise from the lack of evidence. In this hypothetical, the detectives never bothered to dust for prints. Would everyone agree that that would be a lack of evidence which bears on a material element of the offense, identity? Would everyone agree to that? And that the state has failed to exclude that by not gathering the evidence. Does anyone disagree with that? Now, go back to the same hypothetical. Surveillance video shows that the robber's on his phone. The witnesses tell law enforcement that the robber was talking to someone. Law enforcement later seizes that robber's phone, but they never search it to determine if there was a text or call made. Would everyone agree that there's a lack of evidence there?
Yes.
Another way the reasonable doubt can arise is based on a conflict in the evidence. In the hypothetical that I just gave you, can someone identify any potential conflicts? Can you?
Not off the top of my head.
What if they were to dust the table or glass for fingerprints, but it's not conclusive?
What if the guy was somebody who visited the place earlier and could be seen doing the exact same thing?
Now the state, before we move on, does anyone agree that witnesses that are going to come and take the stand are not actors? Does anyone expect to see what you would see if you watch a TV program or a movie? Number 13, you were smiling.
I think before stepping into this whole process, there's an idea in your head that you put in there, like I'll John, what it all looks like. When you step in, it kind of is shattered. You go into the jury, it's like a puzzle, by the way. So that is the difference between make believe and reality.
And this is what?
This is reality, not anything.
Judge is going to instruct you on how to weigh the credibility of witnesses. Now, the state brought up a point, this is something that happened 11 years ago. Does anyone think that if someone doesn't have an accurate memory, that that's something that's going to matter here? You're 22. That's going to matter?
If the person doesn't have accurate memory, yeah, it will matter because it will be harder for information on evidence
It's kind of a different question to ask.
the information that you can provide to the juror will not be accurate.
How do you determine if so?
He's asking whether it matters. So yeah, it matters, but is it maybe pretty normal? Then the answer would also be yes. Interesting way he
is giving you an accurate answer. Would you compare it to the other evidence?
Speed it up.
You cannot really help.
I'm sorry.
So you cannot really help unless you have the videotape or something that you can go back and review.
One of the instructions the judge is going to give you is you can believe or disbelieve any testimony from any witness. Okay. Ms. Kappelman talked a little bit about co-defendants. I'm going to talk about something else. Informants.
Where we get to his jailhouse snitches on his chart.
Why would a jailhouse snitch cooperate with the state? I'm going to call on somebody I haven't called on yet. I can't call on everybody. Number one, what would motivate a jailhouse snitch?
Special treatment.
Okay. Like what?
I don't know. What kind of amenities can they give? Maybe less time or comfort?
In evaluating the testimony of an informant or a snitch, should you consider what benefit they got in determining whether or not they're being truthful? Number 8, I saw you shaking your head or nodding.
Well, I mean, somebody could be getting a kickback and be telling the truth at the same time.
What do you mean?
I mean, they could have seen something bad happen and get a reduction in the sentence for telling on them. It doesn't mean the person did something bad or did not do something bad.
So they could get the benefit, but it doesn't mean that what they're saying isn't truthful?
Yeah, I mean, they could be lying or telling the truth. Just because they got, a benefit or anything doesn't weigh on that other side of the equation in my mind.
Okay, so that statement he made about, I don't think I've called on everyone. Now, you may have heard that and thought, wow, why does he need to call on everyone? Let me explain why some attorneys will try to call on every single person. When you strike a person for cause, when you use your peremptory strike to strike somebody as an attorney, there are certain reasons you cannot strike somebody. You can't strike them for race. You can't strike them for gender. But any sort of general reason, I didn't like her, I didn't like the way she smiled at me, those things are all possible. It doesn't have to be an explanation, yet it can't be one of those explanations that's considered inappropriate. And so in this particular case, the one reason why attorneys sometimes call on everybody is so they have a way to articulate a reason that they chose to strike that person. So if there's a challenge, it's called a Batson challenge based on a Supreme Court case. And if at least federally, and most states call it that as well, if that challenge is made, then they have to be able to come up with an explanation. And if they've never spoken to the juror said nothing individually, it's harder. So a lot of times they'll try to get somebody to speak a little bit. So interesting. Now they're talking directly to Donna. Wonder what that is about. That's very intriguing. And no, I don't have any idea. That seems sort of odd in the middle of the in the middle of the questioning here. Let's see if we caught up yet. Yeah, we're almost caught up. We're about 2 minutes out. So we'll keep it on 1.5 through all of this, because I don't want to have to back up and find where we were. They've also asked about why would a jailhouse snitch cooperate with the state? We know that there are going to be people who were inmates with Donna
back on
both sides.
Topic of informants or snitches. We had one opinion that just because they testify doesn't necessarily mean that they're being dishonest or honest. Okay, so we don't know. How do you determine whether they're being honest or dishonest?
The other evidence is presented as well as their body language.
You got to weigh what they're saying against the other evidence, right? Now, if you were to learn that the state can offer a benefit to an informant or a snitch, and it could be financial, it could be favorable treatment, or anticipation of favorable treatment. On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? And I'm going to go number 7. Is that fair or unfair?
6.5, 7.
Number 6. Number 5.
Fair or unfair.
Number 22. It'd be balanced. Number 4. Yes. Number 24.
5.
5. 2. On a scale of 1 to 10, with 1 being unfair and 10 being completely fair, where do you find yourself? If you were to learn that the state compensated or gave a benefit to an informant. Okay. Number 1.
Scale to 1 to 10?
Yes.
6.
Number 8.
Initially, I feel like it's unfair, but when you think about it, no one does anything for free, and there's going to be a lot of risk to coming out against a lot of folks that also will be in jail.
So it's a balance?
Yeah, it's a risk versus reward, and I think the higher the reward, the more of a risk someone is willing to take for that reward.
Does everyone agree with that?
Defense won't like that.
Okay. Number 9.
I'd say it's unequal. 5.
23.
I agree with mostly what he said. If it's
Someone to disagree.
yes, yes.
Number 11.
Number 5.
Number 12. Number 13.
Now he's finding out who's a leader, who will say, I don't agree.
Number 25.
I'd say it's a 4 because state didn't have more influence to.
You can't hear that.
Number 20. Can't read my own handwriting. Ma'am.
I'm 25. I think she's 25.
Yeah.
Just
Yes. Thank you.
About 5.
About 5. 20. 19. 18.
Is it legal?
It's legal.
And it's fair.
Number 17.
Go with 7 as well.
16.
That'd be hard for me to say, just that general circumstance really depends case by case.
Just a moment.
This is so important for them because they're trying to figure out how they deal with the 2 inmates who are going to say that Donna asked for them to do something. We've all been kind of cloaked in mystery. We don't know a lot about it yet, but it appears to have something to do with she was supposedly coaching them for how they would talk about Katie Medbanawa and Katie Medbanawa's deal with the state. It gets so intricate because Katie made a deal, or she wanted a deal. The state never really agreed to it. And people will testify that Donna wanted them to talk about that.
Does anyone think that the defense should have the same benefit there? The defense can do that as well? No? I'm sorry? Could the defense offer a benefit to a witness?
Well done.
If I were to tell you that we can't. Number 24. Is that fair that we can't do that?
I know that.
Right. Is that fair?
I don't know, I just know it's a lot.
Right. Number 14.
I think fair deliberation is on them to prove their case.
Fair. Now, has anyone here heard that a description of the role of a juror as having a duty to deliberate about the facts? Anyone? Getting some slight head nods? And once you decide the facts, you apply the law to those facts. What does deliberate mean? Let's see. Number 19, what does deliberate mean?
Discuss the facts and case with the jury.
You trailed off at the end, I'm sorry.
Discuss the case with the jury and agree with.
Does everyone agree with that? What does it take to deliberate? Do you think carefully? Consult with each other? Getting some head nods? Does anyone here, bless you, anyone ever just engage in a family discussion around the dinner table? Show of hands. Are there informal rules for that? Number 7. What are the rules at your house?
Well, my dinner table has a 8-year-old, 6-year-old, and a 2-year-old, so right now the 8-year-old is the operator, and everybody gets to tell their part. Everybody gets to go to the computer.
And I've had children that age before. It can be somewhat difficult to wrangle them. How do you encourage them to follow those rules?
Sometimes with stern authority, but most of the time with the illustration of, hey, you want everyone to listen to you when you're talking to, you need to be quiet where your sister talks. I try to model that for them myself too.
So you redirect them. Sometimes you got to be stern, but you try to redirect them and you try to use your own methods of showing them an example. Now, for those of us who have older children, let's see. Number 11. I know what it's like to have 4 children. How did you determine whether the family discussion was successful?
I guess if we were all still speaking to each other, that discussion took place was a success in my house.
I can relate. Now, would it be accurate to say that the end result, the conclusion that is reached, coincided with your initial conclusion?
Not necessarily.
Now, if you felt strongly that your way was the right way, would you be capable of standing up to them and saying, I believe this, I hear you, I respect you, but I disagree?
Absolutely. And that's exactly what I was in my household. And right, your opinion as well. Let's all kind of understand each other and respect each other in that regard.
So in other words, can you accept that sometimes we just don't reach an agreement?
Absolutely.
Now, number 6. I think you touched on this a little bit earlier, but if you are engaged in that conversation and you disagree with everybody else's conclusion, but it's 6 o'clock on a Friday and you're hungry, are you going to change your opinion so you could go get something to eat? I don't think so. Does everyone remember why that statement causes me concern? Are you going to change your opinion? Anyone here willing to change their opinion if they believe that their interpretation is correct? Anyone? Getting crickets.
I'll change my opinion if the evidence suits it. My opinion's not set in stone or anything.
Well, let's back up a little bit. If you believe strongly after having this discussion that you're right, are you going to change your opinion so that everybody can go home?
I mean, there'd be a lot of peer pressure. I could see that, but I mean, me personally, my opinion goes out in publication on all kinds of stuff that we stake our reputation on that as PhDs. So only good concrete facts really change my opinion.
Okay, that was a really long pause about whether or not he would be able to stand up to other people. Obviously, that's what the defense wants. They know that their chances of getting 12 jurors who say, wow, completely not guilty is low, not super high. And so they want somebody who will say, when some people are moving toward guilty, some people who say, yeah, no, I don't agree with that at all. I think she's not guilty. And they're trying to encourage, would you do that? Would you be the person who stood up to everybody else on the jury, got in the way and said, no, I don't agree?
So short answer would be no, you wouldn't change your opinion.
No.
Would anyone change their opinion so that they could go home? I'm getting shake. Okay, great. Are there topics that you should not discuss when you're back in the jury room? Anyone want to volunteer an example?
That's an open-ended question.
Anything you may have heard secondhand inadvertently through somebody, work, home.
What about whether the defendant should testify? Is that something that you should discuss back there? What does it mean if the defendant doesn't testify? Should you discuss that?
And the judge will tell them.
Number
too.
7, should you discuss that the prosecutor decided to charge Mrs. Adelson? Well, you said earlier that if we've gotten this far, that it means something, right? Should that be something that you discuss?
No, I just think that's something that gets us to the trial. The only thing we're discussing is what happened in the trial.
Does it matter what clothing I wear or my client wears? Is that something that you should discuss back there? Trying to find somebody to pick on for this. Number 13. Can you give me a definition of something that's, an example of circular reasoning?
It's really putting jurors on the spot. That is harsh.
The argument that you use as the evidence to prove the argument is true.
I'm going to give you an example too. I like that. I don't think everyone's going to agree with me on this, but good guys don't make mistakes. Law enforcement officers are good guys or gals. Therefore, law enforcement officers are good, I'm sorry, let me back up. Good guys don't make mistakes. Law enforcement officers are good guys. I'm a law enforcement officer. Therefore, I don't make mistakes. Circular? It's not accurate, is it?
I wouldn't call it circular, but
Do we want to avoid that type of reasoning when you're deliberating? Anyone disagree with that? Does anyone think that law enforcement officer who testifies should be believed over somebody who's not a law enforcement officer? Anyone? Number 17? No?
No.
When you're back there, would you be deliberating if you automatically accepted as truthful without the exercise of any skepticism the testimony of a law enforcement officer, number 17?
Ask me again, please.
Would you automatically believe testimony of a law enforcement officer without exercising any skepticism?
No.
You wouldn't be deliberating, would you? You're just accepting what they tell you. You got to question what is said to you, what is presented. Do you agree with that?
I did.
Does anyone disagree with that? Just going to accept what is presented by the witnesses. Anybody? Good. Now, I'm going to go back to you, number 8. When you're deliberating, you have concluded your conversations. You believe that you're right. You said that you're capable of standing your ground, right?
Yes, sir.
Now, what about the reverse? You go back there, you believe steadfast in your position, but then somebody else adds something that you hadn't considered. Are you going to then consider that as part of your deliberative process?
Yeah, that's the whole goal.
One of the instructions that you'll get from the court says that you should use your common sense. Is common sense a process or is it a result? Let's see, who do I want to?
These are really, I mean, I'm not used to people asking the jurors questions of this type.
And so if common sense is a process, should you automatically accept the state's conclusions without discussing them? What should you do?
Common sense might be common, but it's not always the answer. So that's something different. So you have to be skeptical whether even common sense can be wrong.
Are you capable of saying, if someone's common sense result, their process leads them to one conclusion, but your common sense process leads you to another? How do you resolve that? Or can it be?
Go back to what you assume is common, the common sense, and kind of discuss those, what's so common about it. What are you hinging the common part of it on? Like, what do you actually think is so reasonable about it?
Thank you.
Number 26. Go ahead.
I don't think we can, in all fairness, always trust our common sense, because I think we all have to say common sense. But circumstances change, and when circumstances change, we need to rethink whatever our common sense is telling us.
So think through what he's trying to do here. He's trying to condition the jury that I just went through why you might need to stand your ground, why you might need to stand up, because you might be the only person who is in favor of my client, and you may have to go to battle for her when you're back there in the jury room. But now he's doing the other side. Yeah, but what if the other side is, everyone else on the jury is for my client and they're persuading you? Can you be the kind of person who also could accept the fact that other people might persuade you, that you might need to change your mind, that you might need to go through a process of reevaluating and using common sense?
Does anyone agree with that? Getting some nods. Anyone disagree with it? Now, you've heard the court read the charges against my client. One of the things I want you to understand is what's going to be necessary as you are evaluating the evidence. Ms. Kappelman asked, how do you determine someone's intent? Everyone remember that? It's not just, does somebody always say what they intend to happen? Shaking your head? How do you determine that? With their words?
Every time.
Yeah, that's part of the things you know, but how they would benefit from it, from body language, what they're telling you, compare that against other evidence and what witnesses say.
Did he say body language?
Now, what's clear is throughout the case, everyone understand that you don't reach a conclusion until you don't start deliberating until after all the evidence. Okay, so when you get to that point, all the evidence has been presented. At that point in time, you guys then have the opportunity to go back and discuss what the evidence means. Does everyone understand that? Shaking the heads, yes. Now, if the state establishes that there's a premeditated killing of Daniel Markel, and that Daniel Markel is dead, does that mean that it was done by the criminal act of my client? You need to be able to separate my client from the other individuals. Does everyone understand that? discuss. Principle. As Kaplan discussed it earlier, the important thing to take from this is the state's going to have to establish Mrs. Adelson had the conscious intent for Daniel Markel. How do you determine if someone has that? Number 5, how do you determine if that happens? How do you determine if the state can prove that? Now, in the principal instructions, the state's not going to have to prove that Mrs. Adelson was present. Have you heard the term guilt by association? Anybody? Shaking your head, yes. Now, there's going to be testimony that my client's son, Charlie Adelson, was convicted. Does that mean, does that mean that my client has any involvement, that she is guilty? Shaking your head, no. Anybody saying yes? Is that conclusive in any way concerning Mrs. Adelson? Shaking of the heads. Number 7, is that a factor that you're going to consider when you're evaluating the evidence? Yeah. Sure. The fact that my client's son, Charlie Adelson, has been convicted of these charges, is that something that you're going to consider when determining whether or not my client is guilty?
That's really interesting because the judge talked about the fact there was a motion from the defense, and the defense wanted to make sure that there was, and had asked about not necessarily telling the jury about convictions, that if it came up as a natural course when they were questioning the witness, then it would simply come into evidence. This person had been convicted. But in this particular case, they're leading with the fact, the defense is, that Charlie has been convicted. That's because they know that's going to come in. But also notice they're assuming that Charlie is going to testify. At least I think that's how I hear this. But they are definitely telling the jury, no, up front, her son has been convicted of this. And this is going to be super important because they are going to be trying to convince the jury to separate Charlie from Donna. Okay, maybe some jury, rightly, wrongly, whatever reason, thought Charlie was guilty, but that is not the same as thinking Donna is. And that's a very hard distinction for the jury to make.
No, but if the state uses some sort of, maybe just use turn on, the state has a connection, or if they present some evidence, that would have to be considered.
Is it conclusive?
No.
So what you're saying is the state would have to have evidence connecting Mrs. Adelson to her son's actions. They would have to have evidence beyond a reasonable doubt. Does everyone agree with that? Yes. Anyone disagree? Just because he's been convicted doesn't mean that my client is guilty.
Oh, interesting. Charlie guilty does not mean Donna is. Let me stop for a second. Okay. So this is obviously hugely important for them, right? Because we've got I was trying to make this bigger. We know what's going to be happening is that the evidence is going to come in that Charlie did this, that, and the other, and that he and Donna worked together with the bump, that Charlie hired Katie McBanuel. All of that is going to be part of what the prosecution's theory is. And so the fact that Charlie was convicted, that means another jury looked at similar facts and said, well, yeah, to us, that means he's guilty. Can the jury ignore that? Or is that going to be like, look, everybody thinks he's guilty. There was another jury that thought Charlie was guilty. We can rest assured that we're making the right decision. Is that something that could really happen here? And so the defense is trying to draw that distinction. On the one hand, Charlie could be guilty and Donna could be innocent. There might be many reasons. Maybe Charlie didn't make enough objections. Maybe his attorney wasn't as good. Maybe the evidence was stronger again. Maybe he didn't present strong evidence that we are going to present. Can you draw that distinction between the two? And it's going to be really important for them to get the jury. I'll go ahead and push it toward the end. We can catch up right there. Okay. So it's going to be important for the jury to draw that distinction. That's what he's trying to do. I think he is putting the jury on the spot some. He's asking them some really hard questions. Like that. What is conscious intent and how would the state prove it? Like, wow, I don't know, man. That's not my field. So I think that's hard for the jurors, but he's making really important points for his client. And it may be a little tough on the jurors, but I think he is headed toward a direction he needs.
We were discussing other people's responsibility.
Right. And there are a
There's
lot.
one person that's going to be on trial here. Does everyone understand and agree that your feelings about anybody else and whether or not they have any responsibility have nothing to do with Mrs. Adelson's responsibility? Everyone can separate that. Focus your conversations only on Mrs. Adelson. Does everyone agree? Let's see. Looking for somebody with older children. Number 11, I'm going to pick on you again.
Number 11.
Kids ever lie to you when they were growing up?
I know.
Say it again.
Absolutely.
How did you determine if they were lying?
I had pretty good kids, so normally they felt guilty enough to come tell me that to me. But typically, as a parent, it's fairly easy to pick up on when your kid lies to you for the most part. The older they got, the more difficult that was. But
So your children are adults now.
correct.
They ever lie to you as adults?
Oh, I'm sure they do.
Have you caught them yet?
A few times.
Number 16, how do people react when they're scared?
Very much depends on the person. Someone's going to have a lot of big emotions. Someone else might kind of go into a calm response.
Some people don't react the same. People don't react the same when they're scared. Everyone agree with that?
Yes.
Okay, and why is that going to be important? We know it's going to be important because of Donna's reaction to the bump. She is going to argue that she was terrified of the person handing her this note asking for $5,000 because she thought they were a member of a gang. Specifically, she wants to be able to say it was the Latin Kings gang and that was more frightening to her even than other gangs. So they're asking about how someone would react if they were scared because they don't want the jury second guessing whether Donna was really scared. They want the jury to accept her explanation that she was.
And I grew up in Miami, and I had a friend whose family was featured on a reality TV show after Hurricane Andrew. He quickly discovered he didn't like that type of attention. Anyone experienced something similar where they've been in the spotlight and they didn't want to be there? Number 16, you're shaking your head yes. You've been in the spotlight before, you didn't want to be there?
It's not me, like, it was on local news as a kid, didn't like it.
I'm sorry, I couldn't.
Yes, a little bit. Like, when I was a child, I was on local news and got very shy during that.
Okay. You wanted to get away, right? Does everyone understand that that feeling you want to get away from unwanted attention? Yes? Now I'm going to ask you something I don't normally ask in jury selection, and I apologize if I offend anybody.
Okay, that already sounds interesting. So we definitely want to hear that. But I'm really intrigued by that. Where exactly are they planning to make that argument that Donna or someone was in the spotlight and wanted to be out? Is that related to changing the children's names, wanting to pull them out of the spotlight? is that related to Wendi and not wanting to talk to the police, or Donna and Harvey not wanting to talk to the police? I'm curious. So his question was, I'm going to ask you something I don't normally.
By a show of hands, anyone familiar with Judaism?
Maybe it sounded like it was a bad question.
Thank you. Are there important life events that happen in the lives of Jewish children? Was your grandmother at yours?
I'm not.
Oh, okay. My grandmother was at mine. I'm going to bring up something else that's a little unique. And who was familiar with Judaism? Okay.
I'm always going to ask.
12? That's you?
Oh.
Oh, 14. I don't know why I can't keep this straight. I'm sorry. Actually, I'm going to skip that. Let's see.
Darn, I would like to know what that was. It's skipping.
During the course of the trial, there are going to be some photographs shown of Mr. Markel. Is anyone particularly averse to gory scenes? Nobody? Number 9? Can you talk to us about that?
I get fairly squeamish about that kind of stuff. I'm not passing out the sight of blood, but other stuff that are more gruesome is just a bit unsettling.
Is that something that you wouldn't be able to review that evidence?
I should be able to review that evidence.
Should be?
Yes,
Or will be?
Will be able to.
And that, I think, again, goes back to the autopsy photos. Charlie, we know from the phone call with his mother that was recorded while he was in jail, we know that he believed showing those autopsy photos largely and hugely impacted the jury in his case. He felt like that was very prejudicial to him. So they're trying to weed that out in advance to talk about the fact you are going to see some gruesome photographs.
Is that going to impact your ability to be fair in evaluating that evidence?
No, sir.
I'm going to ask a somewhat provocative question. At this point in time, does anyone here believe the state actually knows what happened? Anybody?
Say that again.
Do you believe the state knows what happened? Sure.
Kind of a trick question there.
As we sit here today, now remember, prosecutors were not witnesses to this case, correct?
You have to get my
They're going to present
forward.
arguments.
I'll be right back.
So as we sit here, do you believe that they know what happened? Or do they believe what happened? You understand the distinction? Does everyone understand that?
Yes.
Okay. Just a moment, Your Honor.
Are they side-buying it, as we heard from the Karen Reed trial? I think they are. So, all right, let's talk a little bit about what we've just heard. And the question about, are you familiar with Judaism? They did not get into that. And I'm kind of surprised. It's hard to know which way that question goes. One of the things that the state is going to bring up is evidence. Let me change my... Yep, there we go. One of the things the state is going to bring up as evidence against Donna is things like the fact that she wrote to her daughter Wendi about ways they could really get Dan Markel. as they were trying to win custody and get him to agree the kids could move to South Florida near Donna. So for example, she suggested that Wendi tell Dan that she was going to convert the children to Christianity from Judaism. And that would have been extremely upsetting to Dan, who was strong in his Jewish faith. And that was just one example that she tell the kids they were going to, or tell Dan Markel the kids would be dressed as Nazis. There were all kinds of jokes that were comments. I don't know, joke is exactly the right word, but sort of extreme things that she mentioned specifically she wanted in order to convince Dan Markel. Obviously, those were against her own Jewish faith as well. They may have been more in the sense of a joke. She may argue that.
3 heads are better than 1, Your Honor. Enough, nothing further.
But I'll stop it for just a second. So the question is, if someone says, yes, I know a lot about Judaism, and yes, I know, for example, the question they were asking about some event in a child's life, they were obviously asking about the bar mitzvah, and the Markels wanted to attend the bar mitzvah for their grandchildren, but ultimately ended up not being invited to the primary bar mitzvah. Those sorts of questions, somebody who has a background or understanding of Judaism would understand better. But does that mean, I mean, where does that mean they fall on the spectrum? Does that mean they're going to be more in favor of Donna or less in favor of Donna? It's really pretty hard to tell. I'm surprised he didn't go into more detail about that, but I do think that it's not an easy thing to tell just by somebody's answers around that exactly which direction they would be leaning.
To make any inquiry of Juror 26.
Yeah, were you able to follow the discussion when I was doing my presentation? As far as we talked about principal theory, I gave my circumstantial evidence demonstration with the cheesy donut example. Anything that you felt like as you were sitting out there listening, oh, I would definitely interject at that point? Or has your mind been numbed so much at this point you can't harken back that far?
I was listening to everything you're saying. I mean, I would interject. I want to say this, but I won't say it. You know, I would always consider a person's character when I as to whether I believe them or not.
So in the context of, oh, you're going to hear from some witnesses who've been convicted of felonies, who live a different lifestyle from you, that kind of thing, is that the discussion where you were having that thought?
I try to be open-minded, and I think there are all kinds of people, not everyone. So I don't want to prejudge a person because I don't know what circumstances are. That's why I go to ponder the evidence and decide on that point.
Okay, so can we agree then that although those types of characteristics or character, as you said, are something to consider, they're not the end all be all, and you can keep an open mind to the testimony, does it fit with the other evidence in the case, that sort of inquiry.
Yeah, and I think
Okay, as opposed to being the type of person that, oh, I hear they're a felon, I'm done, can't hear anything they have to say.
I think that's very accurate.
Anything else during my time up here where you were bursting at the seams to share something with me? Okay, thank you, nothing further.
Okay, so what she's doing is rehabilitating a juror. In other words, making sure that the juror can be fair despite the way she answered a question for the defense. And so she said, well, even if you did find the person was a felon, could you keep an open mind? Why, yes, I could. That's called rehabilitating, because now the judge does not necessarily have to strike the person for cause.
Those at this point can join me in the jury room along with the court reporter. For everyone else that is going to remain in the courtroom at this time, I'm going to instruct you once again, do not discuss the case with each other or anyone else. If you do need to stretch your legs or use the restroom, you may do so, but you do need to return to this courtroom. We're in courtroom 3G. No one is to take a tour of the courthouse by themselves. Please come back to courtroom 3G as soon as you finish with the bathroom, using your phone or stretching your legs if you need to. If the parties can please join me in the jury room.
All right. So we are on break again with the court. So we can talk a little bit more about what we've just heard. I'm very curious about your thoughts in terms of what you think the different, very different styles of the defense attorney and the prosecutor, really different styles as they talk. And you particularly saw it there at the end when Georgia Kappelman got back up. She's the prosecutor, and it's a much friendlier tone. It's professional. It's not that. It's just that it's a more relational, conversational tone versus the way that the defense attorney, Josh Zellman, approached the exact same sorts of questions with the jury. And so that difference can really impact a jury. I'm curious what y'all think about that, what you thought about these two different styles and the way they handled it. I do want to say I felt like the defense attorney really put the jurors on the spot more than he should have done with some questions that would be really pretty hard for people to answer. I'm trying to, if I have them all. When he asked about if a principal, and by that they mean not like a school principal, but the person who was principal main involved in a crime as a legal term, and what would conscious intent be? Like, wow, that's pretty tough for somebody who is not an attorney, hasn't been trained in that at all. And hasn't even been given an instruction yet from the judge about that. I thought that was a little harsh. And he said that he asked questions about whether the defense could offer a benefit or not. That's really an important point. I do want to get into that, the jailhouse snitches discussion. And I saw, I think it was Christine said, well, that's a pretty pejorative term. Why is he allowed to use it? And it may just be that the two sides have agreed they're both going to call everybody that. The thing, though, is there are snitches upon snitches upon snitches. So you've got Katie Medbanawa, who is saying, I am turning state's evidence, even though the state hasn't promised me anything yet. I'm trying to get them to promise me something. So I testified against Charlie and presumptively now against Donna. I'm now opposite of what I said before because I'm hoping to get a benefit. I'm serving life plus 30. So I'm thinking anything would be better than life plus 30, although it needs to be less than life or it's actually not better, I guess. So that's one person, one level. And then we've got the new investigation into Donna, where two inmates, we don't know much about them, are going to say something about Donna attempting to solicit evidence, solicit witness testimony. We would like to know more about it. We apparently will find out more. It's not something that's led to separate, distinct charges. It's not like she's being charged with soliciting a witness, soliciting perjury or anything like that. But one of the witnesses is going to say that Donna wrote out instructions for her. We know little about it, but we'll be finding out more. But then there's another witness who is going to say that at least one of those two witnesses was just doing it to make a deal. So, and those, I even missed a level because those two witnesses apparently are going to say something about Katie Medbanawa. So you've got Katie Medbanawa, who is the girlfriend who hired the hitman. And I'm sorry, this is complicated, but it's the best I can do on as we get into this. So Katie hired the two hitmen. She's in prison for life plus 30. Then Katie is going to say, yeah, I lied because I thought the jury wouldn't convict me, but they did. So now I'm telling you the truth, which is Charlie hired me. And I believe Donna was involved as well. But the two jailhouse snitches, they're now being called, are going to say that what Donna wanted them to say was that Katie made that up just to get a deal. We think that's what they're going to say. It's not 100% clear, but those two people would say that. And now the other witness on top of that that Donna is presenting is going to say that at least one of those witnesses lied to get something for herself in order to get Katie, discredit Katie when she came up to the stand. It's all gotten very complicated. There are snitches upon snitches upon snitches. So we're trying to figure out exactly what the story they will tell will be and which one will kind of come out on top. It's an interesting question that he started asking around, do you know whether the state what will people get if they testify? What will the inmates get? And if they don't testify, or if they get that, Do you believe them, or do you think that disqualifies their testimony? But that also could apply to the new witness for Donna, who's going to say that the jailhouse snitch was agreeing to lie in order to get something. So it's going to be incredibly complicated as we move into this. It's going to be fascinating to see how all of this unfolds. It's going to be absolutely wild. All right. I'm so glad to have everybody in the chat today. If you haven't hit the like button, would you do that? That will really help us with YouTube, and I would appreciate it. All right. So he also asked some questions about whether the defense could offer a benefit. The state can, like the state could say, okay, well, you're serving life plus 30. We'll reduce that to 20 years. But the defense doesn't have the power to do that. They don't have anything to offer. And he was trying to make the point that it's a little unfair for that reason too. And that does make the final witness they offered, whose name I'm blanking on, a little more credible, because she can't be offered anything. She's simply coming forward and stating this is the case. He also asked about if anybody there would automatically believe law enforcement without skepticism. That is a constant problem on the defense side, is the idea that the people who come in and testify for the state tend to be pretty credible. They tend to be law enforcement officers, people who have served the public for many years, who have put their lives on the line over and over again for multiple years. It's easy to believe those people, to believe police officers, and to believe some of the law enforcement who have been paid by the state to come and testify about DNA or about fingerprints. That's their job. We pay them to do that. And so he's asking, will you just assume that law enforcement is correct, or will you at least give them equal skepticism to everybody else? The idea that they can make mistakes too. They may be trained in this, but they can make mistakes or testify falsely. So he's trying to get jurors to agree to that. There was another, do you believe common sense is a process? Which these are hard questions. I do think, that aside, I think he's done an excellent job, because what his huge problem is going to be is separating out the standard of proof that the state has to give from what they actually have in terms of evidence, separating Donna from Charlie, separating Donna and Charlie from Katie and the two hitmen. Those fine lines, he's going to have to draw those over and over again. And when he has to draw those, then what that's going to mean for him is that he is going to be asking them to make some very fine distinctions. One thing we had heard from Charlie, that he seemed to feel like the jurors weren't all that intelligent, that, none of them had even read a book in the last year, he said. And the truth is, it sounded to me like overall the jurors were exceptionally intelligent. They really seemed to answer questions really well, and they were hard questions. So I feel like they maybe proved the opposite with this, at least this particular group of jurors. Let's see. Charlie, they already know, they now know Charlie has been convicted, and Charlie will, and all of the witnesses will come in their jail attire and testify. At a minimum, I think Katie, and if Sigfredo comes, he has not come to the other trial, to Charlie's trial, and Luis Rivera, they came in their prison scrubs last time. Now, this time, Charlie almost surely will as well. And the jury's been told he's been convicted. Would you hold that against Donna? Or could you draw a line? Whatever happened to Charlie, that's somebody else's business, some other jury's business, but it's not ours. All right. Making sure. Yep. I think I'm good. I think I still have it going. If I don't, y'all will tell me. All right. He asked him, do you know that only one person is on trial? And that's so important that they be able to separate all of that out. But it is really difficult. And I'll make a statement at the end when we finish talking about this, about the evidence in the case, which is obviously going to be an issue for Donna's team. I thought it was really interesting, the question he asked about how do people react if they are scared? And on several of these, he didn't really follow up with these. He asked, how do you know if someone lies? And then kind of moved straight into, have your kids ever lied to you, and that sort of thing. But he never really got into, how do you know if someone lies? At least if he did, if the juror answered maybe completely fully, I didn't hear it. It sounded to me like he kind of switched over to, have you ever been lied to? Meaning maybe he's going to suggest that Donna's kids lied to her. Maybe Charlie lied to her. I don't know. That would suggest a true distinction between her defense and Charlie's, which would be fascinating if they're going to make that argument. And got into, how would you react if you were scared? And the attorney offered, well, people react differently if they're scared. I'm not sure the jury was getting quite the answer he wanted, so he just put it out there. And I think they are going to be talking specifically about how Donna reacted when there was the attempt to extort her in the bump. There was a person posing, he said in testimony, as a Latin King gang member, although when he came up to Donna, he didn't say the words Latin Kings. He just handed her this note. He was an extraordinarily cordial gang member, and he handed her this note and said, yeah, you need to take care. You need to take care of, and use the nickname for Luis Rivera. And she seemed surprised, but she just put it in her pocket and went on. Later, we know she called Charlie, and we heard some questions about those cryptic messages between them, and when might you want to talk cryptically? That is going to be a big argument by the defense. By the prosecution. Prosecution is going to say that these coded talks between Charlie and Donna show that they had something important to hide. They were talking in code. They were talking cryptically because they were afraid they were being wiretapped. And you don't get wiretapped by a Latin Kings gang. You get wiretapped by the federal state government. That's how it happens. And so you could not have been wiretapped by the Latin Kings. If you were afraid of the government, not of a gang member. That's going to be a critical argument for them. And they asked about gory scenes and whether people would be particularly averse to them. They really, I think, are just kind of getting out there that, look, there are going to be really gory things you're going to see. You're going to see, for example, that that autopsy photographs will be shown, and they're going to kind of condition the jury to the fact that that's going to be happening. Interesting question. Do you believe the state knows what happened? Fascinating question, because, it's really difficult to answer. I think they correctly got it right that I don't believe the state knows what happened yet. I want the state to prove to me that the state knows what happened. But it's so easy to think, well, I believe they think they know what happened, or they wouldn't be here. They wouldn't be presenting this to us. If they didn't have some clue, they were thinking to themselves, I have no idea what happened. What on earth was this all about? Then they wouldn't be standing here in court. They wouldn't be prosecuting her. And that gets to the heart of what the defense is worried about. So I thought it was a really interesting question. And the prosecution went back to that one juror and said, well, can you keep an open mind even if the person testifying is a felon? Could you do that? And she said, yes, she could do that. All right, well, while we're waiting for court to come back out, why don't you put some questions in, put some questions at the beginning, and we can get started on what you're thinking about. Give me your thoughts too. I'm really curious about what you have thought about the very different styles. I think probably the jury is much more likely to get a warm, fuzzy feeling with Georgia Kappelman. I think they're going to have more trouble getting that warm, fuzzy from Josh Selman. He's a little more confrontational with them in terms of the questions he asked, but I think he asked very important, well-done questions that hit at exactly what he needed to get from the jury to prove that the jury is not actually, or to force the state to prove what it needs to prove against Donna Adelson. And he's got to have the jury focused, laser focused on that burden, or he's got no chance at all. I thought it was really well done from that perspective. It wasn't the kind of voir dire that would get that close relationship, but it was one where they were able, where I think he asked really thought-provoking questions that will make a difference in how they deliberate in the case. Oh, CJ saw me on Courtroom Confidential yesterday. Appreciate your asking about that. Enjoyed being on that. We don't have a current plan, Josh and I, to do another collab, but I'm sure we will in the future. Okay, let's see. I'm looking for question marks at the beginning. Will this be on the X? I don't know what that means. On the EX. I don't know what that means, Richard. You will learn if you're new to the channel. You have to be like really upfront with me. There's a lot of times people will do acronyms and stuff. I never get those. So you have to just kind of lay it out for me. So ask a little more detail around that, and I'll see if I can answer that or we can discuss it. Expo, will Georgia extort Zellman for $250,000? I don't think that will happen, but an interesting question. The extortion, the $1 million, I think that Expo is referring to there. One of the things the prosecution says happened in this case is that Donna Adelson came up with a plan to offer $1 million to Dan Markel if he would just agree that the children could move down to Miami and be near Donna and Harvey Adelson. And the reasoning behind that, $1 million, was, according to the Adelsons, that way Dan could move also and have plenty of money to fly back and forth to his job in Tallahassee. He didn't want to move. He was a law professor in Tallahassee, so it really wouldn't do for him to live elsewhere. So they were trying to make it palatable for him to fly back and forth. But the prosecution says, look, this shows you how invested the Adelsons were in getting those kids down to Miami. So invested, they were willing to put $1 million toward it. They were going to divide it, depending on which witness you listen to, as 1/3 from Donna and Harvey, the parents, and 1/3 from Charlie, and 1/3 from Wendi. Although Charlie seemed to think that, but Wendi didn't seem to think she was on the hook for 1/3. So she seemed to think her mom and dad and Charlie would each take 1/3. So I don't know who, if they really had an agreement on that. Apparently it was never offered to Dan Markel. There's no evidence that it was, and Wendi testified that it was not offered. Let's see. Did Donna bake cookies? Nancy Perry asked. Not that I'm aware of. We talked yesterday about the sort of warm, fuzzy look that the defense would like for Donna. I feel like she's been pretty severe and in the first 2 days during jury selection, but you can see today she has on a white sweater, a pastel shirt, and is a lot more approachable looking than she was the first 2 days when I thought she looked pretty grim. They want to cast her, the defense, as the grandmother, the kindly old grandmother who would never hurt a flea, who does nothing but kind acts for others, baking cookies, and for Dan Markel, banana bread. That's the view they would like the jury to have about Donna Adelson. So it's a little hard to do that, I think. Her dress will play a huge role in that, but I think the dress with the dark look, I think that was not a good look. I think this is better. She has gray hair. All of this, let me be clear. All of these things are attempts by both sides, and both sides do these things, to try to make sure that their side is cast in the best possible light. It does not undo evidence. There is real evidence in the case that will be presented. That is only what the jury is going to use to decide. That their first impression of Donna matters, and what they think about what she's wearing and how she looks. Yeah, super, super important. All right, I'm headed back over to more questions. Oh my goodness. Yeah, I'm wondering that too. Willow Wren asked me, is there time for opening statements today? It's getting kind of late. I don't know. It's going to depend. The judges said they won't always stop at 5. They will sometimes go later. So we'll see. And I assume what they're doing back in the back is taking a little time for their strikes, some arguments about more jurors, and then they will come out and announce which ones are jurors and which ones are not, and they'll either take a break and go into getting all my words mixed up. Take a break and go into opening statements, or they will say, come back tomorrow morning, you're the ones who will sit on the jury. I think I'm going backwards now. Let's see. Amy asked an interesting question. Is it important for the jury to like the lawyers? And it is important. It definitely matters. It's not the end all be all. The jury can make a decision based on the facts, the evidence, and their beliefs, maybe likability of the defendant or of the state, where it's not really linked to how they feel about the attorney. But it's not unimportant. It does matter. It's at least something that enters into the large mix of things that contribute to what the jury will decide. And so that's why that rapport, starting with jury selection, is so important. It's the chance that the attorneys have to establish a connection and to say, I'm trustworthy, I'm credible. And that's honestly more important than likability, although that matters, is trust and credibility. The idea that the jury can look at you and say, okay, if you present this evidence to me, I can believe it. You are going to back it up. Witnesses who aren't going to fall apart on cross. You are going to show me documents that support that. All of those things I can trust. I can count on that for you and from you. But what they are saying instead is that the jury, if the jury doesn't really trust the attorney, if that trust is broken at any point, that can create a real hardship for the attorney going forward, because every witness put up is like, oh, what's this witness going to say? I don't know if I believe this witness because the last three were totally destroyed on cross. So you got up in opening statement and you told me this, and this were going to be proven, and you were wrong on all of those things. That really hurts. That's one of the reasons that attorneys hate so much being chastised by the judge. That's one of the reasons they hate saying anything in opening that isn't clearly provable in the rest of the case. They want credibility. They want the jury to believe them. So when they put something up, when they say something, when they offer evidence, the jury says, yep, I expect that that is true. That definitely matters. Pythagorean Runner asked me questions about accessory after the fact defense for Donna. I think that is more or less what she's arguing. She's going to argue, and that it had nothing for her to do with the death of Dan Markel. It had to do with protecting Charlie from this extortion, and not just Charlie, but the whole family, since this extortion came directly to her. I'm guessing that will be her defense. We will find out pretty soon. I don't know if we'll find out today or not. That is a good question that Willow Wren asked. I am not sure if they have enough time yet. We are on the edge, which would make sense. The judge said it would be Friday, but everybody said it would be Thursday. And yesterday, the judge thought so as well. KK asked, do you think they could or would still bring charges on Wendi? That is such a good question. I don't know the answer. I've debated it back and forth. One thing you can tell for sure is that they want to prosecute Wendi. They would really like to prosecute Wendi, but I don't know if they feel like they have the evidence. It will make a difference how the jury reacts in this case. I think the fact that Donna is on trial is because the jury convicted Charlie. So, okay, that worked. We know what that evidence is, and mostly it's similar or the same as what we're going to have here with Donna. So now if Donna gets convicted, that gives the state a little more of an idea that, yeah, they can persuade the jury with what they have, and then they may take that on to Wendi. But thus far, she hadn't been charged at all. She's been called a co-conspirator, but not been charged in any way. I feel like I left somebody's question out earlier. That was there's Pythagorean Runner had asked me that question. I'd left it out because I was going to answer that later. So thank you very much for your super chat. And in fact, there were two. She's believing accessory after the fact defense could work, considering that a lot of the evidence for Donna is all after the murder. It's the actions that happen after the murder. And that's why I think you're absolutely right that the majority of it relating to her comes afterwards. I think that's some of the reason that the prosecution will lean heavily into the question of Donna doing things like supposedly laundering money, literally laundering money and giving it to Charlie There isn't strong evidence about that at all, in my opinion, but they did have a little bit of evidence kind of suggesting that maybe Donna had brought cash to Charlie. Charlie gave it to Katie. Katie gave it to the hitman, technically after the murder, but closely connected to it. And then you've also got the evidence related to Donna's relationship, animosity towards Dan Markel. You've got the fact that they were in the midst of divorce and he had filed a motion to keep her out. So thank you, Pythagorean Runner. And I'm sorry that I almost didn't get to it, but got back to it. And let's see, Jan Shore is a new member, but also has been a member for 9 months. So I don't know which to thank you for, but thank you both for being a new member and for being a member for 9 months. We are glad to have you either way. And she also had a comment about being surprised by the prosecutor, personal and funny, and seems kind. She was harsh in Charlie's trial. I think she's a very tough attorney, and what she can do in the voir dire process is it's part of who she is, but I think she's also a very tough, hard attorney because that's her job. She's the prosecutor. That is exactly what she's responsible for doing. So I think your observations are really interesting. All right, looking for the question marks at the beginning. I'm going to take a little sip of water here. Wow, it's my longest live stream ever, I think. There will be more of these. Okay, well, the jury know that 4 people are already in prison for this. Okay, when the judge made the statement yesterday, he told the prosecutor that to the extent it was possible to keep evidence about people serving prison time out, then he wanted her to try to do that. There had been discussion privately before that we weren't privy to. I assumed he meant everyone who had been convicted, which would be Charlie, which would be Katie, which would be Luis Rivera, which would be Sigfredo. He may have only been talking about what the defense is calling jailhouse snitches, the people who knew about claimed that Donna tried to get them to falsely testify about Katie in order to help her. Those jailhouse snitches, and then the one who snitched on one of the jailhouse snitches, maybe that's what the judge meant. It's not clear at all whether that will hold up, because he said if this comes up naturally, it comes up naturally. And that's the way it is. Last time, for sure, we had Katie Medbanowa and Luis Rivera come in prison scrubs. It was no question at all that they were serving time, that they had clearly been convicted. That was just known. And you could see that obviously. As far as whether, so I think that will happen again. I think Charlie, if he comes to testify, will also be wearing his prison scrubs. So I think it will be just in evidence. We know for sure Charlie's will, because the defense just told the jury about it. Question there. The defense told the jury and said, will that keep you from believing that he has, that he may have been found guilty, but that's not the same as your job in this case, which is to decide whether my client is guilty. Can you keep them separate? Really hard question that he has to ask. We have a lot more. Let me head over here. Pythagorean Runner. Yes, it has. This is really interesting, Pythagorean Runner, that you mentioned this. If you listen to Katie's testimony from Charlie's trial, she seemed unsure the money came from his mom. In fact, she said she thought, well, maybe it came from his mom, and that it was washed. Agreed. She said it was wet. It was in a bag. It was starting to mold after a few days. And she was like, why is this wet? And she said, I thought it maybe had come from Charlie's mother, who might have stopped by, but I never saw her. Katie's testimony we covered last week in one of my videos. It was all over the place. It was a mess, and it was really difficult to determine exactly what her actual story was. She testified twice when she was on trial herself. The first time she got a hung jury. The second time she was convicted. That testimony in both cases was, I didn't do it. I wasn't involved. I know nothing about it. And it changed when she came to Charlie's trial. In between, there were 2 times that she gave proffers to the state where she went to them and said, I have knowledge, information. I'd like to give this knowledge or information to you. And if I do that, will you give me some time off my sentence? Will you give me a break? And they have not yet offered that. At least they hadn't as of Charlie's trial. But those were also available. And they had, throughout it, her story changed and morphed over that entire time. I think she's a really hard witness for the state to bring and impossible not to bring. So that is going to be a challenge. That will be really interesting cross-examination, I think. All right, where were we? Yeah, but I agree with you, Pythagorean Runner. And y'all who are following the case, you might really enjoy that video. Go back and check that one out. I think you'll like that. Barb is a new member. Fantastic. So glad to have so many new members. Glad to have y'all with us. And now I will head back over. Yeah, I think I'm still at the spot. Okay. I don't want to have turned it off again. That would not do. Let's go back over to where your questions are over here. All right. That was from Rosebud. Pascaline, do you think it's an advantage for the state the prosecutor is the same who convicted Charlie? I think the answer to that is yes, because of the fact that she knows so well the case. She knows exactly what worked last time. She's already been through preparing for and cross-examining these witnesses. She's read all of their prior depositions or statements. So she knows the case. Anytime you know the case, it makes it easier. And if you have to learn the case from scratch, that can be a challenge. So yeah, I think that is an advantage. Rosie Burns, in your experience, do juries respond well to older defendants playing up their age? It might depend on the case, but in general, I think yes. I think juries can be sympathetic to that, to the idea that the person doesn't fit their image of a criminal. And even beyond that, the idea, well, gosh, they're older, just give them a break. It's possible that they can be affected by that. So I think there's a reason why the defense is playing it up. Do I think it's going to work? That is an entirely different question, but I think that it can work. And so I think that's why people play that up. Let's see. I'm going through for questions at the beginning, question marks at the beginning. I'm way behind. So if you're just putting them in, I hope they'll be back before we get to that. It'll be late if not. I Wait for Money podcast asked me, if opening statements are today and tomorrow, how many witnesses will they get through tomorrow? Wow, I feel like that's a math question. I don't know. They went through, I think, the first day of Charlie's trial, they had at least 3 witnesses, may have been more than that. And they ended with Wendi on the stand, and then she came again the next day. Wendi is going to be a super big battle because the judges quashed Wendi's subpoena from the defense. Both the prosecution and the defense said, Wendi, here's a subpoena. We want you to come testify at trial. And Wendi said, okay, to the state and no to Donna's. Why, you ask? Well, the big reason is she gets something called use and derivative use immunity for what she is going to testify to when the state calls her to trial. But she doesn't get that when the defense calls her to trial. So she could incriminate herself or be forced to take the fifth on the record and in public if she's forced to come for the defense subpoena. So that's why she's done that. That's another video we covered you'd be interested in. You can go back and look at that. Okay. Peaches is asking me, will the jury know the kid's name was changed to Adelson? I believe they will. That is one of the key things that they talked about in Charlie's trial. And what Peaches is asking about is that Wendi Adelson, after Dan Markel, her ex-husband's death, she changed the names of her sons from Markel as their last name to Adelson as their last name. And she was asked about that on the stand. And she said, yeah, the reason was that all that negative publicity around the murder, I didn't want that associated with them. I wanted them to be able to hide. And I didn't want them to be known and associated with that. And of course, the prosecution thinks that's not it at all. And they talked about it as erasing the entire existence or legacy of the father, who had, as well as the father's family, as far as the children were concerned. That part and parcel of that was removing their name. And the fact that their name was changed just erase their dad from their lives like he was nothing to them. That was one of the prosecution arguments. Now, there has been an argument from the defense that Donna wasn't involved with that. So this really is irrelevant to Donna's case and shouldn't come in this trial because, I mean, that was Wendi. That was all Wendi. The prosecution said, well, there are some emails that suggest it wasn't just Wendi. Donna, we don't have the emails, so knew about or supported or suggested, who knows, somewhere along that continuum that she had some involvement in it. We don't, as of the last I heard, there wasn't yet a ruling on that. So I don't know whether or not they will be, what they will actually know in this case, but I think they will probably be told at least that the name was changed. The question may be how much the state gets to argue it and whether or not that was connected to Donna, but we'll see what the ruling will be. Diane Bennett wants to know what Donna is looking at if found guilty. Well, she is charged with murder, solicitation of murder, and conspiracy to murder. So she is looking at life in prison. Alice wants to know, do you think Donna will testify? I do, Alice. And the reason I think that is just because her side said that. They said it twice in a recent argument in front of the court. Do they have to do that? No. And the judge was super clear with them. You just told me that she's going to testify. Okay, fine. But I want you to know that just because you say she's going to testify, she doesn't have to. I'm not requiring her to testify. She has the right not to take the stand. And the defense said, yeah. Anyway, she's going to testify about this and that. And therefore, and they were using that to make their argument about something the judge should do. So from that and them saying it twice, I think the at least plan is for her to take the stand and for her to testify. Her son did as well. So that will all be very interesting. Freddie's cat asks about whether voir dire is always a group thing as opposed to individual. This case, it was both. It's traditional, Freddie's cat, for it to be a group thing where everybody sits. It's so complicated. It's really hard to get a grasp of it, especially at first. So you'll have, depending on your case, maybe 50 people sitting there, and you've got to take notes on all of them. You'll be, let's say you ask the question, have any of you ever been convicted of a crime? Or have any of you ever been charged with a crime? Let's do that. Have any of you ever been charged? And the juror here and there and here and there raise their hands, and you have a very elaborate seating chart numbered. And you saw, in fact, the attorneys were carrying their seating charts around the courtroom. And those seating charts are places where they can make notes and write about, okay, what about this person and that person? And keeping them in order is all important because you've got to associate your notes and your thoughts about a particular juror with that actual juror, not the wrong one. So it is usually done in a group setting. In this case, they did some individual voir dire where they moved the jury back into an area where one juror and all of the attorneys, it looked pretty intimidating, really. Oh, are we back on? Oh, did we lose our, let me add that back. Okay, I think we're fine. Let's move all the way to the end. I want to make sure looks like we're all the way at the end. I don't see that, still seems to be live. So I think everything's good. All right. So they ask the jurors questions individually. One of the reasons they might do that is if they are asking them something and they don't want other people on the potential jury pool to be affected. In this case, it was really important because what they were asking them is, how much do you know about this case? And do you have some information about this case that would prejudice you? So if they ask that in a group setting, someone says, oh yeah, I know all about it. I know her son was convicted, and I know, that all these podcasts talk about it, and I know they might arrest her daughter or something like that. And wow, then you've got a problem because everybody just heard that. People who had never heard of Donna Adelson, didn't know anything about the case, now just heard way too many facts about the case. And so they pull them off individually so that if anything like that happens, it's not a problem. It doesn't poison the other jurors. They can talk very openly with that individual juror and say, what exactly is it that you know about this case, if anything? And the idea too is sometimes that's used for sort of personal or embarrassing questions. Depending on the case, there might be some of those. I'm not really sure there were any in this particular case. I think more the individual questions revolved around what they knew about this case in advance. But you might have one. You might have something embarrassing medically, but you need to ask the jurors that because there's going to be that issue in the case. So that's just an example of where it might matter. Okay, looking for the question marks here. And I am pretty far behind, but so I'll keep going. Crab Kitten, how many jurors were answering the questions? Does each side still have 10 strikes? That they have not used their 10 strikes yet. That may be what they're doing right this minute. They may be back there using their 10 strikes. They will also be arguing about individual jurors. They will be arguing that this juror or that juror had an answer, whatever answer it was, that means they should not be allowed to serve for cause. You, the judge, ought to kick them off. I shouldn't have to use one of my 10 strikes. We played a clip from Charlie's jail call last night where Charlie argued exactly that. He said, we had to make he called them X's or strikes. We had to X out certain jurors when they were jurors who clearly were biased against me because the judge wouldn't strike them. And so we had to really just eliminate people who were terrible. We never got to the people who were probably not going to be as good. Whereas the state, it was all rose. They were able to just strike, anyone who would be fair to Charlie. And they struck those because they had so many strikes. My experience is that absolutely no one has enough strikes. I think Charlie has a misimpression about that. Everybody thinks that some of the jurors would not fair to their side. And you always think it's more than the number of strikes you have. It's always at least 2 more than the number of strikes that you've been given. That's my experience. And it doesn't matter how many strikes you've been given. It's never enough. Check over here. Oh, wow. What an honor from my father's alibi. That is such an honor. Well, good luck to your daughter going to Yale. That's fantastic. And if I was any part of the inspiration for that, I am really honored. That is just like overwhelmed. That is so nice. Thank you. And I am delighted, and I hope that she does become a lawyer. I think she's already at Yale, so she's well on her way to a highly successful career, quite clearly. Thank you. That was a really lovely message. I appreciated that. All right, we will come back over here. I'm looking for the question marks. All right, let's see. We've got Vina Bates is asking me if potential jurors know what trial they're auditioning for before they get to the courthouse. It depends. In Lori Vallow Daybell's case, they actually sent something out saying, do you know anything about the Lori Vallow Daybell case? And Lori Vallow Daybell objected to that. And she's like, well, you can't tell them about that before they come in. And he said, well, the judge said, well, the whole point was to find out if they knew anything about your case. So if we don't mention your name, how do we find that out? But in this particular case, it doesn't appear that the jury did. They brought them in, and once they were there, they asked them what they knew about the case. So that's more common. Typically, you wouldn't know in advance what case you were going down for. You would know that you have jury duty and you need to be there on Monday at such and such a time, and that would be what you would know. And here's where you park and show up on time. All right, Linda B asking, if you had to defend Donna, what would your defense strategy be? I honestly haven't thought through that. Charlie's defense was so elaborate. I just wonder if there's not an easier way to have done it. It was really complicated, elaborate. It required the jury to believe a lot of different things from him. So I don't know if that was it, but I honestly wasn't able to think of another right off the bat either. So if you have any ideas, let me know. I don't know if I have an answer to that, Linda B. It's a good question. Miss Shorty, do we know if Georgia or Sarah is doing the opening statements? We don't, but I remember, I think Sarah did the opening for Charlie. I'm pretty positive she did it for Katie Medbanoa. And it's kind of common if you've got 2 attorneys to split it. And usually you have one attorney who's kind of your closer and you'll put them on closing, and the other attorney you put in the opening. and they both can kind of connect and relate to the jury that way because they're going to be trading off through the trial. I would expect that's exactly what we see between Jackie Fulford and Josh Selman on the side for Donna. That's what I think will happen there too. One will take opening and the other will take closing. I mean, that's really common. And typically you pick the lawyer who is more kind of the facts-based person, and you put them at opening, and the one who's more argumentative, and I don't mean in a bad sense, but persuasive, better at argument, you're going to put them in the closing, and they're going to try to pull it all together with a more emotional speech that would really persuade and move jurors. So that's kind of how it's common to do. That's not always the case. Remember, Daniel Roshbaum, Charlie's lawyer, pretty much handled it all on his own. So he took the opening, he took the closing, and there you have it. He was the whole kit and caboodle. All right, looking for questions, hoping they come back soon. I'm getting tired. Ann asking, has Harvey been? They have not been charged with anything. And that includes, by the way, there was early talk about whether he was involved somehow in this new investigation that was being done by the state that appeared to relate to these two jailhouse snitches. We're just going to use Donna's team's word for them. And somehow they were being coerced, something, to testify that Katie Medbanowa was making things up just because she wanted to get out of jail, which frankly was an argument you could make anyway. It's an argument that you can make that based on her testimony and the contradictions in her testimony. But they were going to say, at least we think, and we will find out, but they were probably going to say that the two of these two jailhouse informants overheard Katie say something about she was making this up. She thought she'd get out of prison. We think that's what it's going to be about. And that at one point there was talk about what Harvey never cleared that he was involved, and no one, including Donna, is being charged for that. So Donna's team says, yeah, we've proven that's nonsense, that there is no substance to it. And yet the witnesses are all still named. And when the prosecution read off the list of witnesses and the defense read off the list of witnesses to the jurors, they were included in those lists. So I don't think it's been eliminated from trial yet. At least it may come in. Are the Markels present? I can't see that. They haven't really shown the courtroom, Heather, but I would be shocked if they were not present. They were a very present group at the beginning of Charlie's trial and throughout Charlie's trial. So I would imagine they would be there right now at her trial as well. I don't think they will be left out. All right, let's see. I may have left out some people. Oh, thank you. My Father's Alibi has gifted 10 lawyerly memberships. Thank you very much. I appreciate that. And based probably partly on that, we have Helen Beatty as a new member. Welcome. Thank you both. I really appreciate that. And Jackie P has gifted 5 lawyerly memberships. She is one of our largest gifter memberships. We are very grateful to Jackie P. Thank you very much. And Heather, thank you very much for your super chat. All right, so let's, I'm still looking for question marks. If I missed yours, I won't get to all of them. I feel pretty sure about that. Okay, Misty is asking me, could the prosecution ask the jury after the case is over if the evidence presented would have led them to a guilty verdict on Wendi? That is such a great question. And Misty says, well, I know the jury doesn't have to take questions. They don't have to answer up, but would they? Would they maybe do that? Yeah, they definitely could ask them that. I could say, what was your opinion about the guilt or innocence of Wendi based on what you heard? Yeah, they absolutely could ask that. It's really common for the lawyers to attempt to interview the jurors after a case because there are multiple things you can learn. You can learn in part about what you did wrong. I mean, just personally, you can learn that, oh, this would have been more effective, or I didn't buy this argument, or the way you presented this didn't work for me. You can learn all sorts of things for you personally. And then, of course, for the case, should there ever be another trial, let's say it gets reversed on appeal, or let's say that there is, as in this case, multiple connected cases, then you can learn a lot of information that you can pass on and use in the future. So yeah, absolutely, they can ask that. And I think it'd be really useful for them to ask that. I would guess that there is somewhat of a battle because it takes approval levels to decide to prosecute someone. And prosecutors really hate to lose cases for good reason, right? And they don't want to waste resources. They don't want to prosecute people unnecessarily. And just personally, who wants to go in and lose a case? Nobody's eager to do that. So typically, you know, the prosecutor has to believe that it's a case, but often there are levels above that for approval. So it could well be, I feel like from her statements that Georgia Kappelman feels strongly that Wendi is involved, that Wendi should be prosecuted. But she's not the only person who probably enters into that equation and into that decision. There are probably other people who do just as well. And they may not agree with her. They may think it's a tough case. If she wasn't guilty, why would Donna launder money? Tammy asked. And see, Tammy, that is a great question that the jury will be asking, but they are also going to have to answer the question, did she even launder money? Because as I've forgotten who it was earlier, but Katie was pretty vague on that. Katie wasn't just a straight up, yep, she laundered. She was like, I believe she laundered money based on the idea that she came by and the money was wet. Well, what if Charlie laundered the money? Or what if it got wet because you ran through the rain? I mean, who knows? So it wasn't all that specific about her actually laundering the money. There wasn't really strong evidence on that. And so I think that the first level of evaluating that is, did she even do it? Is that even real? And after that, then we move to the question of, okay, let's say she did launder money. Why would you do that unless you were guilty? And I don't know there's a great answer for that. It is a really odd thing to do unless somehow you thought it would remove fingerprints or something, or maybe very, very seriously misunderstood the definition of money laundering. But why would you bother is a great question. And if the jury believes that she laundered the money, they may have to reach that question. Care E just has questions. I'm also often there. Lauren Crime asked whether Georgia will try to elicit incriminating evidence against Harvey when questioning Donna. Yes, I do. I think that is absolutely what she will do. I think she will go directly for questions like that. And Donna, I mean, she can say whatever she answers, but she won't, if she's already on the stand and testifying, she's not going to be allowed to say, okay, I pick that question not to answer. So she's going to have to answer the question. And what will it mean for Harvey? We will find out. Is there any evidence against Wendi? Acquired Taste asks. Yes, there definitely is evidence against Wendi. There is the fact that she drove down the road where Dan Markel's house was right within an hour or so of the time he was shot, or hours, and then turned around, went a different way. The prosecution thinks her purchase of Bullet bourbon was connected. I never really bought that. And she brought some pretty strong evidence against that to the last trial. So I don't think that's a super strong one. But the fact that she drove down the road, the prosecution says the reason she did that is because she wanted to see if anybody had discovered his dead body yet. Like, were things percolating? And she found, to her surprise, yeah, they were. There were police there and they had blocked off the road. So there's not just that. There were statements that she made, none of which were super individually incriminating, during her interrogation by the police when she was interviewed right after his death, things like that. So I think a lot of the evidence bleeds over, but there is probably less specific evidence about Wendi. And that's why I think she hasn't been charged yet. She's the last in the line, unless you count Harvey. So Ginger Snaps is telling me she would be a great juror for this trial. And she believes that Donna made the TV appointment. The TV is going to be a huge issue in the case. Let me take a sip of water so we can get into the TV. So the question of the TV, that is another link that could pull Wendi in. Although, again, I thought it was pretty vague. Charlie bought a TV as a getting divorced consolation gift for his sister, Wendi. It was broken on the day that Dan Markel was shot. It had been broken for a while, and an appointment had been somebody to come out and repair it. And Donna, even though she was in Miami, arranged for the repair person to come out and repair Wendi's TV. It couldn't be repaired. It literally had a hole in the front. Wendi said it was because one of her kids threw a ball into it. The prosecution insinuated it was because Wendi intentionally destroyed it, and that the whole having somebody there at the having a repair guy show up, that was all part and parcel of giving her an alibi, making sure she had some way she could say, yeah, I was here because of the fact that it was, I had to be here to meet him. I could not possibly have been the person who killed Dan Markel. Leo Matthew Chamberlain asked me about whether Wendi is a defense or prosecution witness. And the answer is she is prosecution only. And she moved to quash, that means to put down, prevent from being active, the subpoena the defense had sent her, saying, yeah, I'm not going to come testify for my mother because I don't get immunity if I do that. I'm only going to testify for the state. Now, you might think, well, what does it matter, really? I mean, if she testifies, she testifies. And the answer is that the state may only ask her some questions. And then the defense is allowed to cross-examine on every one of those questions. But what if they had other questions for her, which they say they do, and those questions weren't covered by the state? Well, they can't just throw them into the cross-examination because it's not connected. They can only ask about topics covered by the state in direct. They could subpoena her for their case and then ask the extra questions, except this time they can't because Wendi actually got that quashed. Let's see. Krista OG is asking me, is the defense allowed to bring up the fact that Wendi refused to testify for them because she couldn't get immunity? Very, very interesting question, Krista. I don't know the answer. I don't know that she, gosh, it could go to her credibility. I don't know. I think that they will get into that. That's my guess. They will find a way to get into that. And the reason is they're going to want the jury to know that Wendi, is not testifying for the defense, that she is fully testifying for the prosecution, and she's making sure of that. But I'm not positive that it would be admissible. So that is such an interesting question. I wish I knew the answer. Thank you, Marie Louise. I appreciate that. Scar Motley and Me is referring to one of my favorite stories for the kids, the Amelia Bedelia story. I loved those. I thought those were great stories. So I thoroughly enjoyed those. Thank you, Scar Motley and Me, who has been a member for 12 months. And Mildred, just Mildred, is, this was a huge issue in this trial. The implication from the prosecution, really not even just from the prosecution, from Jeffrey Lacasse, who was Wendi's boyfriend at the time of Dan Markel's murder. Remember, Wendi and Dan were divorced and both had moved on and were dating other people at the time. They were still, though, battling over custody and over the kids. And Wendi was dating a guy named Jeffrey Lacasse. And he believed and testified at Charlie's trial that he thought Wendi was basically trying to set him up for the murder of Dan Markel, that she was stringing him along. She had pretty much fully intended to break up with him. She was already, in fact, seeing other people or going out on dating sites, trying to meet other people. She wasn't staying with Jeffrey Lacasse. And then she, shortly after that, broke up with him. She says, that's not the way it was. I broke up with him before this. And, he kind of hung around. That's not my fault. But that is an issue. And one of the things that Wendi supposedly did, Jeffrey Lacasse believes, is set him up, like make sure, are you going to be in town on this day? And did that so that maybe he could be the fall guy. If anything got traced back to Wendi, maybe they would believe that her boyfriend killed Dan Markel because he was mad at the way Wendi was being treated. And so he went out and exacted revenge. And Jeffrey Lacoste, at the time when he was first interviewed by the police, he really seemed to still like Wendi, frankly. And he was saying things like, well, there's still like a 1% chance we could get back together, or maybe he said 5, but there's a chance, but not really. It was obviously small. They definitely were broken up by the time of his interview, but he didn't seem to believe at that time that he was being set up. But I think he maybe thought about all the things that had happened, and came back and told the police, yeah, he kind of thought that was happening. Lisa S., member for 14 months, asked me, do you think Donna will turn on Wendi as fair play? I don't think so. I really don't. I don't think so for a couple of reasons. One is she spent an entire lifetime with her primary focus being on how to care for them and on doing things for them, maybe too much. If you believe what the prosecution says, then far too much. So I think there's that. It's I think it's bred into her that she would not do that. But plus, in addition to that, I think that it would be too late by then. And I'll even give a third reason, but it would be too late because of the fact that I don't think she's going to do it during trial. I think she would do it afterwards when she got to thinking about what was going to happen for the rest of her life. And I think it would be too late. I don't think they would let her change. And the third thing is, I just don't think it would be all that valuable to the state. They know they've got Donna, I think, in terms of their evidence, they've got what they've got. And I don't think she's going to give them anything credible or believable for Wendi after she's already testified at her trial that she's not guilty. Because she would have to do just what Katie Medbanwa did and say, yeah, I came in and told a jury I was innocent and I lied. That was all a lie. And then the defense in that case, Wendi's lawyer would say, well, look, you're looking at another jury, but this time you're telling the truth. And she would say, yes, that's right. This time I'm telling the truth. But last time I was lying. And that's just a tough argument to make. So all told, I don't think anybody is going to press her for that. The weaker link might be Charlie, but it doesn't really appear that that's something in the cards either. So I don't think that will happen, but we will find out, right? It seems to be a long running case, doesn't it? 11 years since Dan Markel was shot, 2014. Jennifer asked about the jailhouse informants. We do know and whether they got a reduction in sentence. We know from a brief filed by the defense shortly before trial that one of them did get, according to the defense, a reduced sentence. They got probation reinstated. When they had violated probation and it was looking like multiple years, they got probation back. So the answer is yes for one. That was the only one that was detailed. We don't know about the second one. CJ asking, I just started watching this case this year. What happened to all of Charlie's assets since his conviction, his house and dental business, etc.? He had sold the dental business back to his dad, I think. So his dad owned it. His house went on the market and he sold his, he did actually sell the house, I believe. I believe that's done. But as far as what happened to the assets when they got turned into cash and stuff, I would assume Harvey is in charge of that and that Harvey is in charge of using them. One of the things that had been important when Donna was talking to Charlie on the phone in those jail calls, they really wanted to take care of Charlie's son. He had a young son, I think 2 at the time that Charlie went into prison anyway. And that the 2-year-old would need assets and things to provide for him. So I imagine that between that and paying lawyers, that's where a lot of the assets went. He ran a business where he himself personally went to place as a periodontist. So he would come in and treat patients for this doctor and then for that doctor and this doctor or dentist. And so I think it would be hard to sell that. You would just have to have somebody who was the periodontist would actually do the exact same thing. So I don't know that it was really something that was easily sold. Is Donna's husband on the witness list? Texas Two Pugs asked me an interesting question. I do not remember him being read off as being on the witness list. So I'm thinking no. Jan Shore wants to know if Harvey will judge our banana bread contest. Since we did have the great honor of having Lori Vallow Daybell's brother judge our green chili chicken enchilada contest. But I'm betting no on that. That is just going to be a no. And so I don't think Harvey will do that for us. We will find out. But I think we are going to need a banana bread contest. The reason banana bread came in was that Donna supposedly prepared banana bread for Dan Markel. This was one of the things Wendi said proved that Donna and Dan Markel didn't really have that bad a relationship. It might sound like it since Dan filed that motion asking that she not be allowed to have unsupervised visits with the kids, but that was just legal stuff. That was just people fighting over legal stuff. Really, they were good friends. He asked Donna to babysit for him, and he also asked or accepted her gift of banana bread. It was all just the kind of stuff that gets filed legally. It wasn't anything that was real. All right. What could be a realistic sentence reduction for Katie McBanowa? In my opinion, Julia H. asked. Julia, I don't think they're going to give her a reduction. She did this without an attorney and without any promise, and it worked out very poorly. It did not go well at all. So I don't know. My thought is they're not going to offer her anything. They don't have to, and I'm not sure it was worth it. So that's just sort of a thought. All right, where were we? We were at Lisa. Well, thank you. Lisa S. is thanking the mods, and for me, thank you for bringing the case. It is such a tragedy for the Markel family. And one of the worst parts of it is that their relationship with their grandchildren was utterly broken. And they've seen the children only once. And it was really heartbreaking to hear in the jail call, Donna say, yeah, well, they only tried to come see the kid, for like an hour. And then the mother of Dan Markel, Ruth Markel, went off to do her book signing, because you knew that really was unfair. So unfair to the extent that the Markels pushed and fought for legislation in Florida for grandparents to be allowed to see their kids. I am sure it was horribly awkward for them to get to see their children just for a brief time, and they probably didn't want to make it any more unpleasant on the children. And I just thought that was very harsh judgment by Donna. I think it is indeed extremely sad. All right. And also, I want to say a special thanks to our mods, and particularly, I know poor Marlon has been on since the very beginning. I'm very grateful to him. This is a big task. I mean, I was worried about being on all this time. And in fact, I am running out of steam, just as I feared, because it's getting late and we have not heard from the court in a while. So this is like the hardest part of all, right? When you don't have necessarily anybody anybody to react to. So we're just talking about the case in general. But thank you, Lisa S. I appreciate that very much. And thank you to Marlon and to Mama Pinks, our mods. All right. I have to hit the play button. Have I messed up? I don't think so. I'm all the way at the end. I think we're good. Let me go down to the bottom.
Miss Lee, you're good at this moment.
Okay. Okay. Thank you. That was very scary. Okay. Thank you. I appreciate that. All right. Okay. So I'm looking for questions from what is the bump? Megan Jordan asks. Oh, you have so much to look forward to, Megan. Super interesting. You will be absolutely fascinated by the bump. The bump was an effort by law enforcement to figure out and to get the parties to basically admit what they had done. without actually coming forward and admitting it. It happened a good while after the murder had happened. And law enforcement believed they knew who had done it. They believed from wiretaps and things they had that Donna and Charlie, Donna would talk to Charlie, Charlie talked to Katie, his girlfriend, Katie hired her ex, Sigfredo Garcia, and he hired his friend Luis Rivera. And it's kind of a chain like that. And they believed that they could maybe force people to start talking about it. And now that they had wire capabilities and were able to hear what they were saying, they could get some evidence against them. And that's what they did. So they started with Donna because they believed the only way it would go all the way down the chain is if they started with Donna. And so they had somebody come up to her who was playing a gang member. At least that was the role he was cast in. In one of his testimonies, he called himself a Latin Kings gang member. He said that was his role. And he came up to her and said, "We know you took care of Katie and Sigfredo, and now you need to take care of Luis Rivera." They use their nicknames for that. And now you need to take care of somebody else. We know you took care of the other two. Here is, you need to deal with this. And they demanded $5,000. Well, sure enough, Donna calls Charlie and they have this really cryptic call. "Well, there was something that involves the two of us and we need to talk about it, but not on the phone." And they get together privately. There's no information about what that was. And then because that part wasn't recorded, but then Charlie goes and meets with Katie. And they meet out at a restaurant. Well, law enforcement is there and they're there with a recording device. And they recorded this conversation between Katie and Charlie. And in this course of this conversation, Katie and Charlie actually ended up discussing what had happened. There's obviously Charlie and Donna say, "Yeah, this was not a confession." State says, "Yeah, this was definitely a confession. This was you talking about exactly what happened." It was super hard to hear. One of the reasons apparently that they delayed in prosecuting was because this tape was so incredibly hard to hear, but they got a transcript, they got an enhanced audio, and that will be played at trial for the jury. And the initial contact with Donna is called the bump. They're trying to start something up. And then we watch the progression of that with the wiretaps and with the video and audio from the restaurant. There was also a recording of Charlie talking to Harvey, but that really didn't come through. You can hear just a tiny bit, but for the most part, they seem to notice the person next to them and be suspicious of him. Oh, looks like things are moving. I don't hear any noise yet, but it looks like, whoa, it looks like somebody is thinking about getting started anyway.
That has been excused at this point. You will be free to collect your things and you will not have to return at any other point during this process. So, let me allow the court before you get so. Madam Court Reporter, sorry to get ahead of you. At this time, I'm going to announce the numbers that have been excused, and you will not need to return for any further jury service in this matter. We give you our sincere thanks for honoring your summons and participating thus far. Juror 24, you are excused. Juror 22, you are excused. Juror 6, you are excused. Juror 7, you are excused. Juror 8, you are excused. Juror 9, you are excused. Juror 12, you are excused. And Juror 26, you are excused. Watch your microphone. Juror 19, you are excused. And Juror 16, you are excused. We are also going to reconfigure the box at this point as well. Juror 5, please shift down next to Juror 2. Juror 23, take the seat to the left of Juror 5. Juror 11, take the seat next to Juror 23. Juror 13, please come down to the first row and sit next to Juror 11. Juror 14, please take the last seat on the first row. Juror 17, please shift down to take the seat on the second row closest to the wall. On the second row. Yep, that's it. Juror 18, please take the seat next to Juror 17 on the second row. Juror 20, please take the seat next to Juror 18. Juror 25, please take the seat next to Juror 20. When you hear your number, please walk up and take the first available seat. Juror 27. Juror 28. Juror 29. Last for the second row, Juror 30.
Count 15 right there. Which would be 12 plus 3 alternates. So I'm
The
not
seat closest to the wall on the third row, Juror 31. Juror 32 to follow.
They haven't done strikes yet.
Juror 33 after that. Once you are seated on the third row, if you can hold up your paddles so I can ensure you're in the right positions. 31 closest to the wall, 32 next to her, thank you, and 33 right there. Juror 34, please come up as well. Juror 35. And Juror 36. It will be another few minutes before we resume. If anyone needs to use the restroom, please do so at this time or stretch your legs. We will get started as quickly as possible. Once again, you are not to speak to each other or discuss this case while we are still going through this process. We will resume in a few minutes.
All right. I admit to being very confused. I don't understand. I count 15 plus 6, 21, who were seated on rows 1, 2, and 3. That's not enough for 10 strikes. Well, somebody said, are there going to be 6 jurors? Would that be? There's no way there's going to be 6 jurors for a murder trial, is there? That would be 26 plus 3 would be 29. No, that doesn't add up either. I am not getting that. I don't know. I don't know. I am confused about where we are in the process. I think that's too many. If I counted right, that seems too many to be actually starting the trial. I don't think he means opening statements. I think he means strikes, but I thought they had 10, unless maybe they've used some and now they're doing a little bit more interrogation. I've never heard of that. I don't have any ideas. Does anyone know? I'll check in the chat. Maybe someone knows. Florida 6 jurors even for murder? Wow. That is shocking to me, but not impossible. I had 6 jurors one time on a case. I hated it. I thought it was really terrible. Every other time I had 12. So that was a one-time experience for me. I did not like it. 6 alternates. Thank you. It was a good test run. Guess this is the seating of the jury. I know it sounded like it, right? Like we're going to start opening in just a little bit. That sounded like it, but why are there 21 people there? I remain confused. When not a death penalty case, it can be 6. Absolutely fascinating. Okay, I hate that. My one experience, I hated that. I thought it wasn't enough. I just didn't feel like it was the same experience. I felt like the ability of one person to sort of over the jury was greater because there were so few of them. And I thought that it wasn't you didn't get the same robust discussion in a jury. Just my opinion. But that could be because I lost that case, right? That's why I think that. But I did feel like it made a difference. Sarah Boone had 6. Well, I'll be darned. Okay, so it's very possible. Maybe that's the deal in Florida. Mr. Consuer is arguing 12 in Florida. I thought I heard him say 12, but I can't say I know the answer to that for sure. We will find out shortly. And I know he told them they would have 10 strikes each. So either they don't have 10 strikes or they've already used them up or something that's happened that we don't get. Or they're just going to have one heck of a lot of alternates, like a lot of alternates. Who knows? All right. Well, let's talk a little bit more about the case. Put some more questions in. What's the best way to get out of jury duty? Fina asked me. Asking for a friend. Fina, that cannot possibly be what you're asking me. But I think that somebody like you would be the ideal person to have on a jury because you really care about it. You actually are interested in it. You would want to reach the right answer. You would want to know the truth. So you are actually the ideal person. So I hope that you won't just ask for your friend. I'm sure any friend of yours is also going to be an excellent juror. So, but since your friend wants to get out, I think the thing most attorneys look for is if they believe someone is not going to be fair to their client. So if you're willing to say things that suggest that, then most juries don't have a choice but to feel like you wouldn't be fair and they have to do something, either ask the judge to remove you or in your, if they feel strongly enough about it, remove you from the jury. But I am sure they need somebody just like you, Vina. I mean, just like your friend. CJ, Donna much for her sunshines, it's like she called her grandsons, to be close to her. How often has she seen them since she was arrested? I wondered about that too. I think it can't be very often because Wendi's family has moved to another state. It's a little unclear whether it's Texas or Colorado or where exactly, but nonetheless, I don't think they're going to the jail. I don't think that that's something that's happened. And she even said when she was talking to Charlie in the jail after Charlie was convicted, she started talking about how she asked Wendi to come over, and it was kind of clear that there wasn't the same relationship that there had been, and that maybe there was some estrangement there. Obviously, I mean, she had seen Wendi just a matter of days before, so it wasn't completely estranged, but she made statements like, we used to be important to them because we did all this babysitting and now we aren't needed anymore. So I think that things have begun to change as the children got older. 12 plus 6 alternates. 6. Well, that wouldn't be. Did I write my numbers down? I have 21, but I think 6 alternates is great. I am completely in favor of large numbers of alternates because I think the worst thing that can happen is you get to the end of a trial and you're short a juror. What an incredible waste that is for absolutely everyone. So I am all in favor of that. Maybe I wrote down my numbers wrong. I got 21, but that would make sense. 12 plus 6 jurors, or 6 plus lots of them. In any event, we're getting really close, and I think we're going to have opening statements shortly, or at least in the morning. Yeah, I wonder, Canoni's corrupt court is asking maybe they use their strikes at sidebar. Yes, very possible. Typically, you do that all at once because you go back and forth. So the first side will say, okay, we strike number 2. And so number 2 is off. Maybe both sides wanted number 2 off. Maybe number 2 was a problem and for both sides, but for different reasons. And in that case, you're kind of playing a game of chicken till the end, hoping, because it's not just which ones you strike, but the order you strike them in. So you want to arrange yours so that the ones that the other side might have trouble with. So let's say you're the state and you think the defense might have trouble with 18 and 20. You want to make them your last strikes, because what you're hoping is that even though you really want to get rid of 18 and 20, maybe the defense will too. And maybe they'll go earlier and you won't have to use up a strike for 18 and 20. You'll be able to use up your strike for somebody else because the defense already struck them. So it's all a lot of strategy that goes on around that kind of thing. And that's definitely something that normally you do it all at once and you go back and forth. So I am unclear, but about the number. Jan Shore asked me a question. Did it seem to you that it might be odd for Charlie and Donna to know when the murder would occur? Because Dan had the kids. Would Wendi okay it? He did have the kids, but it was also known to them, prosecution will argue, that they knew the kids were going to be dropped off and they were going to be going to school, daycare. They were not going to be at home. And in fact, Wendi knew that Dan Markel had gone to work out and now would be coming home and he would be by himself. The defense argues, why would they even take the risk of the chance that one of the kids came home with them or was there? They wouldn't do that. So that's a factual issue that we'll see debated during the trial. It's a great question. Heather is a new member. Welcome, Heather. That's fantastic. 9AB. 9AB. Did I get that right? Will you be doing an end of day summary for us who don't have the time available to watch the all-day proceedings? That is my hope. That is what I'm planning to do. Yes, an end-of-day summary at the end of each day, just talking about kind of what some of the highlights were and what happened during the day. So yes, I'm planning to do that. It won't be too long, and you can get a quick overview of that. But this is what I'm thinking, is that I will do it during the stream as opposed to separately as a separate video. Let me know your thoughts on that, if that's what you meant, 9AB. And Bart is asking me, why don't you take a break, Lee? We need you to last. That is, so, I mean, am I allowed to do that? Is that like cheating? I'm not really sure. Is this like one of those endurance things where if I leave, I lose? Not really sure how this works, having not done this before. I was thinking, am I allowed to do that? Or maybe everyone leaves if I do that. I'm not really sure. So I will try to find out more about that, Bart, because that does seem like a problem. I definitely think there has to be some period like at lunch, right? When people leave, doesn't that seem to be right? But I looked at a few and it didn't look to me like anyone ever left the screen. I thought these people are superhuman. How are they doing it? Or maybe they delete those parts afterwards. I definitely wondered about that. Thank you for your kind message though. And Bart, by the way, has been a member for 11 months. That's awesome. And Rue, what is your take on her husband, meaning Harvey, I think, meaning Donna's husband? So, we've gotten super mixed messages about Harvey. At the airport, when Donna was arrested,
our newly seated jurors, starting with 27 and going through 36, I'm going to need to ask you some of the same questions that were asked to the group earlier concerning your prior jury service, any connection to the attorneys or the defendant, and also some brief biographical data from you. Once we've accomplished this, the attorneys will each have an opportunity to speak with you as well. I am not going to reread the law to you concerning the presumption of innocence, the right to remain silent, and the burden of proof. The law is fixed. Nothing has changed with it. Does anyone have any questions concerning the law that was previously read for jurors 27 through 36? Please raise your paddles if you have a question as to what the court read. Very well. I'm now going to ask 27 through 36 as a group. Have any of you previously served on a jury? Please raise your paddles if you have. Juror 28, please tell us where and when you previously served on jury. Do you recall if it was a criminal or civil proceeding? Do you recall the charge or the type of case? Without telling us the verdict, did the jury reach a verdict? Were you the foreperson of that jury? Did anyone else have their paddle raised for having previously served as a
That's
juror?
the same questioning
No
you
other
did
paddles
with
are
the
being
earlier
raised in
panel.
response. As to the attorneys on this matter, are any of you, and I'm referring to jurors 27 through 36, related by blood or marriage to any of the attorneys, or do you know any of the attorneys that were previously introduced this morning? Right, no response has been given in the affirmative. Concerning the defendant, are any of you, 27 through 36, related by blood or marriage to the defendant, or do you know the defendant personally? Concerning the names of the potential witnesses that were read earlier today, as to 27 through 36, do any of you know the witnesses that were identified by the parties? And now I will go through your biographical information. Juror 27, what is your occupation or type of work?
Owner and operator of a online agency.
Right. You'll never get advertising better than this. Shout out that name. Go ahead, give us the name.
E-Vision Media Group. E-Vision Media Group.
What is your marital status?
Married.
What is your spouse's occupation if they work?
Physician assistant at Yahoo.
Do you have children?
Yes, 2.
And what are their ages and do they work?
22 and 12 for a 2-year-old does work. Full-time student at UCF and is working at student housing.
And the 12-year-old is just at home?
Is that
Yes, sir. How long have you lived in Leon County?
13 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement?
Close friends, yes.
Have you, any close friends or relatives, ever been charged with a crime?
Yes. My brother was indicted, federal indicted on fraud.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes. My aunt was murdered 17 years ago, and close friend of mine.
Thank you.
Close friend of mine was also murdered.
Juror 28, what is your occupation or type of work?
I'm retired, environmental manager,
What is your marital status?
widow.
Do you have any children?
Yes, sir. 26 on Sunday. Works for Civic Tech.
How long have you lived in Leon County?
About 21 years, sir.
Any close friends, neighbors, or relatives that work in law enforcement?
No, sir.
Have you, any close friends or relatives, ever been charged with a crime?
No, sir.
Have you, any close friends or any relatives, ever been a victim of a crime?
No, sir.
Thank you. Juror 29, what is your occupation or type of work?
Project manager for a civil engineering firm in town.
Right. Once again, no better free advertising than what you have right now.
DRFB,
What is your marital status?
married.
What is your spouse's occupation if they work?
She works with the Department of Health.
Do you have children?
Yes, 2, 8 and 12. They do not work.
Do they owe you money?
I'll be on them one day. No.
How long have you lived in Leon County?
All my life, 40 years.
Any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime?
Yes, close friend.
Have you, any close friends or relatives, ever been a victim of a crime?
My wife's uncle was shot and killed probably 10 years ago.
Right. Thank you. Juror 30. What is your occupation or type of work? If you can say that again, they could not hear you.
Employed, but I'm a social worker.
What is your marital status?
Single.
Do you have any children? How long have you lived in Leon County? Any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime? Have you, any close friends or relatives, ever been a victim of a crime?
My parents auto
Thank you. She said her parents' auto theft. For everyone on the panel, if you can remember to do this, please speak up and speak clearly so you can be heard. Juror 31. What is your occupation or type of work?
Data analyst, Department of Transportation.
What is your marital status?
Single.
Do you have any children?
No.
How long have you lived in Leon County?
A year, 8 months.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
My brother has DUI.
Have you, any close friends or relatives, ever been a victim of a crime? Thank you. Juror 32, what is your occupation or type of work?
I work part-time at a restaurant,
What is your marital status?
married.
What is your spouse's occupation if they work?
He's the owner of a restaurant in town.
Shout out that name.
Carab is attending.
Do you have any children?
Yes, sir, 2. I have a 17-year-old and an 8-year-old.
Right. Does your older child work?
He does not.
How long have you lived in Leon County?
8 years?
Any close friends, neighbors, or relatives that work in law enforcement?
Yes, sir, retired.
Have you, any close friends or relatives, ever been charged with a crime?
I have a brother that was charged with DUI.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes, we had a masked individual try to break into our home earlier this year.
Thank you. Juror 33, what is your occupation or type of work?
Deliver and install appliances.
What is your marital status?
Single.
Do you have any children?
1.
What is your child's age?
9.
I assume they don't work.
Nope.
How long have you lived in Leon County?
They are born.
Any close friends, neighbors, or relatives that work in law enforcement?
Yes.
Have you, any close friends, relatives, ever been charged with a crime?
Yes.
Have you, any close friends or relatives, ever been a victim of a crime?
Yes.
Thank you. Juror 34, what is your occupation or type of work?
I operate our 2 family-owned businesses for the record reporting and vouchers in Tallahassee.
What is your marital status?
Married.
What is your spouse's occupation if they work?
He is a law enforcement officer at the Florida Department of Law Enforcement.
Do you have children?
I do.
What are their ages and do they work?
16 and 13 and 18.
How long have you lived in Leon County?
36 years.
Do you have any close friends, neighbors, or relatives that work in law enforcement? Have you, any close friends or relatives, ever been charged with a crime? Have you, any close friends or relatives, ever been a victim of a crime? Thank you. Juror 35, what is your occupation or type of work? Delivery truck driver. What is your marital status?
Married.
What is your spouse's occupation if they work?
Customer service coordinator for a truck company.
Do you have children?
No.
How long have you lived in Leon County?
3 years.
Any close friends, neighbors, or relatives that work in law enforcement?
No.
Have you, any close friends or relatives, ever been charged with a crime?
No.
Have you, any close friends or relatives, ever been a victim of a crime?
No.
Thank you. Juror 36, what is your occupation or type of work?
I'm a fiscal specialist for the state of Florida. I actually work for People First.
You're not contagious, are you?
I hope not. It's
Go-
just
go-
on
go-
this cold air.
Go ahead and put that mask on then.
But I wanted y'all to hear me.
What is your marital status?
I'm single.
Do you have children?
I have one son, the age of 10.
And I assume he does not work.
No, sir.
How long have you lived in Leon County?
I would say I've been in Tallahassee for the last 17 years. Went back to Fort Pierce, Florida for a year or two for school, and then I came back.
Any close friends, neighbors, or relatives that work in law enforcement?
No, sir. My step grandfather was a state trooper. But he's retired. That's the only that I'm
Have you, any close friends or relatives, ever been charged with a crime?
Not me, thank you God. But yes, I had it. My dad, my sister, and my mom. This was years ago. I'll say back in 2007 was, 2004 was my dad, and then 2005 and 6, my sister was there.
Have you, any close friends or a relative, ever been a victim of a crime?
Not me, a friend. And that was basically, he was a minor, and I had to basically be summoned to vouch that someone
If you can repeat that, go ahead.
So it was I'm just say a friend of the family. I was subpoenaed because she was minor, and I witnessed her being abused, and I'll just put it that way.
Thank you. Once again, for our newly seated jurors, I am not going to read the jury instructions concerning the burden of proof, presumption of innocence, and the right to remain silent. These concepts are static, they are fixed. The law has not changed on these matters since we've started the process. Is the state ready to inquire?
So this is a second group that they're going to do all of the same things with. We did not start until after the prosecution had started. So you'll hear this time the entire set of questions from the prosecution, what they are.
Mr. Catherine Dugan, I'm representing the state of Florida in this case, along with Georgia Kappelman. I know y'all are hot.
This is the other prosecutor, not Georgia Kappelman. Be very interesting to see her style and contrast it with what both Josh Zellman for Donna Adelson as well as Georgia Kappelman for the prosecution did.
Tired, hungry. It's 5 o'clock. I'm going to try to be really quick. I want to go over just a couple of concepts with our new folks to see if y'all have any strong feelings about any of them. But if any of our original folks that are here in the first and second rows, if you have anything that you want to add, change your answers on, an idea that popped into your head, just raise your hand and let me know. All right, so Ms. Kappelman talked about reasonable doubt. The state's burden in a criminal case is we have to prove the case beyond a reasonable doubt. We have to prove a crime was committed and that Mrs. Adelson is a person who committed that crime. And we talked about the definition of reasonable doubt. It's not a forced doubt, something you're making yourself believe. It's not a speculative doubt or a possible doubt. We could all sit around and come up with maybe this happened, maybe that happened. The doubt that you're having has to be reasonable. Does everybody understand? Okay. And we talked about why it's beyond a reasonable doubt, because it's impossible unless you're a witness to be convinced beyond all possible doubt of anything. Okay. Hearing that though, do any of our new people feel that I understand what the burden is, but it should be higher than beyond a reasonable doubt? I would personally have to be convinced beyond all possible doubt in order to reach a conviction in a criminal case. Does anyone feel that way? First or second row or third row? Okay. And who decides whether the doubt you're having is reasonable to believe, given all the evidence in the case? Who decides that? You guys do, right? Okay. And you do that thinking back on everything you heard in the case, using a totality of the evidence that you heard. We had a couple of people in when the defense was asking questions that some of you mentioned, well, Mrs. Adelson, maybe she did something to be charged, but, and while I understand what you're saying, that's not something for you to consider in a criminal trial. The law is that she's innocent until proven guilty, and that it's the state's burden to prove the charges beyond any reasonable doubt to you all through the evidence you hear from the witness stand. Does that make sense to everybody? Okay, so that's something that should not be considered. The evidence in the case and whether it meets that burden is what y'all consider, okay? And speaking of evidence, if you're picked as a juror, your job is going to be to focus on that evidence. That could be physical evidence, like a picture you can hold, or it could be testimonial evidence. That's going to be a lot of what y'all are hearing. People are going to be coming up to the witness stand that may have knowledge or information about the case, or people who investigated the case are going to be listening to the words that they say, watching their body language, so that you all can determine the facts of the case and what happened here. And then you're going to apply what you've heard to the law Judge Everett gives you and render a verdict. One thing that Ms. Kappelman touched on is that it's not the jury's job to decide the sentence. Knowing that, though, is there anybody who feels that I just would not be able to reach a verdict if I didn't know what the sentence is going to be? Anybody on the first row or second row or third row? Okay. Another thing I thought about is, obviously this is a first-degree murder case. And when you hear first-degree murder and you talk about possible sentencing, sometimes people think death penalty. That's not something that's on the table in this case, or could ever be a possible sentence here. So just want to make that clear for everyone when we're talking about that, okay? And I didn't see anyone's raised hands. So everyone is okay leaving this sentence up to the law and to Judge Everett, and you all decide the verdict, right? Okay. We talked about the principal's instruction. You guys listed the person who did the shooting, then you can be considered a principal and treated as if you were the person who pulled the trigger and did the shooting. Does that make sense? All right. Now, okay, so I have another example that if you are, let's say during a football game, if a quarterback throws a pass to a wide receiver, okay, the wide receiver catches it in the end zone, it's a touchdown. If scoring a touchdown is a crime, who is a principal to that touchdown? What do y'all think? Let me see. What do you think, Ms. Tolbert?
After what you just said, I'm confused, but I will say, I guess we got to the ball.
Wide receiver?
I want you to notice how skilled that was, what she just did right there, because you may have noticed when Josh Selman asked his questions, he was like number 32, number 51, whatever their numbers were, he called them. She said, miss, and used the person's name and talked to her and said, what is your opinion about this? That is, that requires a lot of organization, but it's a very useful technique by attorneys.
Catch the ball to make that touchdown happen. He wants it. He's running, trying to catch it.
I don't hear sound. As far as I know, nothing has changed.
The person blocking. Okay. Okay. I gotcha. Okay, so if the person blocking is doing an act of blocking so that the touchdown can be scored, and he wants that touchdown to be scored, is he a principal? Okay. Does everybody agree with Ms. Tolbert there?
Sound out again. We get a transcript of it though. Interesting. They may be having technical difficulty. We'll just let it go for a minute. So one of the things, why is she asking those questions? You may be wondering, why is she asking all this about a football and who's the person who's responsible? Is it the passer? Is it the person who blocked for them? Is it the person in the end zone? What she's trying to do is make a point to the jury that Donna Adelson may not have wielded a gun outside Dan Markel's car. She may not have shot Dan Markel. She may not have even been in Tallahassee when Dan Markel was shot. But if she did some of the things headed toward that, then she can be responsible. She might be the passer instead of the person who made the touchdown. She might be the blocker instead of the person who made the touchdown, but she's still someone who can be convicted. All of that is relevant and important. Does anyone, let's see if that fixes it. I am hearing nothing. Let's see what some of our other possible feeds have. I'm going to look around. No, I see it showing just that. Maybe, why would they? I'm curious why they would do that. I don't see any reason to cut the feed. These are the generic questions. Okay, let's see if we can switch to this. Because you can still see. Let me try removing that. I'm sure this will not be completely problem-free, but we will do the best that we can. They're having trouble too, it sounds like, with sound. Let's see. I'm going to stop the screen share. I'm going to share the screen. And I don't hear the sound for here either.
You don't know?
There we go.
Okay. Is he doing an act or saying a word to assist that touchdown?
The person blocking or the person throwing the ball?
The person blocking.
I'm just saying that was pretty good.
Okay. Okay. I gotcha. Okay, so if the person blocking is doing an act of blocking so that the touchdown can be scored, and he wants that touchdown to be scored, is he a principal? Okay. Does everybody agree with Ms. Tolbert there? Oh, she's...
Okay. What may be happening is that the prosecutor is mentioning names of jurors and they're trying to catch that on the court feed. So she mentions a name and they mute it and pull that out. And then they try to go back. And that may be what's happening, kind of a back and forth around that while they try to figure out that. It is a super effective technique for an attorney to be able to use a person's name because it's so much more dynamic a connection. If you can actually use their name and look at them and talk to them, obviously that's better than calling someone by a number. But it also obviously has some implications because they're trying not to broadcast that. And yet it's being used by the attorney for good reason and effectively, but it can create a problem. So I think that's what the issue is. And they don't know how to, they're trying to deal with that. So that would be my guess. And that's why we've seen it happen on 2 different channels. So 2 different broadcasts are having this. So I think that's it as to why it's happening. So, well, let's go ahead and talk a little bit which they may come back with the feed or they may not come back with the feed. They may feel like during the course of the prosecutions, they're not going to be able to do that because they may be worried that what's happening, and I'll go ahead and make this a little bigger while we're here, but they may be concerned that what's happening here is going to violate what they've told the judge they're going to do. So that's my guess, is that they're having some difficulties with that. So we can head back over while we wait for that to our, ironically, using the numbers probably would have prevented that, and they could have done it. It wouldn't have been as effective for the relationship with the jurors, but it would have been better in terms of the feed from the court. It would have been a little easier. Oh, thank you, Nancy. I appreciate it. Thank you. Yes, don't forget to like the live stream. I would really appreciate that. Nancy, thank you for mentioning that. Please do hit the like button. I would greatly appreciate that. Start with questions down here because I'll never find where we were before. CJ asked me what would happen with this trial should Donna have a serious medical emergency. Would the trial continue without her, be put on hold, or is it up to the judge? Well, it would really depend on what happened. For example, let's say Donna had some illness. Well, let's even think back to Lori Vallow-Daybell. Remember how she got ill and there was a slight delay, but then the judge is like, you're not really sick, get down. Had her evaluated by prison personnel so they could determine, was she really sick, and give him an answer on that. So let's say she had a truly serious medical emergency and was going to be out for a while, they would almost certainly halt the trial. And if they had to, they would completely dismiss this jury. It hasn't even formed yet, but they would stop proceedings here and then schedule trial again. I don't think they would try to push through without her because she has the right to confront the witnesses against her, and she wouldn't be allowed to do that if she's, say, in the hospital. But they would hold it for a while. I mean, they called all these people in. It's be very awkward because of scheduling. These people have been told, here's how long you would need to be here. And it's about 3 weeks. They haven't been told, and it will start 3 weeks from now and go for 3 more weeks. Maybe they aren't available those 3 weeks. So there would have to be some negotiation and figuring out exactly what to do in terms of talking to figuring out just how it would work. So speaking of which, I want to talk a little bit more about the using the jurors' names, because it is a technique that a lot of attorneys like to do. And sometimes it almost crosses into the point at which it's conversational. You know, it's not just asking a question, it's a conversation between the person asking the question, the prosecutor or the defense lawyer, and the person answering the question. And that's the ideal place where it gets, because you get better answers that way, and people are more likely to be telling you what exactly they think or what their real rationale for something is, if they're getting that back and forth. So it is, like I say, very effective. All right, so let's see. A question to poll my audience is, how many people have known women who tried to control their grandchildren's lives, not to the point of murder? Yeah, well, certainly not in this audience. I'm certain that absolutely no one in the audience for this channel has done such a thing. But we will. I'll have to be putting together some polls. I do need to do that. Thank you, Creative Chaos. That's a good idea, and I'm going to put some together. Annie believes that Donna is the coach or play caller in the football analogy. Maybe so. That would kind of make sense. And would they be responsible? So the prosecutor is really trying to make the point that you can't just stop right here. You have to move backwards, and you don't just look at the person who crossed into the end zone. You look at all the people who contributed to that, and they're all responsible under the law. So that's the analogy she's trying to draw, the point she's trying to make. All right. Look at that. I love this comment from Sassy Ladybug. Wow, so many people still in here since almost the live start. This community rocks. I totally agree with that. Thank you so much. I completely and totally agree with you. Pinky saying, have you already named the first 5 in the chat? Asking for a friend. Well, I did not, Pinky. I was so discombobulated getting on. It was really a wreck. I haven't slept in like, I don't know why. I'm not sure why this seemed entirely different, like nothing I'd ever done before. Trying to get it to the top. Boy, there are a lot. Y'all have been talking a lot. There have been a lot of comments. I'm still not up at the top. I don't know if I can get that far, actually, Pinky. I may just have to say a blanket thank you. It looks like it's pretty hard. It just keeps going. Wow. Y'all are talkative folks. I like that. That's actually the goal. Pinky, I don't know that I can do that. I can get to, oh wait, no, that wasn't it either. It says I'm near the top, but it just keeps going. Well, we'll keep talking while I just run my finger over here toward the top. All right, one of the really difficult concepts for the jury is going to be the question of principle. The who is responsible be another way to put it. And that's what she has focused so much of her questions around, as well as the defense too. No, I'm not all the way back yet. Wow. I don't think I can do it, Pinky. I have to hope that I catch that earlier next time. I think that it's just gone. I am really sorry about that. But I would like to call out Pinky for being one of the first 5 in today's chat. It just has to be Pinky, right? So thank you for the comment, and I'll try to do better next time. I'm sorry I missed that. All right. Let's see, where were we? Okay, so I'm looking for the question marks. Noni, after they commit Donna, do you think they'll go for Wendi? Great question, and I don't know the answer. I think Georgia is all behind it. She's the prosecutor, Georgia Kappelman. I think she believes firmly that Wendi is involved. I think she believes Wendi is a co-conspirator. She said that before. It's not like she's hidden that belief, but she has never arrested or charged Wendi Adelson. So there's something standing in the way, whether it be lack of evidence or just strategic timing. It hasn't happened yet. So I don't know whether it will happen or not. It's not only up to Georgia either. As we talked about a little earlier, there will be multiple layers that will probably have to approve that. So it's not going to be just Georgia making the decision. Usually there would be input also from people who are responsible for her office and that kind of thing. So let's see, other questions. Pinky was not only sure she was in the first 5, but she was first. Double thank you to Pinky. All right, let's see. Irish Amy, do you think the prosecutor or the defense's approach to the jury questions has been more effective? I think the prosecutors are more effective. It's not that the defense did a bad job, because I think he did what he needed to do. But the conversation and the conversational style with the other 2 prosecutors has been very effective. I think it's warm, engaging. I think it pulls the jurors in, the use of their names, all of those things. So I think that that's been really effective. It's not that the defense did a bad job. It was just less conversational, but it was also very aimed at exactly what he needed to do. It was an excellent voir dire. There's nothing negative I have to say about it. Other than that, he did ask them some really hard questions, like put them on the spot, like, whoa, I don't know that. I think that's a legal concept, but can I phone a friend? As far as the questions he was asking, though, right on target for exactly what he needed to ask. He was really hitting each one of those points. What is it I need to think about before you hear this case? Great job in terms of what's the burden of proof? What does that mean? What does it mean in terms of splitting my client from, say, Charlie? Can you do that? Do you understand that concept that he could be guilty? You could even decide he's not guilty, but know he's in prison, and that's irrelevant. Your only question is whether or not my client, Donna Adelson, needs to be in prison. And it could be divided in that direction, like completely separated. Do you get that? He asked, I thought, great questions. why don't we go ahead and do this? I'm going to do my kind of run through summary of what's happened today. I don't have the end of the trial yet, so I can't tell you what the judge is thinking in terms of tomorrow. My plan will be to we'll see. Please turn your notifications on. I will be sending out a post and I will give you more information if any of this changes. But my thinking is I'm going to go live first thing in the morning so that to make sure we don't miss opening statements. I want to make sure that we hear that. And I don't know what time it'll be. If we get an exact time from the court, we can be a little more precise on that. What we've had happen today, it's been jury selection. This was up until recently, up until this last little bit, this was a public segment of the jury selection. When they first got to trial, the judge asked some overview questions about where maybe the person didn't even live in Leon County and they weren't even eligible to serve, or maybe there was some reason why they couldn't be there, like they were taking care of a child under 6, or they were the sole caregiver for an elderly person. Those are reasons that someone might be excused. So he asked those general questions. Then they moved into individual voir dire, and they went into the private conference room. The attorney sat around and asked individual questions. It wasn't broadcast. We don't really know exactly what was asked in there. We do know, based on the questions that the judge read out saying he would be asking, that they were going to be focused on what everybody knew about the case in advance. Like, did you know anything about this case? Do you have a firm opinion? Could you change that opinion? What information have you had? Since Tallahassee is a moderately, I think it has about 200,000 people, so it's by no means a small place, but it's not huge. But on the other hand, it's transient, so you get a lot of students in and out. So there's a good chance that people living locally would have heard about this, but it's older, 11 years old, and a lot of the people living there would be students or people moving through who haven't been there for 11 years. So there were obviously opportunities to find people who knew nothing about the case and people who knew very little about it. And then last bit would be people who knew something about it, but could still be fair and could set that aside. I talked last night about my personal opinion about that as a question, but it's entirely legal and done pretty much everywhere. So we went through, they did that individual voir dire over the last couple of days. Today, they moved into the public section, which is the more traditional voir dire that you would normally see in trials. There isn't always that individual section of it. And in this, the judge will ask a few questions, and then the prosecutor gets up and asks a back and forth, and so does the defense. Not every court does it that way, but the majority of courts do it pretty similarly. And the goal of the attorneys when they do that is to get everybody talking, to find out more. And they do that because they're trying to figure out which of these jurors would not be fair for my client. They might be lovely people, but there's something in the way where I don't think they could fairly judge my client, or just I don't think they would rule in favor of my client. And that's what they're looking for. There are a couple of different ways that they might find that. The first way would that they might be able to eliminate somebody. I mean, the first way would be they may be able to find out information where they could take it to the judge and say, look at what this person said. Clearly, they can't be fair. It's pretty obvious that they would not be able to be fair. And you, judge, should strike this person for cause. There's a reason to strike this person. I'm guessing that at this stage, they've already used some of those strikes up, that they have been through the first set of jurors and they didn't reach enough, that they still have some strikes left. They still have some jurors left to be seated. And so that's what's happening next. Then that's the side that they can mark out. Oh, he was about to name. I must have asked them to move them.
Good evening. What I'm trying to do is go through my outline to pick out the key topics I want to address so that we're not here for another hour, hour and a half. Figured that you guys have other places you would like to be at this hour, as do we. Did everyone hear when I discussed the concept of implicit bias earlier?
Yes.
Yes? You all agree that you will make a conscious effort to be aware of that if you were selected as a juror and in your deliberations. Okay. By a show of hands for the new ones, anyone in a leadership position? Okay, we got quite a few. Mr. Oh, I'm sorry. Okay. Do you have staff that work with you?
Yes, I have 2 staff that work with me right now. But
Okay.
I've been an owner operator for the last 13 years, so I've had a staff of 10 at times.
Okay. How do you, when you're a leader, try to draw out other people so that everyone is involved in a conversation?
You want to set up a process or a system to do that. You want to set up a process or system to do that. I think it's the easiest way out front to get everybody involved and kind of let everybody know. Let's have a system where we delegate, everybody has a time to speak or give it a thought, and then we can let them come back.
And so, as a leader in that type of scenario, you would make sure that everyone's voice is heard.
Yes, absolutely.
Even the ones that don't really want to speak.
Everybody has.
Everyone has to be heard.
Correct.
Okay. Ma'am, what was your number? No. Yeah, 28. Thank you. I didn't have it written down properly. You raised your hand when I asked about leadership position. How do you avoid a misunderstanding?
To clarify, I'm hired, that's what
Congratulations.
I said.
When you were working, and it would apply now too, how do you avoid misunderstandings when you're in a group setting?
Repeating what somebody said, making sure there's active listening and communication. And that people making sure that they repeat things that said or repeat the question.
So in other words, not just listening, but comprehending. Does everyone agree with that? Yes. For those new individuals, would you agree that we're all human, we make mistakes? That includes law enforcement, includes the state. Number 32, you said that your family was recently victim of a home invasion type of incident?
Yes, sir.
I'm sorry?
Yes, sir.
Is that something that, I assume that you all were home?
We were not. We were actually out of town and our cameras picked it up. So we called law enforcement as soon as we saw it. And they came out and did their thing.
People arrested?
Yes.
Well, I'm glad that you guys weren't home.
Yes, me too.
Did you do anything, heighten security after that?
I mean, we already had things in place for security, so we haven't taken extra measures on top of what we already have.
Is that something that you think about on any sort of regular basis?
Sure, yeah, of course.
Now, would that or could that be something that you would think about if you were selected as a juror in this case?
No, I think they're two different situations.
It is pretty different.
Number 29. Said that your uncle was murdered.
My wife's.
Your wife's uncle, I'm sorry. How long ago was that?
About 2 years.
10 years? Was that here?
In Greenville.
Greenville.
30 minutes away east.
Were you all close to him?
I guess she was because it was her uncle, but not really. He was kind of in and out as far as just an odd uncle. I don't know. You know, he was there, but I don't know that he was like super close. But the whole incident was a shock. But I mean, I don't know that I never really knew him to know like if he was involved, if it was he placed himself in the situation, or whether it was just wrong place, wrong time. I don't really know the details.
So you weren't very close to him, so this isn't something that you would carry into the jury room. Okay. Number 27, I'm gonna come back to you on that. You had two family members that were murdered. How long ago was that?
It's actually closer to 20 years ago.
And your friend?
6 years ago.
You still think about him?
Yes, a close friend, very much so. I was not never, but we were close, but my friend, we were actually best friends.
Sorry.
Yeah.
Obviously, my client is charged with murder. And so you could anticipate that I'd be concerned that your experience with your friend and your aunt could impact how you feel in this case. When the state asked you about that, you said, I don't think it will bleed over. You don't think that it'll influence you. I don't think is kind of equivocal.
Yeah, being candid, honest at that point, because I can't say right away that, it's absolutely wrong. But I don't carry that bias into the court. I will get the evidence case.
But as you sit here, you can't say to me, Mr. Zellman, I'm not going to think about that at all.
Yeah, I'm not sure.
Okay. Thank you.
I'm sorry, you said those not.
Yeah.
Now, and you've heard the state say this a few times, and we probably addressed it when we were back in individual voir dire. The court's instruction is going to be that you can only rely on the evidence that's presented in court. But as you sit here, you can't tell me that I'm not going to think about that.
No, I can say that I would absolutely only rely on evidence of the case. When you're asking about thinking about the past cases of my aunt, past incidents of my aunt, our best friend, and just as a human being, as the case goes on, if I saw pictures or images or something, I may have a thought about those two.
And that actually brings up a good point, sir. This is a murder case, there are going to be pictures from the crime scene, from the medical examiner. For those new prospective jurors, are you comfortable having to see some of those pictures in this case? Is anyone uncomfortable? If I can get a show of hands. Not that we like having to do this, but is anyone uncomfortable? No hands. Thank you. I'm going to go through briefly some of the hypotheticals that I used to discuss the burden of proof. It's, beyond a reasonable doubt. Did everyone hear the bank robbery hypothetical that I addressed earlier?
Yes.
It's always
Number 33. So with that hypothetical, the first one, where the witnesses to the bank robbery identify the defendant. The surveillance video depicts the defendant. And the defense attorney gets up in closing argument and says, "State didn't prove it wasn't my client's twin brother." What kind of doubt is that creating or raising? You remember what we discussed earlier? What was discussed earlier with the prior panel? What kind of doubt did we discuss? Anyone else remember? Number 27. And speculative doubt is not what?
Let me stop for a minute and give you kind of my best guess. My best guess is, as far as whether they'll do opening statements tomorrow, is that they will do opening statements. They wanted to move fairly quickly from doing this sort of voir dire of the jury and the questioning of the jury, selection of the jury. I think the judge, everyone thought they were going to get done today. They're clearly not done today. And that may move a little bit into tomorrow. It may bleed over, but I think that there will probably be enough time tomorrow that they will get to opening statements. The plan all along has been that they would get to it. Do we know that for sure? Nope. We are still waiting to find out, but that's just my theory.
Has anyone ever had a knee-jerk reaction? jump to conclusions. Okay, I'm going to click on number 30.
Let's go through some
You
of
ever jumped to a conclusion before? Realized that you were wrong? In that moment, did you say something that you may have regretted?
I think
You
this-
realized that you were wrong.
I think that has to do with Donna's statements about the kids, about ways to get at Dan Markel. I think they'd like to say, you know, look, she was just talking. She was blowing off steam. She didn't really hate him, and she certainly would never have murdered him. I think that's her.
Everyone else have similar circumstances happen? Just let me know.
The attorneys are wearing down too here at the end, trying to decide, okay, what do we have to ask? And I think they're probably asking each other, who on this chart did we really need to say something so we could argue they should be struck for cause, or at least explain why we struck the person and why it was not some illegitimate reason. It was a reason that made sense and that we could argue.
Number 32, you indicated earlier that you had a family member who's retired law enforcement?
Yes, sir.
And who is that?
My husband's uncle is retired with Leon County Sheriff's Department and
I'm sorry.
and also worked for the governor.
Okay. You close with that individual?
Yes.
Do you hold is their opinion of you important to you?
Sure, yes.
Now, would you have any concern if you were selected as a juror in this case, heard all the evidence, and returned a verdict of not guilty, how your husband's uncle would feel?
No.
Okay, thank you. Same question for number 34. No concern? It's your husband. Number
You see how he came back out and immediately went to specific jurors and asked about law enforcement. That's a big issue for Donna's side. Charlie and Donna in their jail phone calls talked about the fact that law enforcement personnel or people who were related to them were allowed on his jury, and he felt like they could not be fair to him. He felt like they would be biased on the side of law enforcement and against him.
14? No, 20. Sorry, 29. Yeah, my numbers are all messed up. You have friends or family law enforcement?
Brother-in-law worked for FDIC. I know you, at least one, who's mine retired, law enforcement.
Any concern about what they would think of you if you found somebody not guilty, even of murder?
Correct, yes, sir.
Thank you. Number 27, you had?
Yeah, it's several friends, but several friends, yeah, I would call back in Sarasota County. But no concern.
You're not concerned?
No.
Okay. Anyone else have their hand or paddle raised to law enforcement? Did we talk to you about that? Well, we can't talk to you about it again, so. But specific as to the new people, sorry. As to the new people, anyone been divorced? No divorces for the new people? Good for you. I haven't been so lucky. Let's see. For the new people, this, as I said earlier for the prior panel, it's not something I would normally ask, and I apologize if it's offensive anyway. But just for those new people, can I see a raise of hands of anyone who has any knowledge of Judaism? There's certain events in our culture that are important in life events, correct?
Yes.
Can you give us some examples?
Referring to Judaism specifically?
Yes.
Bar mitzvahs is what comes to mind.
He already got his answer. That's what
Bar mitzvah being,
Or a bat mitzvah for
Yeah.
a girl.
okay, thank you. Anyone else familiar with Judaism?
I don't understand us asking that question and not taking it further. I don't understand where he's headed with that. Just like if you even knew had ever heard of a bar mitzvah.
Number 35. How do you feel about, some call them jailhouse informants or jailhouse snitches? How do you feel about that? You can't say you have an opinion? Okay. Why do you think that somebody would, a jailhouse informant or a snitch would testify against somebody? What would motivate them?
Maybe they want to do the right thing, or maybe they quid pro quo out of it. They get something.
They get something in return?
Yeah, possibly like I don't know, maybe they get like,
I'm sorry?
more benefits in jail.
So do you judge their testimony more critically as because they're getting a benefit? Number 28. How do you feel about that? The fact that they might be getting a benefit, is that something that you would consider in weighing their credibility? Does everyone agree with what number 28 said? Be more cautious in what they say?
Yes.
Anyone in the new group disagree with that?
So that applies to numerous witnesses. Katie at least wants it. Lewis,
Ma'am, do you disagree with that?
And the jailhouse.
Yes. No? I can't hear you.
I would also be cautious.
Thank you.
Good use of your paddle.
Just a moment, Your Honor.
Looks like they're nearing the end with this particular group.
Thank you very much for your attention. Nothing further, Your Honor.
There you go.
We are going to take another break. Once again, I am going to instruct you not to speak to each other. You are definitely not to discuss the case. If you need to use the restroom or stretch your legs, you may do so at this time. Please return to the courtroom as quickly as possible after you've done so. The attorneys and the court reporter can join me in the jury room.
So this will probably go faster than the first one did, but it'll still take a little bit of time. So hopefully at the end of this, they will actually have a jury seated all over. That's what I hope and think. All right, so I want to do kind of our little summary for today. We've been doing jury selection. We've been asking questions, or the attorneys have been asking questions about individual things that might bias any of the jurors. They've been doing it in a group with all of the jurors there once, but they individually answer. And the court started with a number of questions that he asked, and they're sort of basic, but I wanted to go over why he would ask these things. One is, what is your occupation? And do you have a spouse and kids? And what are their occupations? And the reason is because sometimes that will give people information about potential biases. Let's say it's a medical malpractice case and you find out that someone themselves, or maybe is a doctor. Well, they might have an opinion. In this case, one of the things that Donna is looking for very hard is anyone in law enforcement, because we know from her conversation with Charlie, she thinks law enforcement cannot be fair to her, that they will automatically believe other people on law enforcement, and therefore they will just assume that the state is right. They will just assume that Donna is wrong. That's why those can be pretty important. They also can give you information about things that might or might not be directly relevant to the case, but it might tell you about something like income status. That's important to Donna because they had a large amount of money, the state is going to want to bring that out. And some jurors would be shocked by that amount, other jurors less so. Another issue is if anybody had a connection to FSU where Dan Markel taught. And we did hear that today. We've heard some of the jurors say that somebody in their family, associated with their family, worked at or attended FSU. That's going to be one of the things that will be of at least a little bit of concern for Donna's side. Then let me follow through with that, because Dan Markel taught there. He was a professor there. And so the idea might be that maybe they would identify with him because he was a professor connected to the school, and now they are as well. The law enforcement issue loomed large. We'll even talk a little bit more about that. The judge also asked, have any of you ever been charged with a crime? And do you have any family or friends who have been the victims of a crime? That is always important in a case like this, because you're concerned that the person answering your question, the potential juror, might have a bias where they are, for just an example, let's say they had a traumatic experience themselves or a family member did, maybe they would react more intensely to testimony about what happened to the victim in this case. Maybe they would relate to the victim in this case. And conversely, if they've been charged with a crime, maybe their experience was that law enforcement lied. Maybe their experience was they were falsely accused. And so you would need to know more, but that's why those sorts of things could be important. So let's go through some of the things. We heard the prosecution talk a lot about, or at least some, about a killer look like. Georgia Kappelman asked, could it be a granny? And why? Because the defense side is portraying Donna Adelson as just an elderly grandmother, just someone kind and sweet, someone who could not possibly have been guilty. And her demeanor, her dress in the courtroom is matching that. She's wearing a cardigan. She has gray hair. She does not look particularly wealthy. She looks frumpy, and she looks like an ordinary grandmother. I think they softened her look today with some color. I think it was a very wise move. And from the defense side, I think it definitely is improved. But that's one of the things they're aiming for. Both the prosecution and the defense talked a lot about the burden of proof and what exactly that meant. The prosecution wants to point out that although they have to prove that Donna Adelson was guilty beyond a reasonable doubt, they don't have to say without any doubt, no question at all, completely and totally. That's not their standard. And then on the counter side, on the defense side, they went through a really detailed explanation of what exactly had to be proven. And they compared it to the civil standard, more likely than not, more than 50%, ranging all the way up to maximum criminal standard beyond a reasonable doubt, to try to impress upon the jury the importance of making it absolutely ironclad, is what they would argue. I think they would argue that this is the kind of proof level that has to be reached. And of course, they're going to say the prosecution did not reach that. The defense also wanted to get at the issue of law enforcement. Who on the jury believes that it's possible for law enforcement to make a mistake? Who believes that they could be in error? Maybe they charged Donna and she's really not the person involved. They just messed up. Could you accept that? Or do you think law enforcement is always right? So they began to ask that. There were questions around the issue of divorce. One of the reasons, the motive behind the decision from the Adelsons to kill Dan Markel, the prosecution says, is that they were upset about the fact that he was having in this bitter custody battle with Wendi. Even though they were divorced, the custody battle had not ended. He would not allow the kids to move to South Florida near Donna Adelson, and he was not accepting, or Wendi wasn't willing to pay him the $1 million the family wanted to put up. And he even filed a motion trying to keep Donna Adelson from unsupervised visitation with her kids. Put all that together, and the prosecution says that's motive. So they wanted to know more about what kind of experience people there had with divorce, with bitter divorces, what had happened in that area. There was an interesting question by the defense about, have you ever planned a party? And then there was an objection. They went up and talked, and he came back and never asked more about the party. I assume the party he was kind of headed toward was the 70th birthday party given for Charlie Adelson. The prosecution has argued in the past that the big gift that Donna and Charlie talked about on the phone, it was recorded in a tap. The big gift for Harvey was, or I don't know how they got that. That was earlier. But anyway, the big gift was that they were going to murder Dan Markel. And that's a gruesome and hideous form of gift. But this was the big celebration. And that was an argument they made at the last trial. So I don't know exactly where in the questioning that was headed or what exactly Georgia Kappelman was objecting to, but I thought it was interesting that it got cut off right then and there. So one of the things the defense wanted to do was find out who on this jury would be willing to push for us, who would be willing to stand up and say, yeah, I don't agree. I think she's not guilty, and I'm going to stand up for that. So he pushed the jurors pretty hard. It was a pretty different technique that he used. He asked them some pretty hard questions, and he also pushed them pretty hard on things like, would you speak up? Would you say that that somebody was innocent? If you believe that, would you be willing to go to bat for my client? Was essentially what he was asking. He compared he said beyond a reasonable doubt. That's not just most likely, that's not just probably, it's not most convincing, it's beyond a reasonable doubt. It's a very high threshold or standard. They talked a little bit about what the defense has just openly called jailhouse snitches. There are so many in this case, it's hard to know exactly what they're talking about. There's Luis Rivera, one of the hitmen, admittedly, who testified against Katie, Sigfredo Garcia, and against Charlie, and now will testify against Donna. He was given a good deal for his role in being a hitman, considering his role in being a hitman. He was given this good deal, and yet he's testifying. So that's one person. Then we have Katie Medbanua, who has at least tried to turn state's evidence. She was offered a really sweetheart deal at the very outset, but she did not take it. She refused to testify after she was tried once, and there was a hung jury, tried a second time, convicted. After all of that, she then went to the state and made proffers they're called, where she told the state, here's what I could say if you gave me a deal. There's no deal been struck, but she continues to testify for the state in hopes that she'll receive some kind of compensation for it. Compensation in terms of reduced time. She's currently serving life plus 30 years. Then you've got Charlie will testify. We don't think he would turn in any way against his mother. And then there are jailhouse snitches, informants, who went to law enforcement and said, Donna is trying to get us to fill in the blank. We don't know for sure, but it sounds as if it had something to do with Donna pressing them to say that Katie Medbanua had lied. And then at least one of the two, was given a deal. She was given probation when she had actually violated her probation and was set to serve a number of years. Instead, she was given probation, and now she's going to testify against Donna. There's yet another person on top of that who is going to testify that the person who was the jailhouse snitch and was going to testify about what Katie said was actually apparently making it all up. We don't know the details on that. This has been kept almost entirely under seal. We will be getting those details in the coming weeks. Then there was also discussed about the fact that the state can offer a benefit, but the defense can't. So the state can offer people a reduced sentence, but the defense has no capability of doing that. They aren't in charge of the sentence. And so he wanted the jury to understand that. I don't think that Josh Zellman, Donna's lawyer, really liked the answers he was getting back in that area, because I think he was really hoping for was that people would understand more about the distinction, but he explained it to them himself. So I believe they ultimately got that. He talked about things not to discuss in the jury room, like the fact that my client didn't take the stand. And what he's hoping for is that if anybody brings that up, there will be just a statement. Yeah, we don't talk about that. Remember, the defense lawyer said we can't talk about that, in case anyone forgets. Like I say, he had a very different style from what the prosecution used. Theirs was a more conversational, engaged, sort of back and forth. They were both good. They were just very different. His was more confrontational. I said he asked some tough questions. He asked somebody, what is conscious intent? Wow, I think that's really hard. I think a lot of people would be hard. I think a lot of attorneys would be hard pressed to say, well, okay, let me think about that. And so I think that can be off-putting to a jury or juror. It possibly could. Maybe they would feel put on the spot. But I think he did a really great job of drilling down on each of the areas he needed to get the jury to think hard about. He really needed them to focus on these issues and protect his client. I think he did a great job on that. I think that the style of the prosecutors was much more relatable, relating to them. And I think that they will really, I think that they will respond well to the prosecution because they had that good intro. There were awkward, really short questions around, are you familiar with Judaism? And what are some important events in Judaism? The only one I'm aware of that is related to this case is the issue of the bar mitzvah. And the bar mitzvah was an issue mostly because the Markels say that they wanted to come to the bar mitzvah for the children. And Wendi sort of pulled a fast one. They ultimately ended up not being able to go to that because it got moved and they weren't really informed. They have protested the fact that they were shut out of their grandchildren's lives after their son, Dan Markel, was murdered. And they believe this is all part of the Adelson plot to eliminate them and to move with the kids as Adelsons only, including even changing their names. So, but the question, it didn't really seem to go anywhere. Are you familiar with Judaism? And what's an important event? And they did get the first one, they didn't really get many answers, but on the second group of jurors, they got bar mitzvah. And that's the only one connected, but I don't really see how it helped them to get that. Maybe they wanted to strike anyone with that connection. That's all. Maybe they thought anyone who was familiar with Judaism would also be offended by some of the things that Donna said. And so they just thought, let's ask a little question and we'll find out if they're familiar and we'll strike them. That's the only thing I can think of. I was unclear why they asked that. Okay, that's my brief summary of the day. So let's take a look at where we are in terms of questions and so forth. I think that my guess is that they'll come back reasonably quickly, more quickly than last time, with the final decision. And I think the reason the judge didn't want to just say, okay, we'll do this on our own and we will let you know what happened is if he does that, every single juror has to come back tomorrow. And what he would like to do is tell the ones who don't have to come back tomorrow, you're free to go. You don't have to come back. It's all, for you, it's all done and over. I think he also believes they're about to get a jury. And if that's the case, he could start tomorrow morning with the opening statements and just have the entire day available for testimony. Thank you. Thank you, Truth and Transparency. This is my first live trial coverage, and it's been a long day, longer than I expected. Thank you. I really appreciate that. What a kind comment. Thank you, Lana, very much. All right. I met Lana at the Delphi trial. She was covering that as well with her channel. So that is where we met. All right. Let's talk a little bit about some questions. I'm trying to decide whether I think we'll hang out and we'll keep talking. So go ahead and put some questions in. Put your question marks at the beginning. That'll give us our topics that we can talk about. We've done our summary for the day. So when they come back, we can go ahead. We'll sign off after that, after we know all the details about what will be happening next, which I think will be That is another one, Elar. You're absolutely right. One of the issues that supposedly led to early disagreements between Wendi and Dan Markel, or his family, was that at the wedding, they served non-kosher food. And Dan apparently had a very religiously observant family, and they were offended that there was non-kosher food served at them, and they weren't even warned about that. I guess they had assumed it would be kosher food since this was a wedding that was, but where both families were Jewish. So they had assumed that would be the case. So I had forgotten about that. Thanks for the reminder. That could be another issue. Yeah, there definitely, mark my words, that issue about the putting the kids in Nazi uniforms, that's very sensational and obviously going to trigger anybody with that sort of background, but frankly, other people as well. It isn't just Jewish people who will be shocked by that email. It was a pretty shocking email, and it's difficult to explain. All right, so I'm looking down here to see what nobody has any questions. That is your job. You have to have questions. All right, Diane, whose bank account did the money for Katie come out of? Was it Donna's or Harvey's or both? Because wouldn't that make Harvey guilty too? So it depends on what money you mean. And actually, I do have a whole section, which if we ever have a really long break, I'll cue that up. But there were two different potential payments to Katie, actually more than that, but two different types. One is cash that was given to her on the night of Dan Markel's murder. One of the prosecution's points is this has got to be the, defense points, this has got to be the only murder on layaway. Like they allowed it to be paid over time. That's crazy. That doesn't even really make sense. That was the prosecution's argument, and the defense argument was if he were hiring them and if it were not an extortion, he would have had to pay money up front. This wouldn't have been the first payment. You don't wait until after the murder to pay people. You pay up front. But that money was given to Katie. She went over to Charlie's house, spent the night there, she said, and the next morning he gave her cash, which he put into her trunk. It was stapled. She took it out of the bag it was in after a few days, and she remarked to Sigfredo, her significant other, although sometimes she was with Charlie, it's kind of unclear around this exact time what's happening, but she remarked to him, hey, there's something wrong with this money. It's molded. It's wet. It was that caused her to say she believed Donna had brought the money and Donna had washed it in a washing machine. But frankly, there was really not any evidence of that other than her belief about that. The money was wet and molded. That was the part that was known for sure. And she said Charlie gave it to her. Now, Charlie admitted that he gave it to her. Charlie said, yes, that's right. But the reason I gave it to her is she extorted me. She came to me and told me that her ex-boyfriend and his buddy, all of whom, and at least the buddy was a gang member and in fact high up in the gang, and they went and killed Dan Markel in Tallahassee. And the reason they did that was because they wanted to extort money from me to say, hey, yeah, we did this for you and you now owe us, and we're going to set you up for it anyway if you don't. So yeah, you owe us, pay up. That was their argument. So as far as I've gotten off topic of the bank account. So the first payment was actual cash. Now, the second payment was over time in the following weeks, months. There were payments made to Katie by check from the Adelson Institute. Those checks were signed by Donna Adelson herself. And those checks are part of what will basis for the state saying Donna was involved in all this. She must have known she was busy signing the checks. And we will find out what Donna's exact argument is. I imagine she'll just say, hey, Charlie told me she was working for him. And so I assumed that was the case. He told me to write her checks and I wrote checks. All right, I'm allowed to take breaks. That is good news. I have been worried about that. I wasn't really sure what the rules were around this. That's a good question. Are you going to cut the daily recap or chapter market? So, okay, my plan was it would go at the end, and then it would always be easy to find. You could just go to the end. But yes, I probably need to do that. It's just that I'm super tired tonight and we've gone kind of late. So I wanted to go ahead and get that out of the way so that I would be able to do it and not have trouble. Oh, thank you, Veronique. Y'all have been very, very kind to me. I'm very appreciative. Thank you very much for your super chat, and I really appreciate your very nice words. Thank you. And Luca, thank you for your super chat. All right, so I'm going back over here for questions. Would Charlie give up Wendi for a reduced sentence? Asked Diane Bennett. I think the answer to that is no, but of course, with time to think it over, it may become tempting. So we'll see. I don't think Donna would. I'm a no on Donna. I'm a probably not on Charlie. I think it probably wouldn't work, although, boy, the state sure does want to get Wendi. So maybe if one of the two of them offered, maybe that would make the difference. Creative Chaos wants to know, what's been your favorite trial that you've covered? I would give us there have been several, but I would say there were two. I really enjoyed the Murdoch trial. That was so fascinating. But one trial that you probably don't even know about, because not all that many people were watching that trial, but it was crazy. And that was the James Craig trial. It ended fairly recently. It was pretty quick. It is a great binge watch. It was not publicized in the sense that it wasn't televised. You couldn't just watch it. But I did about day 2 or 3, I was allowed in with the media on the court feed. So I was able to do daily recaps. So I did what I could do on days 1 and 2, and then very detailed from that point on. Unbelievable case. You absolutely, if you need to binge watch something, that is one to watch. James Craig, dentist out of Colorado, convicted of poisoning his wife, and a host of things he did to try to cover that up. Wild, wild case. You will definitely be interested in that. Mother Oates, what are the chances you think of a possible guilty verdict? Like 80% guilty, 20% not guilty. So I'm going to hold off. That's a very reasonable question, Mother Oates. And a lot of people are wondering that. I'm going to hold off on answering that because I always try to kind of keep things neutral right until the end so that people can feel comfortable to come here on the channel and talk about the case and get facts without me just informing them of how I feel. So that's what I'm going to do. I'm going to hold off on answering that. I think there's a lot of evidence. I think it will come in. I think there will be evidence we don't yet know about on both sides. So we'll see what happens on that. But thank you for the question. Irish Amy, would Charlie be allowed to take the stand and just plead the fifth and say nothing? So I think he could take the stand and plead the fifth. Yes, I think he could. And I also got a great email from Jacob, who is a defense attorney in Florida. Let me see if I can pull that up. And sent me a statute that he thought applied, which I thought was super interesting. I really appreciated him writing me on that. And wait, that's not it. Oh, wow. Lots of messages. Okay. That's what I get for not being on all day, right? Okay. So I'm looking for Jacob's message to me. Oh, I know it was in the other email. Here we go. Florida statute 914.04. So, and what it talks about is, it's really teeny letters. So let me see if I make it a little bit bigger. It talks about a person not excused from testifying or producing evidence in certain prosecutions on the ground that testimony might incriminate him or her and use of testimony given or evidence produced. So the statute talks about if you get a subpoena, and Charlie will have gotten a subpoena, and you don't testify, then you are allowed to take the Fifth Amendment, of course. That's your absolute right. I have to take these off so I can read this. Okay, so you are allowed to take it, but no testimony so given or evidence so produced shall be received against a person upon any criminal investigation or proceeding. So in other words, and the person is entitled to use and derivative use immunity, and they are allowed to testify right in this setting without it being used against them later. So if you've been served with a subpoena, and it's just what we were talking about, but if you've been served with a subpoena and then you can be required to testify if no testimony so given or evidence so produced shall be received against the person upon any criminal investigation or proceeding. But it may be received for perjury, which is a different issue, of course, related to whether the person lied during the course of this. So, but you don't get to just, I think he can take the Fifth Amendment, but the question then is whether he could have avoided incriminating himself. So anyway, I really appreciated Jacob sending that. Jacob Cohen was his name. I really appreciated that very much. I think a lot of people think, oh, well, lawyers would just know the answer on that. No, lawyers do not just know the answer on that. It's a super hard issue. All right, let's see. Savina Bees, do the jurors feel ripped off or insulted by being told they are finished here? Maybe, but not nearly as much as the alternates. I feel terrible for alternates. That's like the worst possible thing when you just, for all this time, you've been sitting there all through the trial. You've listened closely. You've probably formed an opinion. You've thought a lot about it for days, weeks at a time. And then you're told, hey, you are an alternate. You're out of here. That's brutal. Just brutal. All right, Ginger Snaps. Did we find out who they had a wiretap on during the past few months? We don't really know anything about that whole investigation. I don't know what we'll find out at trial, but it's all a big black box for now. We will figure it out as we go. Emily has been watching the coverage. She doesn't actually have a question. Originally from Southern Indiana. Delphi was fishy. Delphi was unbelievably fascinating case. Absolutely fascinating. That was a very hard case to cover, just physically difficult. The court had made that a difficult one to cover. Can they mention Charlie's conviction? Rosebud asked. Not only can they already have. And it wasn't the prosecution. It was the defense that mentioned. They may have mentioned it earlier at some point, but the prosecution, but the defense talked about it in the questioning of the jurors. Said, can you understand that just because Charlie was convicted doesn't mean Donna also must be convicted? Can you get the distinction of that? And the jurors said, yeah, they got that distinction, the potential jurors. Michelle, does Wendi visit her mother and brother in jail? I don't think so. Watching from France. How exciting. I don't think so. And the reason I don't think so is that she's moved. I don't think she even lives in Florida anymore. So I don't think that that's been happening. Probably not, but I don't know. Don't know the deal. All right, looking for question marks at the beginning. Here we go. I need to have some snacks. Yeah, I really need something. I don't know. I got on so fast. I actually skipped lunch. I just was completely unprepared. I thought I would have this all set, but I did not. Also, ponytail and sweats. Oh, wow. That would be very comfy. LS, would it be enough to prove that Donna was aware of hiring the hitman and did nothing against it? If she is charged with conspiracy, and if she was in a conspiracy and any one person took an act in furtherance of the conspiracy, then yes, she would be charged with that. But if all she did, so she would still be guilty of some of the charges, but not necessarily all of them if she was simply aware and did nothing to prevent it. But that is not at all the allegation made by the state here. They say she was part and parcel of planning it. She wanted this. She instigated it. She was in charge of moving forward. All right. Let's see. Looking for, there's Gabby. Do you think the defense should delay opening and keep their defense hidden from the state until the state rests? That's so, I did think about that. It's a huge risk. The defense often, at least maybe always, has the opportunity to not do its opening before the case starts. Instead, to let the state present its evidence and then do their opening. The beauty of that from the defense point is that you don't have a counter, right? You get to force the state to put on its whole case before you kind of tell them what your theory is. It can be a really effective way of keeping some of your things under wraps. And it reminds the jury, hey, we're alive and well in the middle of trial, and here's our big argument. It can give you an advantage In the Brooks Hout trial we covered recently, there were two defendants and they split it. One did the opening at the beginning, just like the state did, and the other did it in between the prosecution and the defense, which was really interesting because what it meant was that they were able to get two bites at the apple, sort of, where they got basically two opening statements. So that first opening statement, but back to your question, which is, do I think Donna's team would do that? I don't. There is a big negative. One of the reasons it worked in the Hout case was they had the chance to argue against the state up front. It's not technically an argument. I know it's called a statement, but they got a chance to present their theories and their ideas early on. It's a huge risk to not do that, because if you don't tell the jury up front what you think and what you believe, they may go off on a tangent and have already decided the state is right before they even hear what your main argument is going to be, before they even understand your theory of the case. For the most part, I think then that most people don't do that. I think they want to go ahead and put out their theory early enough that they don't allow anybody to run off with that. But it can be effectively used. I don't think Donna will do that. I think her attorneys will make their statement right off the bat. But in a case where your defense is going to be a surprise, it can be effective. It looks like we've got some movement here in the courtroom. No sound yet that I hear, but we can see that they are back in the courtroom and moving toward it.
To our currently seated respective juror panel, we have been able to select a jury at this point. I did want to extend to everyone, thank you for honoring your summons and attending this process today. Although it has been time consuming, it has been very valuable in moving this matter forward, and we are not able to do our jobs without you. So with that, again, we give you our thanks. When I read the following numbers, you are to remain. Everyone else is excused at this time, and you will not need to return tomorrow or at any other point. Juror 1, you are to remain. Juror 2, you are to remain. Juror 5, you are to remain. Juror 23, you are to remain. Juror 11, you are to remain. Juror 14, you are to remain. Juror 25, you are to remain. Juror 27, you are to remain. Juror 28, you are to remain. Juror 29, you are to remain. Juror 31, you are to remain. Juror 34, you are to remain. Juror 35, you are to remain. And Juror 36, you are to remain. Everyone else is excused at this time. Have a good evening.
All right, we have a jury. That is, I counted 12 plus 2 alternates. I don't know if anybody got a different count than I did, but I was expecting 3 alternates. There had been discussion. The judge initially said, I'm going to go with 2 unless I hear from you. And I understood the defense to say, yeah, let's go with 3. So apparently not. It sounded like 12 plus 2 alternates. And he has seated those as the jury in the case. Everybody else has been allowed to go home, which means that we are open for the opening statements. That will be the next stage in the case. I imagine that will happen in the morning. Now we're going to hear from him, I think, again. Probably he'll dismiss all of them. That'll take a couple of minutes, and then we'll hear from the judge about
our remaining jurors and alternates. Now the fun begins. Before you are sworn in this evening, does the state accept this jury?
Yes, Your Honor.
Does the defense accept this jury as well?
Yes, Your Honor.
Mrs. Adelson, do you accept this as the jury to try your case?
Yes.
Members of the jury, the first official act that I'm going to ask of you is to stand up, raise your right hand, and be sworn to take the oath of a juror.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and this defendant and render a true verdict according to the law and evidence? If so, say I will.
I will.
Thank you.
You can be seated.
Buffering.
Before you are released for this evening, I am going to give you some instructions. At this point, you are the selected jury in this case. The instructions that you received before concerning not discussing this case, not seeking out any information about this case, or reviewing any other news or speaking to anyone about this now applies specifically to you. Does anyone have any questions concerning the court's prior instructions on what the prohibitions are concerning information in this case? Number 5.
We tell our employer how long we are expected to be here.
Yes, you may. But as far as any other discussion about the case, that is not to take place. 36.
Yes, sir. Would there be any kind of form that I could present to my employer? But I'm from the state of Florida, and they are very particular about, you know what I mean.
Do you need me to call somebody?
I mean, I left today.
There will be a form that will be provided to you from the clerk that outlines the fact that you've been selected for the jury and the length of the trial. Any other questions concerning that matter? All right. I believe earlier when we went into individual voir dire, we discussed that we would be working more or less a standard day. You are to report at 8:45 tomorrow, and we will expect to finish by around 5:30. It is important because you must move as a group for everyone to be on time. Also, as well, as ridiculous as this may sound, once you arrive, please use the bathroom before you come to the courthouse. If all 15 of you need to use the restroom, that is going to hold us up from getting started. The bailiffs are going to provide you information for parking throughout the duration of the trial. Also, as well, this is the courtroom that we will be in for the duration of the trial. It does vacillate between hot and cold. If you need to bring a jacket or light sweater so you're comfortable, please do so. You are always permitted to bring reading material with you during any breaks. However, again, you are not to discuss the case with each other, even now as selected jurors. You may discuss any other matters that are unrelated to the case during your service. You can talk about the weather. You can talk about how many wins you think FSU might get this year, but you can't talk about the case. Does anyone have a question concerning this?
Donna's team not
Yes,
happy
sir.
you mentioned that.
Sound like a kid, but what about food? Can we bring food?
You can bring food. I will also have some snacks that are back there for you. Went to Costco, bought them myself. Hopefully you like them. If you don't, you always have money and you can obtain what you need. Any other questions? There are no bad questions before you are released. Number 2.
Is the start time at 8:45 every morning?
You are to report at 8:45. We anticipate getting started by 9.
Report downstairs.
Yes. Please report to the area where you initially reported for jury selection. You're to move there as a group. Oh, 1 second.
We're going to take a minute and discuss the
Very well. The bailiffs will explain to you where you will meet, but again, do not come up to the courtroom by yourself. You're to move as a group. Does everyone understand this? Any other questions before we part ways for the evening? 31. I'm not going to tell you what to wear. Wear something that you'll be comfortable in the courtroom with. Beyond that, I'm not going to critique your dress code. I'm not the principal at the high school. Yes, ma'am. 35. For Labor Day, we will not be having court. That is a recognized federal and state holiday for anyone who already has a Labor Day plan. This trial will not affect them. 29.
just to verify, so right now we look like at least 2 weeks is what we're assuming. It could be shorter, could go longer, but is that a good?
We're
start?
anticipating the trial ending by September 5th, but if it possibly goes longer, certainly everyone will be made aware of this, so that way you can address any issues with work or other matters. Any other questions? Very well. I will see you tomorrow, bright and early. Again, please be mindful of the instructions that you've received. We will get started with the court's instructions, the opening statements, and then we will hear from the witnesses. Have a good night.
All right, well, the trial ending for the day. We now have a jury seated. Tomorrow we will begin with, I don't know if there's going to be any discussion. The reason I'm kind of hanging out is to see whether or not there's any discussion with the attorneys and the court afterwards. Sometimes there is. He might tell them a different time to be there. He might tell them about some of the orders he's released in the case. There were at least a couple of outstanding issues. He told them he would rule before they got to actually have to make the opening statement, so they wouldn't say something that didn't fit with the way he ruled. Tomorrow we will be starting trial days.
Opening, the issue can be argued now. Mr. Zellman.
All right, looks like they do have some more discussion to have with the judge where he's going to talk about some rule, even hear argument on some of the issues. I'll keep the screen looking like this until we get finished with that. So my plan will be, if they are going to go, the jurors are supposed to be there at 8:45 to start at 9. I'm going to assume that there are going to be some attorney arguments maybe as early as 8:30. So I will open up the live stream sometime between 8:15 and 8:30, and we can go ahead and get started and talk about the case and get ready for the case. So we make sure we don't miss anything, which is definitely not what we want to do. Thank you, Teresa.
We'll withdraw the objection at this time for purposes of the opening.
Very well.
Right.
Do parties have anything further to raise that we have not already addressed through the process today for jury selection or other matters? All right, please report also by 8:30 tomorrow. We will wait for the jurors to arrive. You'll have the opportunity to defense if you need to speak to your client before we have the jurors there. Everyone can prepare for their openings. Are there any multimedia aspects to the openings that we need to address or you have not already worked out?
We will be having a presentation, but I'm familiar with how to use the work technology.
All right. If you need to practice with that before we get started, please do, so we can move through seamlessly. We'll see you all tomorrow at 8:30.
All right. We can end the stream. Let me do that and say, all right, well, I will look forward to seeing all of you tomorrow. Hope you have a great evening. We will be starting. I'll go ahead and open it up between 8:15 and 8:30. And as soon as they start the oral arguments about whatever the latest issues are, we'll go ahead and go live with that. And then we will be ready to hear opening statements in Donna Adelson's case. You do not want to miss this. It is 11 years in the making. So be sure to be here tomorrow, and I will look forward to seeing you. Thank you again to our mods for being here and to all of you for being here. And let's see if I can figure out how to do my outro. Maybe not. I may just have to say goodbye. I'm so tired. All right.